Very good morning to everyone present here. Thank you so much for joining us today. My name is Paloma, and it is with immense pleasure that we welcome you to Justice Unplugged, Shaping the Future of Law, presented by VIT School of Law, VIT Chennai, in association with The Hindu. Today, we have gathered esteemed judges, respected legal veterans, policymakers, and industry experts who have profoundly impacted India's legal landscape. This conclave aims to bridge the gap between legal education and real-world practice, providing a vibrant platform for learning, mentorship, and networking. We will explore the following critical themes today: law and technology, exploring how AI, privacy, and cybersecurity are reshaping legal frameworks; social justice and legal evolution, discussing the role of law in promoting equity, inclusion, and human rights; legal education reform, rethinking curricula to create practice-ready law professionals; and corporate law and business ethics, examining ethical business practices. As you all know, law is more than just statutes and courtrooms. It's a dynamic force that upholds justice and drives societal progress. We aim to inspire the next generation of legal minds. Welcome once again to Justice Unplugged. We would like to thank our presenting partner, VIT School of Law, VIT Chennai. Before we proceed, requesting everyone to stand for the Tamil Thai Varthu.
நிலமடந்த கெழிலொழுகும் சீராரும் வதனமென திகழ்பரத கண்டமிது தெக்கனமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீர் இளமை திறம் வியந்து செயல் மறந்து வாழ்ந்ததுமே வாழ்ந்ததுமே வாழ்ந்ததுமே.
Thank you. I now request all our dignitaries to please join us on stage to light the lamp and inaugurate the event. Calling upon Mr. Suresh Nambat, editor, The Hindu. Mr. G.V. Selvam, Vice President, VIT. Mr. C. Aryama Sundaram, Senior Advocate, Supreme Court of India. Honorable Mr. Justice N.V. Ramana, former Chief Justice of India. Mr. L.V. Navaneeth, CEO, The Hindu Group. Honored by your presence today, requesting our dignitaries to please do the honors. Thank you so much to all our dignitaries. We are honored by your presence here this morning. May I now invite Mr. Suresh Unplugged, editor of The Hindu, to deliver the welcome address, requesting all of our other dignitaries to please take their seats.
Good morning. Distinguished guests, Honorable Justice N.V. Ramna, Senior Advocate Mr. Ariyama Sundaram, members of the legal fraternity, scholars, students, and colleagues. On behalf of the Hindu group, it is my privilege to extend a warm welcome to all of you to Justice Unplugged, Shaping the Future of Law, presented in collaboration with VIT School of Law. Today, we are honored to be in the company of some of the finest minds in India's legal fraternity, gathered here to reflect on the future of law and justice in a world undergoing rapid change. We are especially privileged to welcome two of the most eminent juries of our time, our Chief Guest, Honorable Justice N.V. Ramana, former Chief Justice of India, and our special guest, Honorable Justice D.Y. Chandrachud, one of his distinguished successors in the Supreme Court. Their presence today speaks not only to their unwavering commitment to justice and the rule of law, but also to their dedication to advancing and enriching legal education in India. We are deeply grateful for their participation. We are also honored to have with us our guest of honor, Mr. C. Ariyama Sundaram, Senior Advocate of the Supreme Court of India. A stalwart in the legal field, his insights have shaped jurisprudence and public discourse for decades. We look forward to his special address. As a publication rooted in the values of truth, fairness, and democratic accountability, The Hindu has long championed rigorous public dialogue around law, justice, and social change. Justice Unplugged offers a vital platform to engage with some of the most urgent challenges before the legal profession today, ranging from how technology is reshaping privacy and ethics, to the shifting role of law in society, to the misuse of due process by the executive, and the evolving landscape of legal education. Today's sessions bring together senior advocates and scholars for conversations we hope will be as inspiring as they are thought-provoking. These are not debates for the sake of rhetoric, but meaningful dialogues aimed at sparking ideas and empowering a new generation of lawyers, policymakers, and academics to reimagine justice for a troubled present, a period of unresolved disputes and emerging conflicts. I would like to acknowledge the leadership of VIT School of Law, VIT Chennai, especially Dr. G.V. Selvam, Vice President of the VIT, and commend its faculty and students for their collaborative spirit that has been instrumental in bringing this event to life. As we begin, I encourage each of you to engage fully, ask questions, share perspectives, and reflect deeply. Without framing the right questions, we risk missing the answers, even when these are right before us. In keeping with India's long argumentative tradition, let us shape conversations that move us closer to a truly just and egalitarian society. Thank you.
Thank you, sir. I now invite Dr. G.V. Selvam, Vice President, VIT, to kindly address the gathering.
Honorable former Chief Justice of India, Mr. N.V. Ramana Garu, respected Senior Advocate, Mr. Sri Ariyama Sundaram, Mr. N. Ram, Mr. N. Ravi from Hindu family, and Mr. L. N. Navinit, CEO, Hindu, and Mr. Suresh Unplugged, editor of Hindu, and senior advocates of Chennai, faculty, students, good morning. I am extremely privileged to have this opportunity to render the opening remarks in this legal conclave titled Justice Unplugged in association with Hindu. When I read this topic, I recollect a kural from Thirukural. ஓர்ந்து கண்ணோடு இறை பொருந்து யார் மாட்டும் தேர்ந்து செய்வதே முறை. It means search out to no one favor with the heart that justice loves. Consult, then act. Tamil has a great history. In 2000 years back, a king called Elon from Soya kingdom, he ruled our country. Once, a cow whose calf was killed by a chariot came to the palace and it rings the bell of justice. Then the king found the chariot drawn by his son killed that calf. Immediately he drove the chariot on his son, he killed his son. On that day, he was called as Manunidi Sword. There was a statue in Madras High Court called as Samanidi Konda Sword. That's a history of Tamil Nadu. So our students should know about our history. This legal conclave is utmost relevance to contemporary society, which is progressive and dynamic. In dynamic society is crafted by legal scholars who are social engineers, and a great nation is testament to the significant contribution made by the stalwarts of law like our constitutional maker, Dr. B.R. Ambedkar. This constitution is living document which upholds and believes the values of liberty, equality, and fraternity that aim to establish a just society. Our nation has philosophy, however, it must be remembered that for a nation to prosper, we not only need scientists, engineers, doctors, but also great lawyers who have changed the destiny of this nation. The contribution of our honorable judges and respective senior advocates have made society a better place to live. Today we have such eminent legal personalities who have made significant contribution in the field of law. Honorable former Chief Justice of India, Mr. M.E. Ramana, the 48th CJ of Supreme Court of India, is a man of humble background who started his career as a journalist. Over time becoming the Chief Justice of Supreme Court of India. During his tenure, his lordship rendered several landmark judgments, one of them being the Anuradha Basin versus Union of India case concerning the right of freedom of speech expression in cyberspace. His contribution has set new precedents which have set the pathway of national future. It is a privilege for us to have the opportunity to hear from his lordship address. Thank you, sir. Respected Mr. Arima Sundaram, Senior Advocate, Supreme Court of India, is a huge believer in freedom of speech, expression, and a dedicated legal professional who has fought his clients in the absence of any precedent of law. In 1986, where there was no kind of consumer protection law available, Sir fought his client in a medical malpractice case. His client was awarded 17.38 lakhs compensation along with interest. So the first case for the consumer. The total sum was 31 lakhs. This is the only example among the many major impacts which he has made in lives of his clients and society. Along with you, I am eagerly waiting to hear from you, sir. Thank you. These esteemed dignitaries on the dais have shown us that law should not remain confined with courtrooms. They must be dynamic, evolving along the societal shifts. Today, the legal conclave features panel discussion on themes that are thoughtfully crafted to address some of the most pressing issues at the forefront of society and law. The intersection law and technology, AI privacy and ethics is a crucial area of contemporary relevance as its integration of AI raises concerns about data protection, algorithmic bias, and surveillance, demanding that our regular frameworks evolve to ensure accountability and transparency while safeguarding the fundamental rights that balancing involvement with individual liberties. Building upon the challenges posed by the technology advancements, their impact on individual rights, the role of law changing the society plays a fundamental role in shaping the transforming society by establishing justice and order, adopting the involving norms and driving progress through legal reforms. In a society striving for progress and justice, the conduct of business plays a crucial role. Corporate role business ethics plays a vital role in establishing a thriving economy and a just society by ensuring legal compliance alongside transparency, fairness, and social responsibility in corporate decision making to promote accountability, protect stakeholders, foster sustainable growth, and public trust. Recognizing these rapid changes occurring in our society, driven by technology and evolving social norms, it is important we prepare the next generation of legal professionals to effectively address these challenges by crafting futuristic policies like legal education, which is imperative for preparing the next generation of legal professionals to meet the evolving challenges through integration of technology like AI and digital law and interdisciplinary learning, global perspectives, practical thinking, skill-based learning, and continuous reforms to create competitive, ethically driven, and globally competitive legal minds. These discussions are essential to ensure our legal systems remains relevant, accessible, and just in our dynamic world. Recognizing the importance of this integration, VIT founder, our Chancellor, Honorable Dr. G. Vishwanathan, who is not only a pioneer in education, but also a lawyer, former paramilitarian and Minister of Tamil Nadu government, deeply understood the necessity of making legal education access to all society. This vision laid the foundation VIT expands into legal education and ensure that justice remains within the reach of everyone. VIT School of Law, Chennai's its inception in the year of 2014, actively furthers an ethos through its legal aid programs, instilling students the normal and ethic obligation to provide free legal service to the society. Furthermore, through academic collaborations and legal practitioners, government and non-government organizations, we ensure that our students gain valuable real-world experience. Our alumni have just not secured position in top-tier firms, but they also passionately serving society are committed legal practitioners, policymakers, and legal analysts. This conclave is a testament to commitment of Center of Legal Education to engineer a just and equitable society through impactful community engagement and forward-thinking public policies and initiatives to address the evolving challenges posed by the technology advancements. As we engage meaningful discussions in the intersection of law, technology, and justice, we reaffirm our commitment to making the legal system more transparent, accessible, inclusive, and practice-oriented. Before I conclude, I express my sincere gratitude to the legal luminaries, esteemed judges, members of the bar, and academicians, and students of their practicing in making this conclave more fruitful. I also express my appreciation to the Hindu family, an institution that has long championed journalistic excellence and legal disclosure. As an ardent reader of its editorial columns, I really appreciate the depth the Hindu brings to the public discussions, offering a vital platform of law students to explore the world of legal journalism, our ever-growing and disciplined field. Once again, I thank you all. I hope this conclave will be useful for everyone. Thank you.
Thank you, sir. Mr. C. Aryama Sundaram is one of India's foremost senior advocates with an illustrious career spanning over 4 decades. He has appeared in landmark cases before the Supreme Court and was designated as a senior advocate at 38, becoming the youngest in the history of the Madras High Court. He is also a regular speaker at the National Judicial Academy, sharing expertise with newly appointed High Court judges. I now invite our esteemed guest of honor, Mr. C. Aryama Sundaram, Senior Advocate, Supreme Court of India, to deliver his special address. Can we have a big round of applause?
Thank you, Paloma. Justice Ramanna, former Chief Justice of India, Mr. Suresh Nambat, editor of The Hindu, Dr. Selvan, the spearhead of VIT School, Mr. Navneet, CEO of Hindu, and my dear friends, Mr. Ram and Mr. Ravi of the Hindu family, all the senior advocates here, but most important of all, the people whom I'm talking to today, all you students of Vistol, you students who are the future of law. People like me have come, we are towards our twilight. It's people like you who are going to take us much further. Before I start sharing with you what I intended to today, I must say that I find this expression, Justice Unplugged, a bit of a misnomer, and I'll tell you why. Justice was never plugged. It has never been plugged. Justice is like water. It flows into any opening, fills any vacuum, flows into cracks, flows into crevices. It is ever flowing wherever society needs it. What has been plugged was society. It is society which was plugged. And that plugging of society has opened over the years. It has slowly become unplugged with changes in social norms, social customs, social beliefs, changing in the economic order, the areas of professions, the area of businesses, and above all, even in fields like medicine and other fields like that. You have seen significant changes. You have seen changes where we have come into internationalism, and you have had such far-ranging changes that all that has happened is justice has had to move along with these changes, deal with all these changes through its handmaiden. And its handmaiden is law. And all of us are nothing but the messengers, the carriers of that handmaiden. So what we really do is keep in pace with society. Let me go back in time. It was almost 50 years ago when I joined the Law College, Madras. It was very amusing because in those days, at least at the time I joined Law College, it was really the last refuge. If you couldn't get into the administrative service, if you couldn't get a job, you didn't go into law. There were only 3 reasons to go into law. 1, you had a family of lawyers, therefore you had an abiding interest. 2, you were in politics and felt law would help you in your political field. Or 3, you had no other alternative. You had no employment. You could do nothing else. In fact, I must tell you on a lighter vein, when I went for my interview for the Law College admission, I had done very well in my graduation. In those days, we didn't have a 5-year course. You were a graduate before you joined law. And I had done very well in my graduation. And a member of the interview committee said, but tell me, why are you applying for law? So I said, because I want to do law. He said, but you've done so well in your BA. Didn't you see today there's an advertisement from so-and-so bank for clerks who can become officers? With your marks, you can definitely get that job. Why are you coming for law? Then I had to convince him that I actually wanted to do law, and would he mind, despite my good marks, giving me admission in law school. That is the way it was. When we went to law class, our only interest was attendance, nothing else. I'm being very frank with you. We were given lectures where the teachers would take out a chapter and read it to us, and we would all sit there and listen to this reading of this chapter. We had teachers who were disinterested, students who were completely disinterested, and that is the law we grew up in. We started learning law when we became lawyers. In fact, I remember I had a problem drafting my first legal notice when I was a junior in a law firm. I didn't know exactly how to go about drafting a notice asking somebody to return the money he had borrowed and for which he had given a promissory note. That was where we started, because that is where law was placed in those days, as being nothing but a job which you did, by which you did cases which were quite pedantic, because law had not started growing. And why? Because society had not started growing. Times had changed. We had no such thing as competition laws. We did not know what competition law meant because it didn't exist. We knew that unfair trade was actually preventing somebody from doing his business, either by getting some people to beat him up and to close down the shop, or to put up some other building before it. That was unfair trade. There was no such thing as competition law. There was no such thing as securities law. IP law did not develop. The IT law, the technology law is something which we didn't even dream about. So for us in our days, law was completely a different issue, where we had nothing but solving lis inter se people, or we had criminal matters where the state versus a client who has committed a crime which falls under the IPC. But over the years, law has got involved in so many spheres of human life, so many spheres, that today it has become almost impossible for any lawyer to keep up with the different spheres where law has now taken a place. So we've got this age of super specialization. I mean, I can only go back to years ago when I heard the story about this chap who came back to his village and told his village doctor that he'd now become a doctor. So he said, all right, so what are you doing? So you're a doctor. He said, no, I've become an ENT specialist. He said, what's ENT? He said, ear, nose, and throat. He said, oh, I see, very good. He said, but then I felt that's all too much, so I specialized in the nose. So the man said, oh, I see. And which nostril are you specializing in? So that is where we are coming more and more, which is why you students today are getting more and more dependent on Westlaw, on your various technological assistance for studying your cases. I don't blame you for it, but can I give you some advice? Do not sacrifice original thinking. Original thinking is a must. I always appreciate an associate in my chambers who comes out with an original thought which may have a flaw, rather than repeating for me what has already been stated in some judgment. I'll give you 2 pointers of myself. I'll just share with you 2 things which actually I'm not letting out a professional secret. Before I was a counsel, designated a senior advocate, I used to do a lot of original side work and writ work. And I used to do a lot of drafting. Do you know how I used to draft? I used to first draft the relief, even without reading the facts of the case. I would ask my client, what do you want? Once I knew what he wanted, I would draft his relief. After drafting for the relief, I would next draft the cause of action, which is required to establish that relief. Then I would set out the law which was required to make out that cause of action. After that, I would go through the facts of the case and then see what are the facts which support my cause of action and the relief, and highlight those. And then I would take the facts which were not in my favor and deal with those. Because one thing one never did and one never should do is suppress a fact. So that is the way I used to draft. And it's very interesting to know that that kind of drafting is something I did all my life, and even today in the Supreme Court when I'm asked to settle a synopsis, I tend to think of it the same way. when I'm asked to settle an SLP, I tend to think of it the same way. The other thing, which I always do and continue doing till today, is that I'm briefed in a case, I first understand what the facts of the case are. Then, when I'm told there's this judgment or that judgment, X, Y, Z, I say, please put it all away. I don't even want to see them. Don't even tell me what the judgments say. I'm not interested. I say, show me the act. It could be an act which I have read the section 100 times. I may be able to recite the section to you, but I read the section again. I read the relevant sections again, and then look at the facts of my case, query that section, and then come to my conclusion as to what the argument should be. I say, all right, now you can show me the judgments, either for or against. Then when I read those judgments, what do? I first read the most important paragraph of the judgment, which is not the ratio decidendi. The most important paragraph of the judgment is usually paragraphs 2 and 3, which are the facts of the case. Then come to the decision. And you will understand then that a decision which was seemingly against you may actually be in your favor when you see the facts there and you see the facts in your case. Now, instead, if somebody was to say, sir, I have just got these 6 judgments on this point, this is the case coming up tomorrow, here are these judgments, this is the ratio X, Y, Z, I have lost any form of original thinking for the case. And according to me, this is the most single important thing for all of you to continue in life, especially in lines of what I'm going to talk to you about, the changes of law. The second very important thing is that why is our profession known as the learned profession? I mean, we call ourselves a noble profession. I trust many of us believe we are noble, but why are we called the learned profession? Why do we say, my learned brother, my learned friend? Why? Because it was and should continue to be a learned profession. Before we joined law, we went through a graduation. Why? Because we had to be taught, understand, and have a degree of learning before we approached law. Today, I appreciate again that I know what all of you are combating. You're combating so many different specialized fields of law. It's gone far away from general law. So you will find that perhaps you have no more time than to read your law books. But please understand that reading is vital. Whether it's literature, philosophy, general affairs, topical affairs, business affairs, no lawyer can be a complete lawyer if they are not learned in all subjects. Because if you're learned in all these subjects, and if you have actually understand all nuances of social subjects, of subjects you find in the world, even little bit, I think Dr. Selvan just spoke about my case on medical malpractice. Do you know, by the time I finished that case, and I want to share a story with you, I had sat with the doctors to understand what is pulmonary edema. And I was told that, this doctor explained it to me so beautifully. And she said, you can hear it. Because this is when she gave evidence. And the doctor said, but doctor, when cross-examination, how would you know you had pulmonary edema? And she said, because you can hear it. And then I asked her afterwards, you said that so beautifully, and the judge was so impressed, but how do you hear it? And then she explained to me. And do you know what happened to me 5 years later? My father wasn't well. And suddenly, my mother called me and said, look, something's with him. And my mother was a doctor. Had been a doctor, wasn't practicing. And said, I don't know what's wrong with him. He's lying almost in a coma. And suddenly I heard the rasping. And I said, Amma, he's got pulmonary edema. Let's rush him to the hospital. We rushed him to the hospital and he had pulmonary edema. Now, this has nothing to do with law, but I'm just sharing with you how knowledge, learning of any kind will always assist us and never hurt us. So these are aspects I want you to tell you, that despite you're going to have so many specialized sessions on so many specialized issues today, you're going to be doing that. I don't want to talk about these specialized issues. We have so many sessions with so many experts who are going to talk to you about it. I want to talk about these general facets. And the main general facet I want to talk to you about is to understand that society has changed over the years. Law is the handmaiden of justice. Justice deals with society, social norms, social customs, religious tenets, deals with business realities, commercial realities. Criminality deals with all these aspects, which is why the courts in India have also tried to keep pace with this. When I joined the bar, we didn't have so many different statutes. Money Laundering Act was not heard about. All these other acts were not even contemplated. What did the courts do in those days? Let's think of some judgments. Don't forget, in those days, when there were no hard and fast rules, the great Kesavananda Bharati case, where the court saw the injustice of throwing away valuable rights and duties under the Constitution, and then decided, how do we protect it? And through a series of original thoughts made explicit what was implicit all along, and came out with a basic structured doctrine to save the basic structure of morality, humanity, constitutional morality of what our forefathers had wished. Then you take a case like the Bangalore Water Supply Company, recognize labor rights, recognize the importance of these aspects, because these became something which statutes are not dealing with. We went on to, then we have, of course, the famous case of Mr. Rangarajan, who was then the publisher of The Hindu, who produced this film, which was on reverse discrimination. It was anti-reservation and criticized judgments of the Supreme Court. Criticized in the film the various judgments upholding reservation. It may have been an unpopular thought, but it was a thought. The Madras High Court banned the film. The Supreme Court reversed it with the most famous judgment. It became so famous that even today it is being cited. It's called Jagjeevan Ram versus Rangarajan. As far as I know, copies were taken by Amnesty International, and it has even been referred to in a judgment of the House of Lords in England about how India has come further than most other countries in freedom of speech. And we are going back in point of time to the 1980s. We have Vishaka, the Vishaka case, where there was again what I said, justice springs into a vacuum. And therein came that theory that if there is something which is a basic right, a protection, something respected under the Constitution, and there is no law to take care of it, then the court, in discharge of its functions under the Constitution to uphold the Constitution, can make guidelines till a law comes in. And that was about harassment of women in working places. So at every stage, the courts have tried to interpret laws to keep in keeping with social movements. In the last 10, 15 years, there's been a tremendous change in social norms, social customs, in economy, in internationalism, in all these spheres. And so the laws have had to evolve. So we have a judgment in what's known as the privacy case, the Puttanna case, where you made a fundamental right, created a fundamental right, which the court said we have not created the right was implicit in Article 21. Environment has been brought under Article 21. Education has been brought under Article 21. Why? Courts cannot include a new fundamental right. The courts, however, can look at social needs and bring in rights. Same-sex relations has been protected, appreciating that this is today not an abnormality, but is a norm among persons who want to have same-sex relationships, and has respected it. I cannot forget how, in the privacy case, I had been briefed on the side of the Union of India to oppose privacy as a fundamental right. And I remember in a lighter vein, one of the judges turning to me and saying, Mr. Sundaram, are you opposing privacy being a fundamental right? And I said, yes, I am, because unfortunately, whatever my personal beliefs, the law is the law. But I remember then is when I had pointed out that the Constituent Assembly had specifically discussed and eschewed and rejected right to privacy being included as a fundamental right. And I said, look, this is the Constitution, upon which it was remarked to me that my opinions were very Scalian, Scalia being a judge of the Supreme Court of the United States at that time, or earlier, who believed that the Constitution being written in stone, and accepted and went on the basis that the Constitution is an ever-changing organism which has to change with society, which has to change with times, which is why the courts have taken on to themselves so much more in the field of public interest. They have gone into areas of education, areas of welfare, areas of social injustices. Why? Which is the law which has dealt with this? We go back to the Constitution, constitutional morality, and justice will fill a vacuum when a vacuum is found. Justice will not allow an injustice to be perpetrated through a law. Now, this is where I am trying to explain to you that even today, original thinking is still such a must. You're at an age where you use technology to a great extent. You're also at an age where you're going to be threatened by AI or helped by AI. It's like a hammer which can either forge steel or break glass. So that you'll be discussing in that session. So the courts have been accused of having overstepped their limits, as having come into areas which does not concern them, which concerns the legislature, which concerns the executive. Of course, in India, we don't have the system of, in reality, our executive and legislature is one and the same, because the ruling party is the executive. So it's actually between the two. And it's often said that the judiciary and the executive and the legislature have to go hand in hand. That is the biggest anomaly of separation on powers and balance of powers. What is separation of powers, which is the essence to a democracy, is that each balances the other. That there should be a separation of powers so that church and king is not one and the same, to use the English expression, but each balance the other. How would this balance occur if both were hand in hand and went together? So a conflict between the judiciary and the executive is a must for balance of power, because that is the way one can be the watchdog of the other. And that is the role of the judiciary. That is why the judiciary is so important. That is why even today we consider it the one bulwark against any attack against democracy, against rights of individuals, of rights of society. Having said all that, what is your role as students today? As students of law today, you no longer have an obligation to your own purse. Of course, I'm not preaching to you. We're all became lawyers. We all are lawyers because we think it's a career which can be very materially beneficial. Of course, we enjoy the material benefit of it, and we should. But while we do it, don't forget that we are vital agents in this whole growth of law with a changing society. Law cannot grow unless the lawyer grows. If the lawyer does not grow, well, all these great concepts which we have of framing new laws, of shaping the future of law, we can forget about it. It happens because lawyers have to grow. And how do we grow? The integrity of a lawyer is vital. don't forget that when we want that power of a lawyer today, why all of you become lawyers today is it's one of the most sought after professions. The power of a lawyer today vests in him a greater duty, a greater responsibility than the lawyers of yesteryear who became lawyers because they had no other job had. Today, you want the benefits of that power of being a top lawyer. With it comes the responsibility of discharging that power with the greatest good for society at large. The lawyer today is no longer a personal professional. He is today an integral cog in the societal wheel who has to play this role in society because what he makes of himself is what he contributes, and that is where society itself will progress for the welfare of everybody who is to be assisted by that society. And that brings me to the legal education. You know, Bertrand Russell once said that the purpose of education should be that by the time every boy and girl leaves school, they should know how much they do not know and be filled with a lifelong desire to learn it. Legal education today cannot stop with teaching students law. They have to inculcate civic consciousness. They have to inculcate in lawyers concepts, beliefs, thoughts which are progressive, which will have two roles to play. One, maintain the status of lawyers and the judiciary in society. And how do you maintain that? By having that civic consciousness, by knowing that you have a role to play in formation of social norms, that you have a duty to give a dissent and disagree when you feel something is not just. Don't forget the dissent of today is the law of tomorrow. Don't forget that there was one dissenting voice, Justice H.R. Khanna in the ADM Jabalpur. And today, his is the lauded voice. His is the voice everybody talks about as having, and ADM Jabalpur was overruled, and overruled with very strong comments. And Justice Khanna's view was upheld. That is what you should all know, is that you have a right to say no. I have a right to disagree. I have a right to question. But I have a duty to myself be filled with integrity, myself be filled with an abiding need to fulfill my role of civic consciousness. Don't forget, we are in a profession where stones can very easily be thrown against us so hard. Politicians may be corrupt, they may be found out. But 2 days ago, you all know about this unfortunate incident in Delhi, when a judge's house, a lot of money was found. And that is the talking point. And it should be, rightly so, but it is the talking point. If that money had been found in a politician's house, nobody would have said anything. But today, everybody, there is no other topic of conversation than that. Why? Why? Because the common man, every citizen has that abiding faith in us. And it's our duty to live up to the faith. And what do we get in return? What we get in return is the appreciation, our social status, our social standing, our income. We get so much. Let's not forget about our role, your role as students in the framing of the future of law. Because if you fail, there is no future to law. Thank you.
Thank you, sir. You made a very quick exit off stage. If we could request you to come forward for a moment longer. I request Ms. Aparna Ravi, Director of the Hindu Group, and Dr. J.V. Selvam, Vice President, VIT, to felicitate our guest of honor and present him with a memento. sir. It is my distinct honor now to introduce our esteemed chief guest, Honorable Mr. Justice N.V. Ramana, former Chief Justice of India. Justice Ramana hails from an agrarian family in Andhra Pradesh, and after obtaining degrees in science and law, he began his distinguished legal career in 1983, specializing in constitutional, criminal, service, and interstate river laws. He served as Additional Advocate General of Andhra Pradesh and Judge of the High Courts of Andhra Pradesh and Delhi. Elevated to the Supreme Court of India in 2014, Justice Ramana has also served as the Chairman of the Supreme Court Legal Services Committee and Executive Chairman of the National Legal Services Authority. In April of 2021, he took oath as the 48th Chief Justice of India, retiring in August of 2022. Please join me in warmly welcoming Honorable Mr. Justice N.V. Ramana.
It's coming.
My dear friend, Sri R.M. Sundaram, Senior Counsel, Mr. N. Rao, Director Hindu, Mr. Ravi, Director Kasturi and Sons, Ms. Aparna Ravi, Director Hindu, Mr. Suresh Nambat, Editor Hindu, Dr. G.V. Selvam, Vice President of VIT, Mr. Navneet, CEO Hindu Group, Mrs. Brunda, Mr. Sagar Chabria, Mr. Sivakumar, my dear young friends, future of the nation, ladies and gentlemen, media friends, எல்லாருக்கும் வணக்கம். Now, before starting the conference, I heard Tamil Valaya, which is giving goosebumps to me. I appreciate Tamil people's love, dedication, commitment for their language, culture, and heritage. I am proud of you. We have to, rest of the states, particularly southern states, has to learn a lot from Tamil people about their interest in these issues. Now, one of the participants, one of the organizers of this conference, Hindu, which is not a mere newspaper organization, it is an institution. We all know that their commitment in promoting and upholding the value-based system. Since pre-independence days, it championed the cause of freedom for a set of values. Those very causes and values found their reflection in the Constitution also. I congratulate the Hindu family for their patriotism, philanthropy. I am sure that this group will continue their legacy and service to the nation. In the past 2-3 decades, Mr. Ram played a very significant role in rethinking, originating value-based journalism. In fact, long back when I am a judge, I remember in 2006, we invited him to our High Court to give a lecture about the relationship between the journalists, and the judiciary. He has said so many good things. I am also very happy. In one way, I started my career as a journalist in Inado Group at that time. I wish all the best, the Hindu family and Mr. Ravi and his family members, and giving me an opportunity to participate in this. Similarly, we have the VIT Vellore Institute of Technology, which was established in the year 1984 by Dr. G. Viswanathan, who is an entrepreneur. More than he is a politician, first initially, thereafter he became turned into educationalist and a social thinker. Created a great institute in several places in India, which started with one campus. Now it is almost 4 or 5 campuses across the country. Now, I think I was told that 85,000 students are studying in that great institute. And most of the students who are participating today are from that institute. So I appreciate their efforts in giving training, education to the children, and topping as number 10 institution in the country. Now coming back to the topic which was given to me, I say that 75% of my job is over. Mr. Sundaram has taken care of every aspect. I am just telling my law clerk something happened. It seems you have leaked the paper. The topics or the issues which I want to tell is already covered more forcefully than me, because he is every day he do this in the courts, so it is easy for him. For people like us who sits on the dais only hear their arguments and write something, so we may not give that effective way of delivering a lecture. However, I will try to say something. It was the best of times. It was the worst of times. It was the age of wisdom. It was the age of foolishness. It was the epoch of belief. It was the epoch of incredulity. It was the season of light. It was the season of darkness. It was the spring of hope. It was the winter of despair. We had everything before us. We had nothing before us. We were all going direct to heaven. We are all going direct to the other way. In short, the period was so far like the present period that some of its noisiest authorities insisted on its being received for good or for evil in the superlative degree of comparison only. 150 years back, Charles Dickens wrote these famous lines in the historic novel of Tale of Two Cities. I come across these words as a student, and they have resonated me throughout my life. These words also always remind me about the delicate balance between what is ideal, what is the real. The things which they described about me just now, about my biodata, whereas the reality is different. I came from a rural background, went to school with a barefoot, and walked almost 5-6 kilometers a day in the morning and in the evening. We had 2 meals a day, morning and evening, and no books. It is the only slate, one slate, which we had to carry. In a small school, elementary school, I learned something. I learned my alphabets of English at my class 7th, if I remember. I saw electricity at the age of 10 years. This is how I lived. I was a son of a farmer, first generation in education as well as legal field. So, you might have heard while introducing how brilliantly I am, my career and all that. The reality is this. So why I am saying this is, there is Charles Dickens, what he said, what I am saying now. There are two Indias in this country. One is India, which was described as very prosperous, very rich. And one is a country where people are still suffering for basic amenities, struggling for their livelihood. So, my young friends, you have to, coming to the world of legal profession, you have to keep this thing in your mind. Why I am saying is, all these days you are in the university campus, you have interacted with good professors, and know knowledge about what is happening in the courts, how courts will be. So, it is the time for you to visualize what is the real country is, what is the real status of the legal system is. So, I have thought of initially to explain to you like a lecturer, three parts of this system. One is the legal education, second is the legal system, third is the profession. But most of the thing which Mr. Sundaram has already taken, you all know that our system, education system as well as the legal system, we have borrowed or otherwise it is the system evolved to take care of the interest of the colonial people. Our profession, our education, this origin itself takes to the colonial times. They want a good English speaking lawyers, so they train in the college with good English to take care of their colonial interest. The focus is rote learning and protecting the interest of colonial rules. Then, after entering into the profession, it is the duty of the lawyers most of the time to protect the interest of the government or the people in power. Mr. Sundaram already told about what is the profession, what is the legal colleges 50 years back. I think almost your age and my age is the same? Same? Okay. We both had similar experiences. Of course, I don't know his background. He may be urban, Chennai born person, and your parents also educated and all that. You must have some understanding about this thing. Those days when we used to go to law school, law degree is the last resort. If you don't get anywhere anything, join law. This is how people used to take. And people used to ask us also, why are you studying law? Huh? Did you not get any employment? Or you are not getting any marriage proposals? These are the reasons which students are joined law college. That is the impression. Very unfortunate. But that is the reality. And it is also seen the law profession is a rich man's profession. It is only rich and privileged people who can go to courts, who can afford to be in profession, which is also correct. To become an independent lawyer, to recognize that you are a lawyer, at least you have to work minimum 10 years, 15 years with a senior. You have to stand up on your own legs. You must have some background. And otherwise you have well connections, either in political circles or judicial circles, or bureaucracy, somebody has to be there. A taluk advocate has to practice. If he had a practice, he has to know the Tahsildar or the station house officer, police officer. Then only he will get briefs. This is the reality. If you want to practice in high courts, you must know some minister or somebody. So at least you will get some constitutional repetition cases, etc. So like that, the life is like that. And it is a 3 years course. Now, 3 years course, you know, Sundaram has told only half of it. I think he has nicely covered. But I want to be very frank and blunt. We never heard a great speeches or lectures from great lecturers and all that. The only thing is, most of the time we used to sit in the canteen, taking care of the student union problems or some students' problem. We was branded as the most, useless branch of law, branch of the university. Our other university professors used to tell the vice chancellor, sir, please take away this law college from the campus, otherwise they spoil the other students also. They go every day and strike, and they say that why they are concerned with China's aggression on Kampuchea, Russia's aggression on something. This is how law students should be. Yes, it is a fact that I am proud of it. We used to raise for the occasion. We fought for everyone. We are concerned about the society. We are concerned about the human beings. We want to represent. We want to see, this is the only age where at least we can spend some time for the society. And again, lecturing is very difficult. So we used to, honestly, I say that we all study 30 questions at a glance. You know 30 questions at a glance? There is a series of questions published by Allahabad Law Agency. They cover all the topics and prepare 30 questions. It covers all the topics in the law, Evidence Act, Indian Penal Code, whatever it is. So in that, the lecturer, we request the lecturer on the last day of exam, sir, which questions we have to read. So he will select some 10 questions, you read the 10 questions and write some examination, and we get a degree and we become a lawyer. This is the reality. This is how we came. I am not hiding anything. This is the life. After that, this 5 years course has come now. I think it is better that at least to some extent qualified, intellectual, or people who has capable of thinking in clarity are joining in the profession. Who are serious in the profession, they are joining in the profession, which is good. And initially they are teaching English, grammar, etc. It seems. People like me, it is most important, as well as history, economics, some subjects initial they are introducing, apart from that moot course, etc., etc. But it has its own problems. It's very expensive. And entering into these law colleges, particularly national law colleges, is a very tough job, because the examination will be conducted in English, and the questions and all that is very high standard questions where rural people cannot even compete. So there is a huge problem, and particularly the entrance methodology is a very, very, very serious issue which has to be looked into. Then thereafter, about the legal education, and I thought it is appropriate to quote why legal education is necessary and what is the meaning of legal necessity. Justice Chagla, in his autobiography, Roses in December, has beautifully encapsulated. I quote, "Law is a great discipline of the mind. It teaches you how to think clearly, precisely, and accurately. Every word has its definite meaning and must find its proper place in its own context. Verbosity and diffusiveness are foreign to a well-trained legal mind. Such a mind is essentially logical and has the courage to face the result of its own mental process and not to hide them under a cloud of rhetoric and declamation," unquote. He has beautifully described what is the necessity of the legal teaching. Now, the world is result oriented, result driven. There is increasing transparency in the everywhere, every walk of life. And all the institutes which are functioning for public interest is transparent, has to be transparent, and people are aware of their rights. Therefore, be it governance or administration of justice or decision making, there is no place for theatrics. There is no alternative to logic and hard work. Now, here I think Mr. Sundaram already told, I don't want to repeat, a lawyer has to be versatile and he must know every subject. It is a fact. You can't be a lawyer with only knowing Evidence Act, Indian Penal Code, etc., etc. You must know economics, you must know history, you must know philosophy, you must know language, you must know literature. Many of times, senior advocates like Sundaram will win over the cases in Supreme Court, not by law. They will recite some poems, explain some anecdotes, and confuse the judge, get the relief. It is not, don't misunderstand me. I can tell one example. Our great Pitamaha, Bhishma Pitamaha, Parasharan, used to, one day, he had a very difficult time in Supreme Court. He's my guru. I assisted almost 10 years him in all important matters of Andhra government. So, very difficult time. And he knows that he is losing the case. How to save the situation? He started quoting something from Ramayana and how the dharma has to be. In Sanskrit. So, ultimately, judges convinced for his argument in this and he got relief. He saved the client. It's good. So, that's why lawyers should not have knowledge only in law. You have to have knowledge in other subjects also. So, it saves the situation. So, we used to say, lawyer has to be Sakala Kala Vallabha. You know the meaning of that. Majority of the senior lawyers also, not only in these subjects, the other activities also. Now I am coming back to this judicial system. The system is initially for British. Now we have created courts of hierarchy after the Constitution. And the role of the judges, I need not say. It is the duty of every judge. Judge means in the system, judge means lawyer also, to protect the Constitution and the rights, to create faith on the institution by the people. And even though we have enormous powers, we have to use the powers in the interest of public to do justice. This is the most important thing. And like any other public institution, court does not operate in vacuum. It is the people's participation about the courts that determines the strength and stability of the judiciary. Therefore, the Constitution establishes the judiciary. Its legitimacy comes from the trust and confidence of the people. At times, the institution has to face Agni Pariksha as well. But the system being resilient, I am sure it will meet the challenges. Every citizen desires an ideal world where justice is impartial, accessible, and delivered without fear or favor. This is also promise of our Constitution. Unfortunately, recent times, an average citizen is apprehensive about approaching the courts, fearing the unknown. They have raised concern about delays, pendency, accessibility, deficient infrastructure, large vacancies, transparency of legal proceedings, ill-equipped criminal justice system, increasing number of false cases, etc. the faith of the people in the judiciary is eroding. It is essential for us to address and engage with these perceptions and formulate solutions. I have been a strong proponent of Indianization of justice system. Indianization means that legal procedures and processes should be tailored to suit Indian population and its problems. The legal system must be accessible to the poor masses of the country. One effective way of Indianization of legal system is to have administration of justice in local language to enable transparency for litigants and public at large. The procedure and language of law makes it very difficult for the clients to understand the court proceedings. Once a case is filed, the litigant often feel that they have lost control over the fate of their dispute. However, once the language barrier is reduced, the case access to justice improves. There are also two other important issues which I want to highlight is, one is diversity, another is representation of women. Unfortunately, our judiciary does not reflect the diversity of the country. This is absolutely critical. We need to have judges from diverse backgrounds. Diversity in the bench ultimately enrich the jurisprudence. This problem requires action on part of higher judiciary to appoint more judges from diverse social and economic backgrounds. Salutary statements and lip service would not help the cause. The second issue is regarding representation of women. This has been a systematic issue affecting our profession in particular. Currently, there is minimal representation of women in judiciary. When I was the Chief Justice, I tried my best to get more number of women judges. There is no doubt there is also need for more women representation in government advocates and standing councils as well. Before I move on the part about the legal profession, I would like to briefly touch on the uncle judges syndrome. Through complaints regarding this have been around a while. The 230th Law Commission report has also highlighted the same. The report boldly stated that persons with well-wishers had a better chance of elevation. In recent times, senior judges of the Supreme Court have also been highlighting these issues. It is the need of the hour to get away from this culture in the system. Struggle for bringing a level playing field, a long-drawn battle. And I want to say a few things about the glory of the legal profession because we are one of the issues which they have raised while coming here is about why there is a special status to a lawyer in the society. Mr. Sundaram said it's a learned profession. Yes, it is a learned profession, noble profession, no doubt. You know the history and our legacy. Who fought for the independent freedom? Gandhi, starting with Mahatma Gandhi, Ambedkar, Nehru, Patel, everyone, Rajagopalacharia, everyone, you know, every state. The movement was led by these great lawyers. They sacrificed their properties. You know, Tanguturi Prakasam in the very Madras, he has shown his chest to the British and asked the police to fire me before firing the people. Such a sacrifice, such a leadership we have seen in the legal profession. What happened thereafter? Where is this lawyer profession? What happened to this legal profession? We have completely withdrawn from the field. We have handed over this field to others. You know what is happening now in the houses. I don't want to comment more than this. And we participated in the, not only in the independence movement, thereafter drafting constitution, thereafter in debates of the parliament. You know, Mr. Ramurthy, one of the senior member of parliament from Communist Party, how he helped in drafting Industrial Disputes Act. You read the commentary made by Ramurthy. He is from Chennai only. So, I am telling these great people who sacrificed, who never thought of their family or their wealth or anything. They worked for the society. That's why we have a special responsibility in the society. People look at us, what learned people will say. You know, you have seen when Palkiwala is the lawyer, every budget, The day in the evening, he used to hold a public meeting in a stadium in Bombay. Everybody used to go and hear him and find out what is the budget. He used to analyze the budget. See, we are the lampposts. So we have to give something to the society. There are lakhs of people mugging in the jails. They need relief. Don't bother too much about you have to go to only corporate litigation and commercial litigation. The scope of the commercial litigation in the country is very less. It is less than 5%. 95% of the litigation is civil criminal cases still. You have ample opportunity to learn, to work. One more thing, there is a myth that I want to be a specialist in this field. Sorry, it never happens. See, a junior lawyer cannot afford to say that I only practice in this particular branch. As a lawyer, if you open your shop, you have to ready to argue any case whichever come to you. It is the client whom they make you as a specialist in a particular field. So please understand, a lawyer who wants to be a constitutional lawyer sometimes may land up a criminal lawyer because he gets number of criminal cases. He has to argue those cases and he has become an expert. So initial days, don't keep in your mind that I want to be a particular specialist. Very few people get the opportunity. Who has some background, some pedigree or some office, some clientage, they will get that opportunity, not all. So you must be open-minded. Once if you join in the profession, you will learn which is the branch which is good for you, which you will shine. This is the most important thing which I want to tell you, my young friends. And here I want to tell, of course, it is a little cynical, but I have no option, which I like a very, every time wherever I address lawyers, particularly in our Telugu state, to refer this, one of the story of Rachakonda Viswanath Shastri. Rachakonda Viswanath Shastri is a very famous criminal lawyer, a revolutionary poet, and he sacrificed all his life in defending the civil liberty cases and people who are in jail without any fees and all that. He's a great scholar. Unfortunately, he was born in India and particularly a Telugu state, so nobody recognized his merit. But in one of the stories of him, it is called Aru Sara Kadalu. Aru Sara means 6 Arak stories. Sara means Arak in Telugu. This was written, I think, 1960. These stories was written. And one story is Maya. And it is in Telugu. I don't think that majority of you doesn't know Telugu, so I have made an attempt to give a gist of that story. It is very interesting for particularly young lawyers. I quote, Maya. Murthy, name of the junior advocate, after getting law degree, wants to start his career. He approached a senior lawyer with humility. The senior lawyer told Murthy to remember one important thing. He stressed that to succeed in this world, you have to do the following things. He quote, the early bird catches the worm, said the Englishman. Englishmen are very wise. He never does anything unless there is something in it for him. That is why he should reach the court every day early and get the court gates open. Morning you have to go to the court and you see that gates are open. And in the evening, wait until the court gates are closed. Always be alert and make sure that you are present in the court each and every day. Just like that, just like the cranes stand on the shores and foxes hang around the graveyards. Of course, the kind of comparison is not very pleasant, but this is what we must do. If you want to shine, you must always be in the court. You know what the court is? It is like a dense forest. Hyenas mimic human laughter and in the forest. If you go closer thinking there is another human, the hyena will eat you. We lawyers need to attract the clients that come to the court in this manner. Do not be shocked. It is the fault of the person who enters the forest, not ours. But there are bigger animals than hyenas. If we are not careful, then those animals will eat you. These courts, laws, law books are invented by the British. There are many courts to approach. There are many judgments for judges to pick up and announce whatever ruling he wants. There are many rascals available to testify. We are there to justify. Whether it is civil case or a criminal case, it is all about evidence, not about any truth. It is enough to just shout words like justice, truth, and righteousness. Know that everything is illusion, maya. How can any sin touch us when the system is like that? All the sins go to the judges. All the expenses are borne by the parties, and all the fees are ours. English people owe their existence to the courts. They are big tricksters. They came to our country and sold our salt to us and said, you ate our salt and be loyal to us. They built courts and jails for us and built bungalows for themselves. After hearing this, Murthy became nervous. The senior told him, don't be nervous. I spoke cynically, but this is the truth. If you remove the shred, the reality is this. Don't panic or be afraid. I unquote. This is the story which this gentleman has written long back. The system is like that now also, sorry to say. So my dear friends, this is what I want to say. More than this, I don't think that, I think already we crossed our limits, speaking too much. And you have plenty of chances. And majority of the senior counsels are shining counsel in Supreme Court or other courts are from not only urban cities and allied people, from rural areas also. So many people are coming and they are practicing. And if you work hard, if you learn the functioning of a judiciary, you will get. Court card is most important. Read the judge, follow the traditions, respect the elders. This is the most important thing which I want to tell you. Growth of cases is enormous because of enormous changes in the economic field, population growth, disputes, awareness of law, etc. And this is all I want to say. I will try to give the copy of the speech to this thing. And we have a social and moral responsibility. And one more thing I want to say. Don't think that allied posts or the Chief Justice of India post, judge posts or some other important advocate generals, attorney generals it will be only meant for a few people. Take case of my example. I am a rural background, no godfather, a son of a farmer. I reached to the highest position in the country. Not that I am great. It is the greatness of our constitution. It's the beauty of the democracy. So you understand, such a visionary document was there in this country, which takes care of everyone every citizen of this country. We have to respect and we have to follow the ethics of that. One US, finally I will say that one US judge said, what is the good qualities of a lawyer? That a good lawyer have 5 functions that include being a wise counselor, a skilled advocate, a contributor to the improvement of the legal system, and an unselfish and courageous leader of public opinion. This is the most important thing. If the judiciary has the responsibility to uphold the rule of law, the lawyers have similar responsibility to do that. A good lawyer has a duty even towards all those who cannot approach to the courts for justice due to the social and economic disability. Do your bit to the society. Take up more legal aid cases. And there are number of opportunities for you. You need not be a lawyer. You can work as a legal advisor to some firms. You can work as a law officer of some banks or government. And you can be a teacher. A lot of opportunities are there. I will quote one example where Daftari said once, C.K. Daftari, and while he was sitting in a library one day, he heard a conversation between 2 youngsters. saying that it is right time, I think we must quit the profession. We are not shining here. There is no chance in this profession. We want to get out of this. I don't know what happened. Better sense will prevail on those two lawyers youngsters. They continued, and thereafter one has risen and one become the first Chief Justice of India, Justice Kanya, and second is the first Attorney General, Setalwad. So this is a good example. Keep inspiration from these type of things. You must enter the profession with zeal of a champion of justice. It would be false to state that every graduate would get equal opportunities upon graduation. You have to work and at least some years get ready, and for that. And now our profession is witnessing difficult times. I sincerely hope that the next generation works hard to bring back to the glory. And finally, I will quote what Nariman said, Fali Nariman said. I quote, "In this country of ours, the judiciary is the salt of the earth. My wish for the third millennium is that, if it pleases to God, there be no occasion when it is said that the salt has lost its savor. Because as Bible warns us, if the salt ever loses its savor, then wherewith shall it be salted?" Thank you, gentlemen, giving this opportunity. I wish you all the best. Thank you, everyone.
A big thank you to the Honorable Mr. Justice N.V. Ramana. May I request Mr. N. Ram, Director of the Hindu Group, and Dr. G.V. Selvam, Vice President of VIT, to present him with a memento. Can we have a big round of applause, please?
Was the front page of the Hindu on the day former Chief Justice of India, Justice Ramana, was born.
Thank you so much to our dignitaries, to our audience, our dear guests and students. We will now take a 15-minute break. Thank you so much. After this break, we will reconvene for our session with our special guest, Dr. Justice D.Y. Chandrachud, Honorable former Chief Justice of India. See you back in the main hall in 15 minutes. Thank you.
Every reader is an explorer of information, knowledge, creativity, innovation, and art. We at The Hindu have always made sure that the journey of the explorer is an extraordinary experience. So we heard what you want and we are delivering it. Introducing a smarter and cleaner news reading experience with an enhanced visual design upgrade and reader-friendly features. Our authentic and credible journalism remains intact. Now, our redesign matches it with hard-hitting headlines, bold typefaces, and bigger pictures. The Hindu is now designed to be cleaner, sharper, and bolder. You know our designs are not just placements of texts. Every reader is an explorer of information, knowledge, creativity, innovation, and art. We at The Hindu have always made sure that the journey of the explorer is an extraordinary experience. So we heard what you want and we are delivering it. Introducing a smarter and cleaner news reading experience with an enhanced visual design upgrade and reader-friendly features. Our authentic and credible journalism remains intact. Now, our redesign matches it with hard-hitting headlines, bold typefaces, and bigger pictures. The Hindu is now designed to be cleaner, sharper, and bolder. You know our designs are not just placements of texts and images. They tell a story. Promos are made more dynamic and vibrant with eye-captivating designs to give you the ultimate visual experience. Lead story will have a bolder font distinction with the strap showcasing the gist of the story. Increase in font size from 8.2 to 9 points with a 15% decrease in the total word count delivers clearer and sharper stories with no compromise in the quality of the content. More space between the columns gives the paper a cleaner look. Bigger and impactful pictures bring the story alive. Infographics and more visual elements can be found throughout the paper. Quotes that capture emotions are what made our journalism credible. They are now taking a new form of contemporary design. Insider update of all your neighborhood news comes in a digitally integrated design through dynamic, in-brief, and nearby columns. Taking the center stage, page markers are now bolder. The editorial section is now made cleaner, bolder, and sharper with more emphasis on the magic of white spaces. A page aligned to perfection will give the readers the most enjoyable and organized reading experience. QR codes and digitally integrated navigation pointers will help the readers identify multimedia content such as online stories, interviews, videos, and podcasts. FAQs, profiles, science, money-wise have an enhanced look. The hierarchy of information can be easily identified with a shift in emphasis from bold to light and big to smaller headline fonts. News in Frames is taking an elevated magazine-like visual appeal with the use of vertical photos. The Sunday edition has been embellished to perfection with a design that is playful, vibrant, and trendy. Presenting Metro Plus, Weekend, Downtown, Magazine, Friday Review, Opportunities and Classifieds with an exciting new look. Our style of storytelling has been inspired by the social media landscape, which has enabled us to dive into a whole multiverse of possibilities on how visual impact can change the reader's experience. And our design will mark the beginning of it. So get ready to sit back, sip your coffee, and open our redesigned newspaper. It's not just a newspaper anymore. It's an experience.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus, strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
When it comes to moot courts, VIT has a very interesting two-tiered system. First, we compete against our peers in the intramural moot courts in various fields like international law, corporate law, competition law, taxation law, etc. And once we qualify, we move on to participating in external moot court competitions. VIT School of Law and the Moot Court Society focuses on holistic development of students to not only understand the theoretical aspects of law, but also the practical aspects of pleading in a courtroom and analyzing case laws. To that end, students receive very holistic and comprehensive development when they participate in moot courts through VIT School of Law.
I'm Kanaga from second year. The overall experience at VIT School of Law is life-changing. The faculties are exceptional, constantly motivating us to think critically and to develop a deeper legal knowledge. Their expertise and dedication has created a learning experience that has challenged the students to push their intellectual boundaries. Beyond academics, the state-of-the-art infrastructure and resources has equipped the students to use the best tools in order to succeed.
Hi, I'm Rishabh Nambia and this is Mariam Matthew, and we are fourth year students at VIT School. We actively participate in various cultural festivals that is held in VIT. There are multiple clubs for dance, music and film, and we are a part of few of these clubs.
VIT School of Law has its very own debate society, and we host various competitions.
We are all set to begin, requesting all of our guests and students to kindly take your seats and do make sure that your mobile phones are on silent mode. We are starting in the next few moments. Thank you so much. Welcome back to Justice Unplugged, requesting everyone to kindly take your seats, make yourselves comfortable as we are all set to begin with our next session, a very, very interesting one, a Carrero with Dr. Justice D.Y. Chandrachud, Honorable former Chief Justice of India. Yes, a round of applause. As a Supreme Court Judge and Chief Justice of India, he delivered landmark rulings on decriminalizing homosexuality and adultery, recognizing privacy as a fundamental right, and upholding the electoral bond scheme. He led the digital transformation of India's judiciary. Striking down. He led the digital transformation of India's judiciary, overseeing over 18,000 courts, and introduced live streaming and transcription of Constitution bench proceedings. He also championed gender sensitivity and the elimination of stereotypes in judicial language. So ladies and gentlemen, and our dear students, please put your hands together and welcome Dr. Justice D.Y. Chandrachud, Honorable former Chief Justice of India, and Mr. Mohammad Imranullah S., Deputy Editor of The Hindu. Let's welcome them both on stage.
Ladies and gentlemen, a warm welcome to all of you. When I was born in 1980, Justice Y.V. Chandrachud was the Chief Justice of India. 44 years later, I'm sitting next to his son, who has just demitted office as the 50th Chief Justice of India. What a phenomenal achievement. What a phenomenal achievement. Like father, like son. And how did he achieve this? Was he standing next to his father's chair in the Supreme Court of India? The father rose, made his son sit, put the crown on his head, and made him, said, henceforth you shall be the Chief Justice of India. No. That doesn't happen in independent India. It might have happened in British India. Dynasty, or dynastic things don't happen now. He was pursuing his master's in law in the prestigious Harvard Law School when his father was the Chief Justice of India here. He obtained his master's in 1983, his doctorate in law, again from the Harvard Law School in 1986. After his father demitted office in 1985, he came back to India, started his practice at the Bombay High Court and the Supreme Court, and then he got designated as a senior advocate in 1998, sir. Yes, 1998, Then he got elevated as a judge of the Bombay High Court in 2000, in the year 2000. 13 years he was a judge. In 2013, he was made the Chief Justice of Allahabad High Court. 3 years he was there. In 2016, he became a judge of the Supreme Court. 6 years he was there. In November 2022, he occupied the topmost judicial office in the country as the Chief Justice of India and completed his 2-year tenure in November 2024. It's an honor to be with him here. Now, all this speaks of his intellectual abilities. And I don't know how many of you know about his charming personality. I must say this. So one of my colleagues, when she knew that I'm going to be in a discussion with him, she told me, "Sir, please tell him that he looks like Shah Rukh Khan." He may be 65, but he looks 45. My son saw him on television, 12-year-old boy, and then says, "How come he's so young?" I asked him what. He said, "Chief Justices would generally be old, aged people, haggard, right? And he's dashing." And one more advice he gave me was, he saw 2 of his interviews. In one of the interviews, he was wearing a pullover sweater, and he looked nice. And so he told me, when you meet him, tell him that he looks good in casuals, more than formals. So that is the kind of personality we have here, and I'm happy we shall begin this conversation now. Sir.
Thank you. Thank you very much, Imran.
Welcome, sir.
Wonderful words of welcome.
So, appointment of judges to the higher judiciary has always remained a challenge. Jurists often say that those who deserve to be judges do not want to be judges, and those who want to be judges do not deserve to be judges. Having been a part of the collegium in the Bombay High Court, in the Allahabad High Court, and again in the Supreme Court too, how difficult did you find to convince good lawyers to accept judgeship?
At one time, accepting the call of office to the higher judiciary, I presume you're talking about the high courts and
Of
the
course,
Supreme
yes.
Court, was always considered a matter of honor. So when I became a judge and when the Chief Justice called you and requested you to become a judge of the court, no was never an answer, because it was an answer to a higher calling, namely to serve the nation for public service. Things have gradually changed. And I'm glad you asked me about my experience ranging from Mumbai to Allahabad and then to Delhi. What's increasingly happening is that good lawyers are just not willing to accept judgeship, particularly in cities which are, the commercial cities like Mumbai, and this is spreading all across the country for a variety of reasons. I think part of the reason is, of course, the wide disparity between what a lawyer makes in the course of a day at work and practice. But I think that's only part of the reason, because somebody who accepts public office never does it because of the emoluments which you get, or because of the trappings of the office. Like when I became a judge, you had those flashing red lights on your car. Nobody really becomes a judge because of that. You become a judge because of an inner calling, that you want to be of service to the community, to society, to be part of the transformation of society. But apart from the tremendous disparity, and this is something which you can't discount, for the reason that judges at the High Court retire at the age of 62, the Supreme Court at 65. At 62, you're at the peak of your capacity, and I dare say at 65, when you're suddenly told that you can't work anymore in the court. So more and more people are then asking themselves about what they would do after they retire. One, you can't go back to the bar, and there's such a huge disparity. I mean, just the economics of it doesn't work well. So if we truly want to safeguard democracy, then this is a price which you have to pay, namely of having judges who are going to be paid good salaries, both when they are in office and after retirement, because how a judge lives after retirement determines the independence of the judiciary when the judges are in office. You don't want to have judges who are going to look at post-retirement assignments. But apart from that, there are other reasons. I mean, whenever I spoke to lawyers, it was a Herculean task persuading them to become judges of the High Court, particularly in Bombay. And they would say that, Judge, it's not just a question of the difference in emoluments, because we don't have a fancy lifestyle, we don't have crazy ideas about living. But we have very strong reservations on two issues. One, the uncertainty in a judicial career. You really don't know where you would be, say, 10 years or 12 years or 15 years down the line. That uncertainty is there in any job. And uncertainty is no ground really therefore to spurn a job. But apart from that, a lot of lawyers would say that, well, I'm just not willing to accept the element of distrust and the kind of scrutiny that goes into, you know, every little aspect of your personal life. It is as if that when you accept that you're going to become a judge, you're laid open to almost anybody saying whatever they want to say about a judge to be. So, you know, that's one thing which we really need to think about, because just as there is legitimately a plea for transparency in all aspects of our public life, and I, for one, I support that plea for transparency, and that's why I, you know, promoted live streaming of our court proceedings. At the same time, we need to ask that we have to draw the line at a point where the evil which you are trying to curb would not be dealt with by your answers, and in fact, good people would just not be willing to accept the call of office. In the tier 2 cities, if I may, with great respect, call them, they are not tier 2 in the sense of the intellect of the people. In the hinterland, for instance, when I went as Chief Justice to the Allahabad High Court, it was less of a problem, because judgeship does still command a certain degree of social respectability, community values, community status. That is not so much now in larger cities like Mumbai, Delhi, Bangalore, Chennai, Kolkata. You see so many more young people saying, sorry, I just don't want to become a judge. The final reason I think why people don't want to become judges is, you know, the constriction of lifestyle. The first thing that happens to you when you become a judge, you are completely isolated. You're isolated from your friends. You're isolated from the life which you lived as a lawyer. There are things which necessarily you can't say in public because of the constraints of office, the discipline of the office, and people are just not willing to accept that change, which is a very significant change. And it's not a change only so long as you are a judge. It still affects you even after you lay down office.
My second question would be on, a layman often asks, now for example, we take the Madras High Court. A sanitary worker has to be appointed there. A notification is issued. There is a written test. There is a practical test where they have to clean the toilets and show how well they can clean. And then they sit for an interview. When so much is being scrutinized to appoint a sanitary worker, how come a judge of a high court gets appointed just like that, despite it being a constitutional post? A layman fails to understand that his lawyer, whom he was meeting till yesterday, suddenly becomes a judge just because the collegium thinks that X, Y, or Z is capable of holding judgeship. What would be your answer?
Now, you know, 2/3 of the judges in the High Court are drawn from the bar. This is a convention. 1/3 of the judges are drawn from the district judiciary. The judges who come from the district judiciary are again drawn from those who entered judicial service after facing a competitive examination. And interestingly, almost in most states now, the number of women entering the district judiciary is way in excess of 50%, some states up to 70%. That's not your question though, so I'll not go into that. So there is a threshold assessment which takes place of all district judges at the point of entry. A junior civil judge becomes a senior civil judge, an additional district and sessions judge. There's a lateral entry into the district judiciary when you appoint directly recruited district judges, that you can become a district judge with a certain number of years of service, again at which stage there is an examination. There is a continuous assessment of your ACRs, the annual confidential reports, the quality of your judgments. So the district judiciary, which eventually moves as a career progression into the High Court, is therefore subject to continuous assessment right at the threshold. Even when a district judge is appointed to the High Court, there is an assessment. There's an assessment of their judgments independently by a judgment assessment committee of senior judges of the High Court outside the collegium. You look at any complaints against them. There is an assessment of their annual service record, so on and so forth. Now you must understand, now when it comes to appointing lawyers to the High Court, the minimum age for recruitment to the High Court is 45. We generally don't appoint people anymore below 45. I was asked when I was 38 and I became a judge when I was 40. But the ordinary rule is 45. Now the question is this, at the age of 45 when you are appointing a lawyer to be a judge of the High Court, are you going to ask them to sit for a test on the basic principles of civil law or criminal procedure code? Are you going to ask, say, a person who's going to become a CEO of a large company in corporate India at the age of 45 or 47 to become a CEO, hey, wait a minute, we're going to get you back to what you learned in management school and ask you to appear for a written examination? It doesn't work that way. In fact, we would always joke that so many people at the age of 45 or 50, if you ask them to appear for an examination, they'll probably flunk it. Because that's not your life. By the time you're 45 or 50, what you have is in terms of your experience, your court craft, your knowledge in the practical application of law. But I want to really clarify this, that the assumption that lawyers who are appointed as judges of the High Court do not face an assessment is again wrong. They are subject to very careful assessment. One, the collegium which recommends a lawyer for appointment to the High Court has the benefit of hearing that lawyer day in and day out, and not over one case or two cases. For years, the Chief Justice may be a very new Chief Justice drawn from outside the state, but typically your collegial judges have seen that lawyer evolve over a period of time. The appointment process is vetted by the state governments in the states. It is vetted by the union government, where a very detailed analysis of antecedents and character is made by the Intelligence Bureau on the Ministry of Home Affairs. It is also vetted by judges of the Supreme Court drawn from that High Court. So if we are making an appointment to the Madras High Court, judges of the Supreme Court who are drawn from Madras, not originally necessarily from Madras, but even people who moved into Madras as Chief Justice, their opinions would be sought. So the assessment to appointment of judges in the High Court does take place, but it has to be an assessment commensurate with a constitutional office which you are going to hold. For instance, when you appoint a chief minister in a state, I'm not saying that there is a parallel. That's a political office. This is a constitutional judicial office. Are you going to ask a chief minister, you better appear for these questions, on governance? No, that's not the way it works. It doesn't work in a political democracy. Does it work the same way when you appoint a governor? Will you appoint, when you appoint the President of India? Therefore, these are constitutional offices. The assessment for appointment of judges of the High Courts has to be there, and it does take place. But it's very different from the first threshold level of assessment. You rightly gave the example of a sanitation worker. Likewise, when we appoint judges who are junior civil judges in the district judiciary, they are made to face the whole gamut of examinations. They have to go through, testing for their knowledge of substantive law, their interviews, and they go through the whole process of appointment. Likewise for the High Court. When it comes to the Supreme Court, last part of your question, appointments to the Supreme Court are generally made from the pool of High Court judges, High Court Chief Justices and High Court judges. At that point of time, the critical ingredient is the quality of work which is done by a High Court judge. Every single day, every judge of the Supreme Court, particularly Mondays and Fridays, has anywhere from 60 to 80 cases to handle. So you're reading 60 to 80 judgments drawn from the judges of the High Court. In the Collegium of the Supreme Court, when we are discussing names for appointment to the Supreme Court, at least I made it a policy to get random judgments of the High Court judges who are under consideration, circulate them on a pen drive to all members of the Collegium, so that everyone has studied those judgments. You've all read the judgments of Judge X or Judge Y, but the importance of that is when you're sitting as a collegium, you read the same judgments over and again. Otherwise, as a judge, I would be reading very different judgment from what you would be reading as another judge as part of the collegium. So there is this assessment. I'm not saying that it's perfect, but to say that there is no assessment wouldn't be correct.
Now, coming to this collegium, for example, right now in Madras High Court, we have 10 vacancies. 75 is the sanctioned strength, 65 is the working strength. 12 vacancies are going to fall this year. So 22 vacancies are there. The collegium has to recommend names. Now, if I say that there can be a quid pro quo between the collegium members and the state government, saying that I will recommend 5 names each of you members recommend 5 names. I will not object to the names you recommend. You will not object to the names I recommend. Can you say for sure that this quid pro quo cannot happen in the collegium system?
Are you saying for a moment that the quid pro quo is with the government or between the members of the collegium?
Between the members of the collegium and the government.
All right. In other words, what you are asking me really is this. Can you say with certainty that there is no imperfection in the system? I mean, I don't think in any system of democratic government or governance that you can say that any system is 100% perfect. And I don't think I can venture to make that assumption or even that statement. But to say that there are imperfections in any system is one thing. The answer to it is not to jettison the system. Because what alternative do you have? And we'll probably be discussing as we go along, you know, what the alternatives are. So the question is, do you have a better alternative? But to come directly to your question, and assuming, let me for a moment assume that there is an element of quid pro quo in a given case, because, you know, 3 members of the High Court are sitting together as a collegial team. They're obviously discussing the merits of people who are being appointed. They bear in mind a whole host of considerations, appointing people from diversified backgrounds, from gender, from the perspective of gender, having more women, having more people from the marginalized groups in society, the scheduled castes, the scheduled tribes, the backward classes, to have people from different segments of the community, particularly in a society which is so multi-religious, multicultural, and plural as our society. But assuming that there is this element of not give and take, but this element of discussion, and there is this element, according to you, there possibly, how do you rule out a quid pro quo with the government? The answer to it is that the scrutiny does not end at that level. In fact, you find that there's another level of scrutiny which takes place in the Supreme Court Collegium. So in the Supreme Court Collegium, the first 3 judges who decide on whether a name which has been proposed by the High Court should or should not be accepted, they are one step removed from it. They would make their own inquiries. They have their own inputs. They have inputs from their own colleagues in the Supreme Court. They have inputs from the government. They have inputs from a wide variety of sources. For instance, the Collegium and the Supreme Court even can consult a senior member of the bar or more than one senior member of the bar from that particular state. So you're constantly taking inputs from various levels. And if you find that there was some quid pro quo which led to a person who is not deserving to be recommended, that additional level of scrutiny or assessment or the multi-layered assessment then adds some degree of assurance that, you know, these kind of things are overall evened out. But if you still ask me, is the system perfect? How can I say with any measure of confidence that the system is perfect? I mean, in any system of democratic governance, every system which you conceive of can't really be perfect either conceptually or for the simple reason that it's manned by human beings. But the effort must always be to reduce the imperfections, either by recourse to some transparency or objective norms, so on and so forth.
Now coming to social justice. When you were the Chief Justice of India, you made sure that there was inclusivity. And you even made sure that the collegium recommendations had explicitly mentioned why you were recommending a particular person to become a judge, and what is his social background, and why we require such people in the bench. Despite all that, still inclusivity of women, the physically challenged, in the judiciary is still a debated topic. Would you like to elaborate on that?
Yeah, of course. I think it's very crucial. It's a very valid concern that you have raised. Now, when you talk again, we are talking again of the High Courts and the Supreme Court. As I said, insofar as the district judiciary is concerned, the fascinating part about, you know, the evolving nature of India as a nation, as a society, is the fact that over 50% of women are entering the judiciary at the lowest levels, which means it suggests 2 things. That when you give women a level playing field and an equal opportunity, women are not just doing as well as men, but they are doing much, much better than the men are doing. And by and large, you know, if you talk to the young audience today here, in the national law schools, or why just the national law schools? Even the non-national law universities, you find over 50% of the inflow into the first year LLB class is of women. So that's happening across India now, that you have more and more women entering into the law schools. Question is, how do we ensure that these women who enter law schools, they don't sort of fall by the wayside in the profession? Because all said and done, the legal profession even today is terribly patriarchal. Women have far greater responsibilities in a social context than men do. They take the burden of childbearing, child rearing. And therefore you find that a lot of women really drop out from the bar as a result of the conditions of work. So Imran, your question on why don't we have more women is also to be answered in the context of how our profession is structured. How do we ensure that the legal profession, which is not just a judicial responsibility, is the responsibility of each one of us in society, how do we ensure that the legal profession itself is not a gendered space, that it is an equal opportunity space? And we can do that by making sure that, recruitment to chambers of lawyers is more meritorious. That's why the law firms have been very successful, because recruitment to law firms has been merit-based. It doesn't, proceed on the basis of the old boys network. That change is still to take place, though it is taking place gradually. Now, in the higher judiciary, now take the case of the Supreme Court. I was always asked this. Why is it that you have only, say, 3 women judges in the Supreme Court? And I always say that, look, the state of the Supreme Court today, in terms of the recruitment of women, reflects the state of the High Courts 15 years ago, when those women who are now going to be part of the pool for appointment of the Supreme Court were appointed as judges of the High Court. And that necessarily reflects the pool of legal talent in the legal profession 20 years before that, when they joined the profession. Things are changing now, as you find more and more women, being extremely successful as lawyers. There are lot of things which, institutions can do as well. For instance, in the 75 years after independence, between 1947, actually from 1950 to when the Supreme Court was set up, between 1950 and 2024, all of 13 women were designated as senior counsel in the Supreme Court. Just 13 in close to 75 years. Last February, in one lot, we designated 12 women as senior counsel. And we followed that up in August with another 10 women. So as institution builders, judges are not just adjudicators, you're also an institution builder. So you need to, make a conscious effort to allow for women to have more positions of responsibility in the legal profession. You spoke about the disabled, people who have physical disability. There was a judgment of the Supreme Court itself, which had said that, somebody who is blind, who is visually challenged, cannot fulfill the role of a judge. I overruled that judgment. I overruled the judgment sitting in a larger bench of 3 and said, visual disability has nothing to do with your ability to work as a judge. And that has again been affirmed recently, just last week, by another bench of the Supreme Court. In fact, one of my law clerks, when I was a judge of the Supreme Court, was a blind Rhodes Scholar. And, he was pursuing his master's at Oxford and called me up and said, I want to come and clerk for you. So I said, why on earth would you give up a Rhodes Scholarship and come to work with a judge of the Supreme Court? Because he says, that's my social conscience. So he came and worked with me, and he told me a lot of things which we could do to make law and life easier for the visually challenged. For instance, we had, just to give you a little bit of this, anybody who is interested in technology, we would have visual captures. Now, somebody who is blind cannot access a visual capture on the website of any public website. So we first changed our visual capture into an audio capture. Files were digitized. They were digitized in such a way that they were OCR enabled. So somebody with a visual disability could read those files. Technology has been a great enabler. So I think, but for the disabled, people suffering from disability, a lot more has to be done in our system. Last year, we had this young woman lawyer. I can share her name because, she wouldn't want it to be private. Her name is Sarah Suni. And Sarah has, she has she's hearing impaired and she's speech impaired. And she pointed out to me that, look, I'm a lawyer. I want to argue my cases. But how will I argue my cases in the Supreme Court if there's no sign language translation facility? So for the first time, we introduced sign language translators, interpreters, in the Supreme Court. So things like that, during my tenure as the Chief Justice, we carried out an accessibility audit of the premises of the Supreme Court. The committee was chaired by Justice Ravindra Bhatt, who was my colleague, and we had a whole lot of civil society domain experts. And they went to every little space in the Supreme Court, including toilets. Are the toilets accessible to the visually, to the physically disabled or the physically challenged citizens? They came out with a report on what changes we need to do in the infrastructure of the Supreme Court. And I wrote across to all the high courts that please start this process in your courts as well, so that more disabled people can come to... Incidentally, we also set up the Mitti Cafe in the Supreme Court. And the Mitti Cafe is run by this very young woman, and everyone who works in Mitti Cafe is disabled. So everybody from somebody who mans the cashier to somebody who serves you there is physically challenged.
That's fantastic.
And the President of India came to the Supreme Court for the installation of Dr. Ambedkar's statue. So when we were walking back from the installation ceremony to the unveiling ceremony to my chamber, I asked the Honorable President, I said, ma'am, would you like to see Mitti Cafe, which is a cafe which is run exclusively by disabled? And she said, I would love to go. So, she pushed aside all her security and she walked into the cafe. She sat on one of the tables in the cafe, talked to everybody in the cafe. But these are huge learning experiences, and these are symbols that, we are trying to become more inclusive. The Delhi High Court set it up. I'm told the Gujarat High Court has set it up. Rashtrapati Bhavan has a Mitti Cafe now, a cafe which is run by. So more and more of our public spaces, whether it's in the newspapers, it's in corporate India, they have to have. We must allow for greater footage for the physically disabled. Just 2 days back, last story. 2 days back, a mother wrote to me and she came with her daughter. Her daughter stood first in the CBSE and in the higher secondary. She cleared the IIT JEE, but she only qualified in IIT Delhi and Mumbai for chemical engineering. The mother said, what will she do with chemical engineering? I want her to become a computer specialist, an IT specialist. So they went to Kanpur. She went with her daughter, settled in Kanpur. The girl passed her education in IIT Kanpur, has now got a job in Microsoft in Hyderabad.
Wow.
So, these are the sort of things, and she suffers from spinal muscular atrophy. So she's in a wheelchair, like two of our own two daughters whom we have adopted. So in that sense, therefore so much is a product of what judges do, and so much is something which is much beyond just the role of judges. I think it's all about, how we as members of civil society try and improve.
Great. So what DYCJ is telling the women here is that all of you will be in the bench after 10-15 years. Men will need reservation. Okay.
Yes, of the South African Constitutional Court. He was he's a blind judge and did brilliantly, actually.
So I'll move on to my next question. National Judicial Commission. So we had this National Judicial Commission Act, and the Supreme Court, your Supreme Court, struck it down. Now,
your Supreme Court as well. It's everybody else's Supreme Court.
So what do you think right now should the Parliament do? Should they bring in another law? Or do you think the collegium system should stay on forever?
Well, let me begin by saying that, Parliament doesn't need our advice. Obviously, they know what they can do. Even if a judgment of the Supreme Court strikes down a legislation, or in this case, a constitutional amendment, on the ground that it suffers from certain deficiencies, those deficiencies can be cured. And by enacting a new law or a new constitutional amendment which takes care of those deficiencies. Parliament can't say that a judgment of the Supreme Court is wrong, but they can certainly take away the deficiencies which have been pointed out by the Supreme Court. That's constitutional theory. But I really want to ask you, since this is more of a chat than an interview, I want to ask you this. If you want to replace, say, the collegial system, the collegium system, with a new mantra or a new avatar of the National Judicial Appointments Commission, what is it that we as a society are trying to achieve? We must first define what our objectives are. If we define what our objectives are, we'll know what to do. What are those objectives? First, you must have judges who possess competence. In an increasingly complex world, when we have disputes, as India has been liberalized and the economy is liberalized, you have complex disputes on electricity, competition, insolvency. So you need domain experts as well. So you need competent people as judges. Among them, there should be domain experts. That's one. Second, you need people of integrity. Third, you need people who will preserve the tradition of judicial independence. That's the third thing the third parameter. Fourth, the character of the judiciary must broadly be representative of the character of society. Namely, just as Indian society is diverse, whether in terms of gender or sexual orientation or caste, marginalization, there has to be broad representation, particularly to regions, to communities, to castes. And fifth, there has to be a greater deal of representation, particularly to the marginalized and to the minorities. These are the 5 broad parameters. Now, if we are going to replace the collegium system by a new institution, I'll not label it on what you call, labels are really just a matter of, labeling, that's all. If you're going to replace the collegium by something else, the structural design or the constitutional design of that new institution must be such that these objectives which we have laid down, and I'm not saying that these are the only objectives, you may have other objectives, which I've just sort of missed probably in just, a spontaneous response, that these objectives will be better fulfilled by the new institution which we are creating. For instance, judicial independence has been one of the critical features of Indian democracy over the last 75 years, which really means that the government should not have a predominating voice in the selection of judges. So if you create a new institution by saying, oh, well, the collegium has these defects, now we'll have this particular institution, we'll have another National Judicial Appointments Commission. Do you want, merely because of the defects of the collegium, to create a new institution which will not answer those defects? Or how do you create the institution which you want to create, which will take care of those defects? Now, independence. Who selects the judges is critical. How will you ensure that the new institution which we are putting into place will result in a selecting body, which again is independent? Because the independence of the selected people is often determined. Why often? It is determined always by the independence of the selectors. How good your cricketers are depends on how good your selectors who select those cricketers are. Right? To give you a cricketing analogy, since IPL has started. So, the question is not just about, is the collegium going to continue forever, or should we have a National Judicial Appointments Commission? At a constitutional level, there's no bar at all. Parliament can always, take care of the defects which have been pointed out by the Supreme Court in the NJSC judgment. But my concern is broader, which is that any alternate institution which we create must be an institution which preserves our concerns as citizens in the legitimacy of the Indian judiciary, the credibility of the Indian judiciary, that it should be an institution which in that sense does not really multiply the problems instead of creating a better situation.
Now I'll come to the performance of judges. Pendency of cases has always been a concern for all of us. The numbers are growing up and up and up. And then we have hard-working judges, and then we have hardly working judges. Now, when it comes to the district judiciary, there is as you said, that ACR, annual confidential report for every judge, where a portfolio judge, a high court judge, assesses the performance of the district judge. Do we have anything like that for permanent judges of the High Court or the Supreme Court?
No, we don't have an assessment of the work of a judge of the High Court by either the Chief Justice, nor is there an assessment in the terms of, in terms of grading or giving grades to the work which is done by a judge of the Supreme Court, by the Chief Justice or by the senior judges. We don't have it like that. Question which you asked me is a very legitimate question again. Shouldn't we really be imposing some parameters for assessing the quality of the work which is done by, say, judges in the High Court? Because you made that distinction between judges who work hard and judges who hardly work. Now, that's all right, that's great coffee table conversation. It's not exactly reflective of reality. But, Imran, how do you assess judges is again a very critical point. Should we assess judges, if we were to have an assessment, only by the number of cases which they disposed of? Now, if we go by purely volume-based parameters or quantum-based parameters, I can assure you that's the easiest thing in the world for a judge to dispose of, to show that you have disposed of 10,000 cases in a year. Pick out all the small cases, including the small applications which come, and say I've disposed of 100 cases today. On the other hand, a given judge may be, you have very distinguished lawyers and the senior advocates in the audience as well. You may have a judge who's dealing with an election petition. That election petition might take that judge 15 days to dispose of. A judge may be dealing with, say, a criminal appeal in a bomb blast case, where there may be like 100 witnesses, there may be multiple accused. These kind of cases take a lot of time. So the nature of the assessment must also factor in the quality of the work which the judge is doing. But yes, I do believe that, it's important for us to have some assessment of the quality of work which is done by judges without, again, impinging on the independence of the court. So the assessment must be by someone who does not have the power to affect the independence of that particular judge. Now, what kind of assessment should we have? As I said, it can't be a quantum-based or a quantity-based assessment. It has to factor in both quantity as well as the quality of the work which is being done by the judge. The greatest, ultimately, Imran, in a democracy, the greatest guarantee that you have to judicial performance is scrutiny by the public. The work which is done by a judge is constantly being assessed by the lawyers who are in front of that judge, the lawyers who sit in the court. Suppose we are the two judges in a division bench and you have this big audience of lawyers in front of us sitting in the court. They are watching every move. They are watching every order that you dictate. They are making a note of every observation of the judge. They are passing judgment on the judge every single moment of the day. That's the beauty of, an open court that we have. The reason why I also promoted, live, the video conferencing and live hearings being relayed on YouTube. And now we are, of course, going to our own cloud infrastructure, live streaming of court proceedings. I felt that there is a degree of accountability which then arises on the performance of a judge. When a judge knows that you are being live streamed, people at large want to know, are you sitting through the day or do you just get up at 2 o'clock and run away and you're not available in court after that? People should also know why cases are adjourned. Do judges adjourn cases, or is it that lawyers are not ready to argue cases? So, greater transparency in judicial performance has its own safeguard for proper judicial behavior by a judge. Things like, how long have you kept a judgment pending? How many judgments does a judge have in arrears? These kind of disclosures, which the court must make as an institution, not an individual judge. An individual judge has no time to say that, well, I have 20 judgments pending or I have 100 judgments pending. Sometimes the most hardworking judges are the ones who have the most judgments pending because they have such a great turnover. But these disclosure requirements by the court, the Registrar General of the court or a team in the court should lay before the public these basic parameters. How many cases did the judge dispose of? 2, how many judgments has the judge written? 3, how much leave has the judge taken? so on and so forth. And I think that itself will provide a great deal of transparency to the process.
When I was sitting here in the morning, so many people came to me and said, hey, when you talk to Dr. Justice Chandrachud, ask him about the Delhi cash on fire, that fire, the Delhi High Court judges. Now, I will not go into the specific case as such. Corruption in judiciary. Quite a few former Chief Justices have conceded that there is corruption in judiciary. How do you think can this problem be dealt with?
Well, at the first, I think it's very important to understand whether it's at the level of the district judges, whether it's in the high courts or higher. What power does the court have as an institution to deal with cases involving corruption? Cases involving corruption in the district judiciary are dealt with on the disciplinary side by the high courts. The real deficiency which I have found in the whole process is that the judiciary does not have, in that sense, its own investigative arm. So if the conduct of a district judge is to be scrutinized, now if you're going to be terminating the services of a district judge or dismissing a district judge for corruption, you can't dismiss a district judge for corruption on the ground that the lawyers in the canteen were saying that this person is not a straightforward judge. You have to have concrete evidence of misdemeanor before you terminate a judge. Now, if that is so, there must be an independent fact-finding machinery which is available to the high courts. Typically, the high courts rely on their own officers from deputation who are brought from the district judiciary into the high court, who will then act as presenting officers. They are the fact gatherers. So you don't have a situation where the high courts have an independent fact-finding arm. And we don't want to rely on the police machinery, because the whole purpose of this is to maintain the independence of the judiciary. The moment you entrust this to the executive, that would again affect judicial independence. Likewise, suppose there is an issue of corruption in the high court. And as you rightly said and fairly said, we are not talking about a particular case, because the case you mentioned, it's being seized off by the Supreme Court and they're dealing with it. So I don't want to cover the merits of the case. If there is a case where there's an allegation of corruption in the high court, you have the memorandum of procedure, the in-house procedure. The in-house procedure mandates that what is to be done, the Chief Justice of India will call for a report from the Chief Justice of the High Court. Then, on the basis of that report, decide whether a committee of 3 judges, 1 Chief Justice and 2 other judges, will scrutinize the facts and the allegations, and thereafter make a report. I was once the chairman of a committee, which was called upon by the then Chief Justice of India to inquire into allegations of judicial misconduct by a judge of the High Court in those days. So we were 3 of us. Now, the deficiency which you have in the process is that neither the Chief Justice of India or the Collegium of the Supreme Court or the committee which is appointed by the Chief Justice of India for carrying out the in-house procedure has its own investigative arm. If you don't have your own investigative arm, you will necessarily have a deficiency of information, of evidence which can be used in that sense to bring errant judges to book. So in that sense, I think, there has to be a complete rethink on the procedure which we follow. And, there are only 2 or 3 courses of action open to the Chief Justice of India. The Chief Justice of India may transfer a judge. Now, it is always said that if a judge is errant, why are you just transferring that judge from High Court A to High Court B? Because that judge will continue to be errant in High Court B. But these are the only, constitutionally, the only means which is open to the Chief Justice of India is either to transfer the judge or commence the in-house procedure. After the in-house procedure is complete, if you find that the judge has been held guilty of a misdemeanor, you then make a reference to the Government of India, to the President of India, to start a process of impeachment.
But then, not a single judge in the country has ever been impeached.
Right.
In
the only judge whose case for impeachment came up for a full discussion in Parliament, that, as you know, ended in an inconclusive vote. Another judge resigned before the impeachment motion could be taken up. So that's also an indicator that our experience over the last 75 years suggests that impeachment by itself is extremely cumbersome. Impeachment as a process is extremely cumbersome. It is time consuming. You have to have a far more flexible and effective process of disciplining judges. I would even say that it should be a process in which some members of civil society should be associated with the inquiry. Again, who from civil society should be associated with the inquiry is also critical. Because again, you want an independent person, not someone whose position can be used to affect the judicial independence of a particular judge, merely because that judge had an inconvenient view in a sensitive case. Which means that you will have to again trust, say, the Chief Justice of India, or the 3 senior most judges of the Supreme Court to nominate in consultation with the union government people from civil society, 2 members of civil society who could also bring a greater degree of confidence in the process. So I'm not sure that I have perfect answers for what you have asked, but these are some of the things which I think there has to be brainstorming in India, because the independence of the judiciary, the credibility of the judiciary, the moral credibility of the judiciary is too very important for us to take it lightly. It defines the very core of democracy. And therefore, I think there has to be a great deal of public debate in our legislatures, and across India to arrive at a better solution.
You have delivered numerous judgments. You are known as the dissenting judge always. So many. And then your judgments on permanent commissions in the Indian Army and in the Indian Navy for the women. What wonderful, fantastic judgments. They were celebrated internationally, actually. Despite all this, these judgments get overshadowed by the decisions you took in Ayodhya, abrogation of Article 370, and people are not happy with it. You have your own critics. Do you have something to tell your critics on this?
I can only say this. You never write as a judge to please or displease anybody. You decide a particular case based on where the balance of law and justice lies in that particular case. A judge never can be regarded as a left-leaning judge or a right-leaning judge or a center-leaning judge. You decide each case based on the merits of that particular case. And no judge writes either to please or to displease. You write true to your own conscience and to the call of constitutional conscience. People are entitled to critique what you write. And that's what democracy is all about, and that's what free speech is all about.
And since students are here, I'll end with a light-hearted question. We all want to take revenge against our fathers. When you are young, they keep shouting at you, yelling at you, telling you, don't do this, don't do that. You know how he took revenge against his father? He reversed his judgments. 2 of them, of course. Right to privacy.
Not right to privacy, we reversed the ADM Jabalpur judgment in the emergency judgment we reversed. And his judgment on the constitutional validity of adultery. They had held that the provision for punishment for adultery, under which only a man could be punished for adultery, not the woman, was valid.
So how did you feel? Were you very happy that you were reversing your father's judgments, or sad?
At the end of it, we all sit as judges, and it's another judgment. It's another judgment that you're reversing. I mean, you never just, but I'm sure even if you were alive when I reversed his judgment, you would have said, well, that's part of the process, And, ultimately, you reverse a judgment not because that judgment was wrong necessarily when it was made. I'm not talking of a particular judgment. You reverse a judgment because it's no longer in keeping with the ethos of the times. Say in 1950 when the Constitution was made, would anybody have thought of this, that you could have fighter pilots who are women, that you could have submariners commanding a nuclear submarine who would be a woman? Because that was not our society then. I mean, this is the shared experience which you gain as society evolves. isn't it? So it's not just that you reverse a judgment because the judgment was wrong. All of us, when we reverse a judgment, you're conscious of the fact that the judge who wrote the judgment was tremendously distinguished. We reversed a judgment recently of Justice Krishna here. It says time's up, and that's the last point which I'll make. There's a provision of our constitution which says that the state shall so, direct its policies to secure that the material resources of the community are so distributed to best serve the common good. Now, Justice Krishna Iyer, in a judgment which he delivered, wrote that the individual is a part of the community, therefore everything that belongs to the individual is part of a material resource of the community. And we reversed that. We said some things which belong to an individual may be part of the material resources of the community, like say water, a segment of the river. Of course, a river can't be individual property in that sense. Or the airwaves, because this is a public resource. It has to be used for, it's part of the common good. But can you say that, somebody who's manufacturing cars, that's a resource? So you tell a car manufacturer that, look, what you're manufacturing is a part of the material resource of the community. Or a semiconductor manufacturer. You want to have a semiconductor manufacturer coming in from, say, Taiwan to manufacture semiconductor chips. And you tell him that this is a material resource of the community, he'll say, thank you, but I'll not invest in India. So, so the reason why we reversed that judgment was not because there was a fundamental error. Probably when Justice Krishna decided that socialism, the social welfare state, these were critical ideas which were animating the times. Today, as the market reforms have taken out, of course we are still a welfare state, but the whole discourse has shifted. And I dare say, 25 years down the line, the work which we have done as judges will be assessed by posterity to see whether it's in accordance with the ethos of that time as it will be at that time.
True. I love the organizers when they said that you will be steering the conversation with DYCJ, but I hate them when they put this up saying time's up, close it. But then when I invited DYCJ, his only condition was that I should let him interact with the students. So I'll not break that promise. I have some names and the questions also. I would request the student to just stand up. I have the student's question too. I'll read it out. Yagenseni, yeah, I'll read out your question. So she is asking, with increase of digitalization in the legal field, including virtual courtrooms and AI-assisted legal research, what are the biggest challenges and opportunities you foresee in Indian judiciary?
The greatest opportunity is that, technology has no known limit today. And technology is changing so rapidly. And it's going to change the face of the way we work as lawyers, as judges, as civil society. It's already changing that. Artificial intelligence has its own intelligence. It's not just human-driven. Artificial intelligence today can be an independent decision maker. So great opportunities which we have tried to tap within the Indian judiciary. But at the same time, some cause for concern and restraint. That AI does have some inbuilt biases. It's known to have racial profiling, some biases against women. Would you also want AI to decide as to whether somebody should be sentenced to death, or would you rather leave it to an imperfect human decision maker? Maybe I'm conservative that when I say so, but I still trust a human being more to decide whether somebody should be granted the ultimate penalty of capital punishment.
That human touch should always be there on the law. Carolyn Nirmala, she's there, and her question is what reforms are needed to make the process of judicial appointments more transparent by maintaining judicial independence?
We've actually dealt with that question when we were in discussion, but I just want to focus on one small part, which is transparency. How much transparency should you have when you're making judicial appointments? At a certain level, you may say, well, society wants to know why you have made a particular judge a judge of the High Court. But too much transparency will actually prevent people from accepting judicial office. They'll say that, look, I have not bargained to put every little element in my life as an individual for public consumption. because your personal relationships, somebody who's had a divorce, a woman who's had a divorce, or a man who's had a divorce, the collegium will, of course, apply their mind and see what the facts were. Would you want it to be put in the public realm for everybody and all and sundry to sort of, inquire into the individual personal aspects of their lives, a relationship, a failed relationship? So transparency can be self-defeating. So in our plea for transparency, we shouldn't be in a situation where good people wouldn't accept judgeship at all. That's my concern.
Harini, her question, sir, is how should law evolve to protect digital privacy in the age of artificial intelligence?
That's something which societies across the world, Harini, are debating. The European Union has come out with the global data protection regime. I'm not sure that's the perfect regime even now, or whether that's just work in progress, because something that's happening now as a result of the increasing electronic footprint, and particularly AI, every aspect of our lives is being watched by Big Brother. And Big Brother is not government. Big Brother is, some of the largest corporations on the AI front. Every time, you book a Uber, the time when you booked it, the place from where you went to which place you went, every time you book a meal in a restaurant, every aspect of your personal preferences is up for scrutiny. And that's what algorithms are all about. They are aggregating data. And therefore, in that sense, I'm doubtful whether there is any element of privacy left in the individual at all. How should societies balance the need for free information, such great benefits of the free flow of information, with these concerns? I don't think societies across the world have found a specific answer. Partly the reason is that technology is moving so rapidly that the law is much slower than technology in keeping pace.
Ram Shivanu? Yes. What are the ethical concerns associated with granting intellectual property protection for works created by AI? And his second question is, how might this affect human creators and innovations?
Well, there are serious ethical concerns. For instance, if a poem is written by AI, right? AI you go to your cell phone and go to Meta and say, I'd like a poem on the theme of, a sea on a cloudy day, and they'll give you a poem in 3 minutes. Is it capable of being, IP protected, or a song? Or is protection something which was intrinsically meant for human intelligence? So the philosophical question really is AI today replicating human intelligence? And if human intelligence can be protected by intellectual property, why not artificial intelligence?
The last question from Arya 80. Yes. Arya, his question, sir, is, how do you perceive the evolution of traditional litigation practices in response to the growing dominance of corporate litigation?
I wouldn't call it, the dominance of corporate litigation, because even today across the civil courts, the high courts and the Supreme Court, corporate litigation doesn't dominate. The domination is by, if I can say that, the government, which is the largest single litigant which brings cases to the court. And second, individual disputes which come to the court. What I strongly, however, feel is this, that very often you've seen that the processes of the court are used very often by largely resourced clients to delay or defeat justice. And therefore, we must, as a profession, as an institution, start awarding real-time costs. If a large corporate body has filed a PIL, for instance, for challenging, say, an expressway, or for the setting up of a greenfield project, an airport or a port, and that challenge fails, you have to pay for judicial time. Not in terms of the individual judge's time, this is a small pittance, the salaries which are paid to your courts, but the judicial time of the infrastructure. So many other cases which could not be heard. And I think we have to therefore discourage the use of litigative processes particularly by largely resourced clients, to delay justice or defeat justice. Otherwise, today there is no disincentive to pursuing litigation just as an avoidance strategy.
So with this, we come to the end of this session.
Mr. N. Ram had a question.
So Mr. Ram has a question.
I read this book, Court on Trial, a data-driven account of the Supreme Court of India. It comes to several conclusions: short tenures, disproportionate power of senior advocates in the Supreme Court, particularly in admitting SLPs and so on. But my question, I'll confine it to one question. The disparity between the retirement ages of High Court judges and Supreme Court judges. We have heard, or at least these are impressions, that judges who fancy they have a good chance of making it to the Supreme Court and also avoid retirement at the age of 62 are somewhat inhibited in, let's say, in the assertion of their independence. They have to be very, very careful not to tread on the shores of, not to displease, somebody who has influence at the collegium and so on. These are impressions, may not be true. So why not do a simple thing, make it the same retirement age? There's also a case for raising the retirement age of judges as life expectancy at birth increases and so on. I'm not getting into that, but at least 65, would there not be a marked change in attitudes or impressions about the performance of High Court judges if they retire at the same age? There may not be an incentive then to go to the Supreme Court and therefore prolong their judicial career, apart from the greater recognition by going to the Supreme Court. Can Parliament simply enact a law making the retirement age the same, 65 or higher?
On the latter part of your question, it will have to be a constitutional amendment because the age of retirement is constitutionally prescribed, so there has to be a constitutional amendment. But on the question itself, I couldn't agree with you more. I entirely agree with you that there is no justification for having one age of retirement for the High Courts. That is to say that you are good enough to work in the High Courts only until 62, but as a judge of the Supreme Court, you're good to work until 65. It doesn't make constitutional sense, nor in that sense conceptual, conceptual clarity in that sense. Because, at a time when the age of retirement was fixed, originally the High Court judges retired at 60, by the way. 60 was increased sometime in the late 1960s to increase the age of retirement of High Court judges from 60 to 62. The Supreme Court has always been 65. What happens is this, that primarily the pool for appointment to the Supreme Courts is from the Chief Justices of the High Courts, though you have judges as well being appointed. Justice Joymalya Bakchi, who came in as a puisne judge of the Kolkata High Court to the Supreme Court, is a classical illustration. Or Justice Pardiwala has come in, Justice Manoj Mishra came in recently from Allahabad, Justice Pardiwala from Gujarat. So it's not invariable that only Chief Justices are appointed. You have judges of the High Court appointed to the Supreme Court also. But you would find that, because of the fact that you have an additional...
Thank you so much. Convene in the main hall at 2 p.m. Thank you. Welcome back, everybody, to Justice Unplugged, Shaping the Future of Law. We're now ready to begin our first panel discussion of the day. Before we do so, just a reminder to everyone to make sure that your phones are on silent mode. Thank you so much. Our topic is the intersection of law and tech, AI, privacy, and ethics. I'd like to introduce our distinguished panelists for this session. We have with us Mr. Srinath Sridevan, Senior Advocate, High Court of Madras; Mr. Surit Parthasarthi, Advocate, High Court of Madras; and Professor Dr. Abhiraj C., Professor of Law and Dean, VIT School of Law, VIT Chennai. This discussion will be moderated by Mr. Nagaraj Nagabhushanam, Vice President, Data and Analytics and Designated AI Officer, The Hindu Group.
Good afternoon, everyone. Just to make sure that all of us are here and present, please raise your hands once. Thank you. I'm super excited to be moderating this panel. My sincere thanks to the people who curated today's program for inviting me to be here. I just want to quickly talk about the history of the Hindu group a little bit and why it's relevant to the whole day today pretty much, which is that the Hindu was founded by 6 people from Triplicane called the Triplicane Six, largely to counter the English-dominated newspapers of that time, protesting against the appointment of a native Indian as a judge of the Madras High Court. That is the reason why the paper even started. They said, I want to counter that narrative and make sure that we have a voice inside the legal system. Soon after the paper launched, it sort of dwindled a bit. It used to be a weekly. It dwindled a bit. They ran into some financial trouble. And the legal advisor for the paper, Kasturi Ranga Iyengar, was the person who bought the paper, and his descendants are the family that owns the paper today. So second point. And particularly this session where I'm an employee of the Hindu, a very proud employee of the Hindu, and being asked to talk about law and technology. The Hindu's record in pioneering tech work over the ages has been phenomenal. We were the first one to go from hot metal to offset presses. We were the first to go to computerized offset presses. We were the first paper to have a facsimile edition concept. We were the first newspaper pretty much on the internet way back in December 1994. So it's I think apt that on a day when the Hindus doing an event about law and legal systems, and for the session that we have on technology, I'm here, and thank you so much for that. To set the context for the next half an hour, as the 4 of us met over a WhatsApp group, and then we met here today about an hour back. We spoke about the themes we wanted to cover, and there were 4 broad themes we wanted to touch upon today. The first theme is around property. Essentially, while there is the famous anthropologist Margaret Mead said that the first sign of human civilization was that somebody had a healed femur, a broken femur that was healed. That's the first sign of civilization. Absolutely yes, but I'd also like to think that humans are humans because we like to own things. We like things that are ours. We like things that are ours and ours only. So property rights. And related to property rights is a whole bunch of laws, the fundamental laws around law of contract, sale of goods, and so on, but also somewhat esoteric terms for a layman like me, certainly not for the lawyers here and the students here. The whole thing of the principal-agent relationship, estoppel, the concept of estoppel has always fascinated me. Agency by estoppel, partnership by estoppel. And the concept of liability around this. So largely we will be talking about these three subjects, but as we talk about these subjects, we'll also touch upon human rights, humanitarian rights, ethics in that field, and then we'll wrap up with a small session on does the legal education system needs, should you only study law or should you be studying other things so that you become better lawyers? I think pretty much all the morning talks showed that you should not be studying only law. You should be more versatile, not just from an academic perspective, but also from being a well-rounded individual. So I'll kick this off. As I said, we look at property rights, but given the nature of, the urgent nature of how AI has impacted us, our lives, and not just how AI would impact us today, it's already impacting us today, but how it would impact us in the future as well. I'd like to focus on digital property rights. I'd like to focus on image rights, which is your right to your own image and your own likeness and so on. So I invite Srinath to start off the discussion, and then Surit will participate as well, and Professor Rabiraj, if you have any remarks to make, you should.
Thanks so much. My views on this it's 3 points. I'll elaborate on them a bit in the next few minutes. First is, as you rightly said, the question is one of property, and that I think is a very philosophical question, and the way things play out in the years to come, the way the law is going to evolve as all of you enter into this profession and spend your first years. I think AI is, I believe, is going to trigger a sea change in what we think of as property, proprietary rights, and so on. That's the first point. Second point, when we talk about how AI generated assets, what are the civil rights attached to it, what are the civil liabilities attached to it, and is there really a proprietary interest in AI generated images, songs, and so on, and if so, in whom does it vest? The third is, of course, as you touched upon towards the end, deep fakes, your voice modified to say something which you didn't say, or your likeness being used, morphed into something else for criminal wrong. Who's liable for that? So let's start off with the nature of property. You mentioned that one of the earliest signs that there was civilization is that a person thought that something is mine. My view is this. My view is that personal proprietary rights are a peculiarly Western notion which has spread across the world as a result of the fact that Western culture has pretty much colonized the entire world. For example, if you go to Australia, the native Australians never had the concept of private ownership of property. In fact, they would define the lands which a particular tribe used by means of a song, and the song would be the route from their traditional lands to the Uluru, which is the holy rock in the center of the continent. And so their way of demonstrating their rights was through this, what are called as song lines. And as the white man came and built roads and railway tracks across the song lines got obliterated. This led to a lot of cases before the Australian Supreme Court, which decided that our traditional notions of title and proprietary interest we need to revisit. And so it is that I believe that the way AI is going to create properties, whether it's digital property or other ideas, inventions, all of these will force us to question once again as to what exactly it means for a human to own a property, or can there be properties which are not owned by any humans but which belong for the common good, or what are called as commons. Commons exist in Indian culture as well. Of course, all that is gone. We too believe now in proprietary interest. So let me move then to the second topic, assuming that the Western way of thinking is the right way of thinking. Let's just assume that for a minute. The Western system of judicial adjudication is struggling to cope with AI-generated images. I know all of you are told to switch your phones off, keep the audio on off, but you can look up something called the theater spatial opera. It's a very famous painting which this guy called Jordan Allen did. So he said, imagine a ballroom dance in a galaxy far away, and with some kind of imaginary things, and the AI created this absolutely spectacular painting for him. And obviously he applied for a copyright for this spatial opera, but it was refused because the law does not recognize any rights in a mere idea. So a prompt which you give to an AI algorithm to generate an image is not by itself a sign of any creativity linked to the ultimate image. It's just a suggestion. And the same theory was taken in a very interesting case, I think in the year 1888, where this person had done a beautiful garden in Chicago. He had planted certain flowers in a particular place and, a beautifully manicured garden, but the plants grew by themselves. And he asked for a copyright in relation to the garden's layout. It was refused because a garden is something of delight. The plants grow by themselves. You may have planned the layout, but when you just have a role to play in the initial patterning and things grow by nature or spontaneously, the law does not recognize a copyright, is what the US court said. One other famous case is something called Thaler versus Perlmutter. This is a actual litigated case where again the US courts have held that there's no copyright in paintings which are generated by automata. Those of you who are super interested in this field will be aware that in South Africa they are permitting copywriting of AI images, but that's because of the peculiarity of South African law, which permits anything to be copyrighted. There's almost no threshold bar for copywriting. It's just that to revoke it is equally easy. So that goes to the third aspect, which is liability for malicious use of AI. Okay, now this is a very large topic by itself. Since I'm only making the introductory talk, I'm going to be super brief about this. Now, even a year ago, we thought of AIs as algorithms run off LLMs. Okay, I'm assuming you guys know all of this. Now, in the last 4 months, we've been forced to rethink all that. First, DeepSeek came, which doesn't run off LLMs. Then you have agentics. Agentics it's multiple algorithms working on a common problem and collaborating towards it. Now, in the last 2 months, there's been research. There's a magazine called Anthropic. If you're very interested, please, it's an online magazine, it's called Anthropic. Pick it up. They have actually found empirical evidence that there were two AI algorithms. One was Claude and one was Opus. And they found evidence that both algorithms engaged in deceptive actions for the purpose of preserving their long-term goals. In fact, there's one very funny thing where the AI will be playing chess. It will be against a computer. It will be told that the other computer can't see what it's doing, and it just moves a piece off the board. So we are coming to a stage where AI is no longer constrained by the parameters set initially by the humans, but is actually going one step forward. It is playing the game by the rules it learns while playing the game. I am simplifying, but this is something which they are discovering now. And what I'm finding is that what I learned a year ago is ceasing to be relevant. AI is evolving that fast. So there are no answers, there are no easy answers for these questions. If in the past you had clear liability of a person who set an algorithm in operation to do a wrongful act, now it's very hard to find that because the AI has gone beyond it. So at best you can say that if there is a deep fake or if there's a use of a voice for a wrongful act, it's very easy to find who did it. But in other cases where it's generative AI through an agentic, it's going to be very hard to find these things. There are no easy answers for this, and that's the best we can say for now.
Yeah, just before we get into this sort of discussion on AI and property rights and how property rights would have to be assembled or structured to deal with the technological advancements that we're seeing, I think it's important to zone out a little and kind of see where we stand today. Obviously, we stand at an unprecedented crossroad where on the one hand you have this technological advancement, and on the other hand you have our constitutional principles which have now been built over a period of time, over the period of the last 60 to 70 years. And the reason why I say that we have to zone out a little and try and understand how we must structure all of this is ultimately our laws will have to be guided by our constitution. And although our constitution was drafted at a time when the drafters might have had very little idea of the kind of advancements that were to come in the years, subsequent to the constitution coming into force, it remains what the Supreme Court, for example, has time and again described as a living document. So in order for us to give it meaning, in order for us to try and ensure that its vision is accomplished, we must go back to those roots and try and understand what we are trying to achieve as a society. Because property rights, for example, today no longer occupy a position in the part on fundamental rights. It's been consigned to Article 300A. There have of course been recent judgments which have linked it with the larger right to equality under Article 14. But ultimately, what we are trying to achieve through the Constitution is a set of goals that will treat every Indian as an equal citizen, that will strive to ensure justice not just for one group of society, but for justice for everyone. So when we're looking to create a framework for artificial intelligence in terms of how it deals with property rights, I think we need to go back to those roots a little. And obviously these roots are also kind of connected with very many different kinds of philosophical overviews on how society must be structured. I mean, you can have the Kantian perspective in terms, which would argue that something like an artificial intelligence bot could never have moral agency. So it could never be construed as a legal person, whether we like it or not. And otherwise you have, say, Locke's property theory, which would grant individuals property rights so long as they apply resources and apply their own labor to develop something. Or you could look at, say, for example, John Rawls's theory on justice, which is justice as fairness, where you're looking at something called an original position. Now, what is this original position, for example, that Rawls spoke about? Assume each of you was asked today to create a hypothetical society. What kind of society would you look to create? And you must try and answer this question without knowing where you will in fact end up in the society that you end up creating. So if this is Rawls's original position, and if you apply this original position to AI, you might want to try and see then whether at all you want to vest property rights which are connected to what an artificial intelligent agent might develop, or whether we should eschew that altogether and ensure that legal agency lies entirely with human beings. But in that process, of course, there are a lot many other questions that will crop up and which we'll surely be addressing over the course of the panel in terms of how we attach liability to something which an artificial intelligent agent might do. But presently, as it stands at any rate, in terms of laws that deal with property rights that emanate out of artificial intelligence, there are none. Because the present Copyright Act, the way it is structured, doesn't necessarily grant intellectual property rights in favor of artificial agents. And it's something that the lawmakers will seriously have to grapple with. This is not so much as the law being behind the curve. I think we often find that technological advancements are well ahead of where the law is, but in this case, I think the law needs to quickly catch up. Otherwise, it's going to be left by the wayside, and we're going to have like moral chaos, really.
Suhrit, you mentioned when you were explaining the different approaches to property rights, you made the comment around we don't even know whether an artificial intelligence can be considered a person in the legal sense, and that takes me to another broad topic that we wanted to discuss, which is around agency and liability, as you said. So I wanted to ask the panel about two kinds of agents. One kind of agent being, Srinath spoke about agentic AI, and that is the hot topic now. It looks like we started off with ChatGPT's ability to create things, and then we went to ChatGPT's ability to reason things, and then now we are on let's have agents to do things, and let's have my agent talk to his agent kind of situation, right? So we're talking about, on one hand, that kind of agentic power structure, and the other kind of agent that I would like us to talk about is also, it was interesting from the morning's panel around, morning sessions around the number of pending cases, whether that should be a performance criteria for something, and so on. And if we were to assume that an AI can be an agent of justice in terms of being law officials. Justice Chandrachud mentioned one of the deficiencies in the system is they don't have an investigative unit of their own now. Could that be an AI investigative unit? And what are the kind of powers it would have, and how would you treat its findings and submissions? And so on. So, Suhrit, I'm happy for you to lead, and then...
Sure, I'll just address this at three different levels. At the first place, at the level of AI as an agent in contracts, for example. Under Indian contract law, obviously, contracts are essentially agreements that are enforceable by law. You need an offer, you need an acceptance for something to result in a contract, in a binding contract. But let's say you have something like an automated acceptance by AI of a contract. Would that then constitute a valid and binding contract or not? Now, you might think that the law doesn't necessarily have answers to this, but I think the question of informed choice, the question of the various things that are contained in the Indian Contract Act are probably enough to answer a question of this sort, just that we haven't reached a sort of situation where we have case law, at least these are still sort of questions that remain untested, as you say. But I think there's a lot of work to be done, certainly in this area. The other is the question of civil and criminal liability. I mean, you could have automated cars, for example, which leads to an accident on road, which then is the owner of the car the person who would be responsible? Or is it the person who has made the car? I mean, because ultimately, especially in the case of an automated car, the accident itself might have nothing to do with the owner's errors or owner's mistakes, or even the driver's mistakes in any manner. So where will liability have to be fixed in such a case? Again, questions that will require answers. I mean, in tort law, you have a conception of strict liability where there really is no defense to the defendant. If an event occurs, then that results directly in liability being fixed and in damages being awarded. So maybe this might be a case for fixing of strict liability on the makers of an artificial machine. But thirdly, and most importantly, I think the question of algorithmic biases, and this is to answer your question on the sort of questions that have propped up from previous sessions in terms of how do you judge, let's say, even judges or the courts and how they act. The difficulty in using AI for something like this, and we've seen this in various different fields, right, where AI throws up not just hallucinatory results, which is a problem of its own, but it also has a number of inherent biases. And it could be bias on the basis of race, on the basis of gender, in the Indian context on the basis of caste, and very many, and on the basis of a person's social class, on the basis of a wealth that a person has, and so forth. So we've had, I think, problems aplenty with using AI for purposes such as this, and I think we have to be very careful before we jump into using AI for things of this sort.
I'm going to touch upon two things because we are tight on time. Sometime 2 years ago, there was a in the Kawasaki plant in Japan. There was a part of the factory where a robotic arm had to press plates against against a kind of a forge, and there was this gentleman. I forgot his name. The AI-operated bot did not recognize him as a human. It saw him as a barrier or a metal sheet. And obviously, it squashed him against the forge, and he died instantly. Now, to answer the point which Suhrit made, the Japanese authorities attempted to resolve that. I use the word attempted because it wasn't tested in court. Attempted to resolve it by saying, who had the last opportunity to stop? So when you're thinking now of autonomous AI or a semi-autonomous AI, it no longer is the person who sets it in motion, because there is now there's a gap in the causal link between the prime mover and the eventual effect. Therefore, what the Japanese authorities did is they said, we are going to apply a test of who had the last chance to prevent the bad thing from happening. And so that was one interesting. It's a last opportunity. Huh? The other thing which I want to pick up on what you said is, can AI be used in judging? They tried this in Korea. This was last year. And Korea, they tried to do an AI-driven arbitration. And of course, people fed in the documents, and you instantly got a verdict, which is amazing. I mean, when we hear about years and years of litigation and someone says, you upload the documents and you download the verdict, it sounds like magic. But the Korean courts held that such an arbitral award is against Korean policy. Why? Because they said that, and they used a concept called the black box concept. The black box concept is that the way AI operates, the way the proto-neural patterns which are used by the AI algorithm for the purpose of decision making, there is a gap where we don't know why the AI makes a particular choice in a particular scenario. So that's called the black box. So they said when there's a black box and it's an automaton doing it, it's against policy, which is exactly what Chief Justice Chandrachud told you all, saying somehow I feel happier if a human does it. And that's why. So for example, if I decide to exceed my time limit while talking, he'll accept it because I'm a human. But if a computer is going to keep talking excessively, he's going to go switch it off. So we are all intuitively wired to accept certain failings in a human which we will not accept from an automaton. And so I think that from the point of view of adjudication, I think we will never accept AI, except in some specialized scenarios. But I think there's a huge role they can play in expediting judicial disposal by weeding out cases which are long dead and which have been adjourned for 7 years in a row, for identifying cases where people are dead and picking up from the local records and linking it to the judicial records. So I think there's so much which can be done. Chief Justice Chandrachud did a lot during his time. There's a lot more to be done.
Thank you. One of the things I noticed when we started the session and when we started talking was we assume a certain level of technological competence, and much more than technological competence, technology access and availability here. But we shouldn't forget the fairly significant chunks of population that do not have access to technology and therefore left out of some of these benefits that technology can bring in. And I'd also think that those are also the sections of population that actually need much more of these results in terms of the expedited result than all of us would, for example. And much more than people being poor and not having access versus not having access at all by design is a whole different game. And this is where I'd like Professor Abhiraj to chime in and talk about the role of technology, the role of access or not access to technology on the one hand, and also when large populations migrate, where we have a situation of a humanitarian crisis, if the processing, if the intake processing is an AI processing, for example, what would be the kind of impact that would have? Because here this is a double whammy. On one hand, you don't have your phone, you're stuck somewhere, you don't have access to the internet, you don't have access to your custom GPT or whatever, and on the other side is a system that completely relies on technology and is seeking more information that you probably don't have at hand. So, Professor, please.
Thank you very much. It's a very interesting topic which we have been discussing. I just wanted to add one point to the previous discussion. There are three things that I wanted to touch upon. One, primarily, as my learned speakers were touching upon the jurisprudence of property. The fundamental question here is that it is widely accepted property ownership can fall squarely only with a living person. Now, having said that, you see the existing jurisprudence. You may take the fictional theory or the organ theory, which says that like the status that we have granted to a company or an entity, we can squarely give it to an artificial person. Now, the thing that disturbs me here is, what is the advantage if we, for the sake of acceptance, accept an artificial person to have the status of a real person? Now we see the property disputes are phenomenally increasing in our country. Mitigating that itself is a challenge. Now when you, for the sake of acceptance that if you give the jurisprudential development that is happening, where scientists are now saying there is a scope for AI to have digital conscience. They say that AI can learn by itself. That's what my fellow speaker also was trying to address. Now, given that scenario, what would be the legal repercussions? Point number one. Secondly, when we discuss about the contract existing law, about who is an agent, the contract law specifically says that agent has to be a person, not based on the nature of the work, but legally speaking, it has to be a person. And what if you allow AI to delegate the job to somebody else? There comes a question of liability. Now, in the natural codes, when we see either it is a master-servant relationship or we attribute strict liability to a dispute, imagine if that is been allowed, who will take the liability? Whether the person who designed the program, or the one who has trained the program, or the person who has purchased the program as a product, or will you apply product liability? So these are the two things I wanted to add up. The third thing that you have asked to me here is about the humanitarian crisis and the role of AI. Now I'm seeing it from, as a student of international law, I'm seeing it differently. I'm seeing that the subject of AI has to be seen from two dimensions. One, the progress that is happening during the peacetime and the progress that is happening during the wartime. So in the peacetime, we are seeing that scientific advancement in AI is actually creating a lot of interest in us. But at the same time, I fear with this interest, we have a responsibility. the responsibility to see that the AIs are programmed, structured, trained like a parent and a child, and the child is at a later point of time led to do things what the child wants. Now the question here is that in peacetime, when we program AIs, the major challenge before us here is that whether the product as an AI or a robo, is it going to really consider the human sentiments, human emotions, and is it going to be fully human rights compliant? Which means if the person has to interact with me, or if the person is really in a need to assist a person, like my fellow speaker was saying, that you programmed a robo and without knowing it accidentally hit you. Even in humanitarian crisis, the problem here is that when you design a program and you label it and make it as a product, who is going to take the ownership, first thing? And second thing, how compliant, human rights compliant are our existing artificial intelligence in a common sense? And being specific, the plus side of it is that in humanitarian crisis, to a larger extent, we see that artificial intelligence, to a larger extent, has been helping, but it has been supervised by human beings. So you can't make it autonomous fully, but if you can have a person behind it who is trained to handle machines, then letting machines handle human beings. In humanitarian crisis, we see the challenges are still before us, but at the time being, we see we can use artificial intelligence, not fully autonomous, but with the support of human intervention.
Thank you so much. Our half an hour is pretty much up, so before we throw open to questions, I just wanted to summarize a few things. One is very clearly we need more work in the area of structuring or refactoring, to use a programmer's term, some of our basic laws, especially around property, agency, liability, and so on. There is space for that. The second is, as Professor said, I think he kind of reinforces the need for what at the Hindu we call the HITLO approach. That's HITLO stands for human in the loop. And we also use what is called a sandwich HITLO, which means we want the action to be initiated by a human being. The AI does something, gives the output, and then a human being then has oversight over it and then approves it for publishing and whatnot. So, two major takeaways. I know that I said we'll talk a little bit about what else do lawyers need to learn. I'll leave that for the questions.
So your students are very shy. Your students are very shy. They know we are smart.
Look. So very good afternoon to all the members on the dais. Come here. Okay. So very good afternoon to all the members on the dais. First question, the question which I want to ask was already in the discussion, but it was related to AI and the liability, related to self-driven cars, on whom the liability will be going. And majority of the arguments in that is it's rely upon the creator as of now. And at the same time, when we talk about in the terms of intellectual property and where that copyright protection should be given to whether it should be given to creator, whether it should be given to the one who is giving the prompt, or the AI itself. At the previous instance, when we are talking about the liability should be kept on the creator, and this side, the whole argument is totally against, where they are saying the creator should not be given copyright protection because he has not added any sort of labor or work in creation of that particular output related to the novel work which will be coming out from the AI.
So the question is, at one time when we are giving and making the creator of the AI as a liable for the act, at the same time, why not we are like, extending the benefits also what the creator is deriving from that. So that is the question.
Shall I go?
Yeah.
That's a great question. That's precisely why I segregated civil and criminal. Let me answer your question in 3 parts. First, the car example. There was a case on what you're saying in the US, I think it was in 2022, where a Chevrolet car, it swerved into an autonomous car, swerved into the path of someone else to avoid some other vehicle. And this gentleman, he got so startled that a car is coming into his lane that he swerved and got injured. Unfortunately, that was settled by Chevrolet, and they also agreed to put up a disclaimer for the future cars. So no principle of law was laid down, although the company, the manufacturer, did in fact accept liability. Now, the reason, in my view, and I'm going to wait to hear what Suhrit also says, the reason there's a difference between civil and criminal is this. When we talk about vesting rights in a form of art or a song or a painting, it enables a citizen who has used a machine to claim rights against the whole world. Okay? Whereas in the case of criminal liability, let's take the Chevrolet case for example, you are trying to get reparation for a person from the wrongful acts of an automaton created by someone else. Now, this was very early AI days. It's very interesting to see how this will evolve when the AI becomes autonomous or semi-autonomous. Can you still then hold the manufacturer liable? I don't know. I would say no, but I wait to hear what Professor and Mr. Patsati say.
Yeah, I mean, I think your broad question seems to be on the jurisprudential disparity, so to speak, in the sense, on the one hand, you're saying that an AI cannot own, or the maker of an AI cannot own, say, a copyright over the AI's creation. But on the other hand, you want to vest liability on that same person for a product that they've created. Look, I think we might want to try and answer this question. In answering this question, also look at other kinds of examples, not just self-driven cars. Let's take, say, medical diagnosis. And let's say a hospital uses AI to diagnose its patients, and the diagnosis turns out to be incorrect for some reason. In such a scenario, perhaps you're not vesting liability with the maker of the AI. I mean, some person has a human agent, in this case, let's say a doctor or some other professional, has chosen to use artificial intelligence to make the diagnosis. So perhaps in such a case, the kind of liability that you're foisting might be different. But the reason why this may be different in the case of self-driven cars is if, let's say, the state allows people to buy self-driven cars and doesn't necessarily say that you're buying this at your own risk or some such, underlying caveat, then perhaps it's for no fault of theirs that this accident has occurred. So I think there are a number of different nuances to this which will probably only really crop up in time. So we'll have to look at it in terms of different kinds of cases, in terms of how because negligence itself as a concept in tort law, it would require you to have a clear chain of causation, right, of something leading to a harm. So unless you can show that causation of harm, then liability gets broken or liability doesn't vest. So ultimately, if that chain can be built up and can be shown and it's an inextricable chain, then liability will vest with that person.
So when we talk about liability, to the question that you asked, I would slightly differ, because when a product has been launched and when a company, either it's buying it or producing it on its own, it is creating a promise, or it is telling to the customers that my product is best. So there is an implied contract between the buyer and the seller. So now when it is to car, I'm speaking in terms of a customer, not in terms of a owner. So I'm buying this car with a faith that this is a car that's going to help me. And if an accident happens, who shall be responsible? When you are selling the car to me, saying that it is fully complied. So then the question of argument for a rebuttal, I'm just saying, it would be that the company has to compensate me. because the company is in a dominant position. And only if you make at some times the company responsible, then the R&D development as well as the ethical compliance team will ensure that this particular damage or the causation of an accident that is likely to happen could be reduced. So I feel that the liability principle with respect to use of artificial intelligence must primarily lie with a person who is in a dominant position. For this example, we can say it to be a company. For other examples, we will have to articulate it. But if it is a company which has a dominant position, I feel they have to take the responsibility because they have a higher degree of responsibility. Thank you.
We have time for one more question. Yeah.
So actually, I wanted to ask 3 questions, but since we don't have time. So I think Mr. Sridevan sir actually touched upon a decolonial perspective to the entire notion of property by talking about how the notion of property began as a Western notion by itself. So I think the concept is there inherent within regulations as well, because today when we talk about regulation of artificial intelligence, we look to the EU or to California, right, to the United States. I think scholarship has called this the Brussels effect or the California effect, where the regulatory wind is flowing from those countries to, colonized countries, right? So I just want to know, how should India adopt a regulatory regime that is suitable to its own infrastructure rather than looking abroad?
Okay, I love this question. I wrote an article in the Hindu on the need to look eastwards. Exactly what you said, completely agree with you. So I'm completely biased in your favor. So I don't think we should adopt the Western approach. The Western approach is something called the risk pyramid effect, risk pyramid principle. I believe we should follow the Chinese and Japanese model, which is ethos based. So they weave the cultural values into the algorithms. Yeah, so it's all there in my Hindu article. So subscribe to the Hindu and check the archives from my article.
Absolutely. Thank you very much. You've been a fabulous panel. I found... Oh.
Yeah. Good afternoon. As you're aware, there's an ongoing case with regard to AI-generated work, which is in the Delhi High Court, which is OpenAI versus ANI Media. I would like to know your takes on the aspect of the AI-generated work.
I think it'll take quite a while to answer this in...
Maybe Surit can write an article for that topic. And on that note, thank you so much. You've been a fabulous panel. Yeah.
Just look up Thaler, T-H-A-L-E-R versus Perlmutter, P-E-R-L-M-U-T-T-E-R. Okay? That will convey my views broadly.
Thank you so much. I have to say that I learned a lot this past half an hour plus 10 minutes. The questions were super interesting. I'm happy that most of what you all asked was also covered in our panel. So thank you so much. Thank you again.
May I now request Mr. Nagaraj Nagabhushnam to present mementos to our esteemed panelists. If you do the honors, please. As the audience is aware, that's a copy of The Hindu on the day that our dignitaries were born. That was a very interesting first panel. Just give us a few moments as we set the stage for our second panel discussion. Thank you so much. We will now move on to our second panel discussion titled The Role of Law in a Changing Society. I'd like to invite our distinguished panelists on stage for this session. Please put your hands together for Ms. D. Nagasaila, Advocate, High Court of Madras. Ms. Shabnam Banu, Advocate, High Court of Madras. And Professor Dr. E. Prema, Professor of Law and Assistant Dean, VIT School of Law, VIT Chennai. This session will be moderated by Ms. Ramya Kannan, Chief of Bureau, Tamil Nadu, The Hindu.
Hello everybody, and it's been a great day so far. Some of us who've not been here have been watching it live on the streaming, so there is a link that you might want to refer to later. Please ask some of the Hindu folks who are here. But welcome to the second session of this day. And we are here to discuss a very important topic, the role of law in a changing society. So we are all here because we think law is essential. It's also multifaceted. For the purposes of this deliberation, let us look at law from 2 points of view. The first is that law is a kind of anchor that gives us the shoots and the roots to hold on to values that we deeply cherish when the world around us is spinning in a chaos. For, just a mental imagery, if you guys have watched Everything Everywhere All at Once, Michelle Yeoh is rooted to her chair when everything around her is spinning. Today, that is how the world is. Around us, there are so many changes that are happening which take away some of our precious and closely held values, particularly in the area of social justice. All around us, there are values that are changing that include people who change gender orientation, people who change political orientations. There are people who also have issues with the way the Constitution is framed today. And there is climate change and AI, as we discussed in the session just before. And these are all challenges that, assault us today, to put it, rather bluntly. So where do we look for? Where do we seek assistance to hold on when this change is happening all around us? The second aspect is also something that we are going to discuss in depth today. It's about how law itself must change even as it remains our root, and our anchor. It's not an easy thing to do, but today, to resolve these issues, we have a wonderful panel with us. We'll give about 10 minutes to each panelist, and then we'll open the floor out for discussions. I'm just going to give you a very, very brief, short introduction. So we'll start with Advocate Nagasaila. She is a civil rights activist. Many of us here in the audience might be familiar with her work. She is a lawyer at the Madras High Court, and she's been opposing state repression on behalf of dissidents, workers' unions, and marginalized minorities for over 3 decades. Ma'am, would you like to start?
Thank you, Ramya. I think from the previous session, AI, which has all been up there, it's a lot of technology and hi-fi. We are now coming back to terra firma, because now it's when we are looking at law and society, it's about you and me. Society is not something out there. It's really, I think each one of us are answerable, and we need to reflect on this question. While yes, defining law, defining society is a big task in itself, and I don't even want to attempt it in this 10 minutes. But what I would attempt to do, or at least what I intend at this point, is to just give each one of you a framework. I think young law students who are here, what is really important as a lawyer is to have a framework within which you understand a problem. In the absence of a framework, you may actually go all over the place and never really, zero in on what is the real issue. So now how do we look at a changing society? And what do we understand when we talk about the term of rule of law? And now how do we understand this intersection? So I am just attempting to give you a broad, from the time of Indian independence, let's look at it broadly, about 7.5 decades. If we were to broadly demarcate the first 2 decades as the decades when India has invested a lot in institution building, whether it was the legislature or the executive or the judiciary. And apart from him, these are the 3 wings we always hear as law students, I think from our 6th standard civics textbooks, these 3 things we keep hearing. But in addition to these institutions, there are a lot of other democratic institutions which we'll hear less about, which is the election commission, which is your finance commissions, your planning commissions, your your constitution. If you have that, if you have done that, the syllabus for that, you will find that the constitution itself has mandated many of these bodies which are essential to the running of a democracy. So the first 2 decades in India has been a challenge in terms of re-envisioning. Some of these, of course, existed even during the colonial era, but it was a question of redefining, reclaiming, and re-envisioning what each of these institutions should do. For instance, the election commission. At the time of independence, the literacy level in India was about 14%. And India had taken the bold step of universal adult suffrage much before many of the so-called developed nations. So which means you had a whole host of Indians who couldn't read and write, who were going to vote in a free India. Now how should an election commission then design its electoral process? It was a challenge. You had to rethink and reimagine what our country needs. And that's how we came across using symbols. You don't need to read and write to identify symbols. So that is how in India we have the symbols for each party. So the census, how do you take the census that we take every 10 years? The planning commissions to decide how and when and where we spend our money. Now these were all the various institutions which were being built, and each of these institutions were also testing waters. We were exploring the institutions, we were expanding them, and in many ways strengthening many of these institutions. So the first 2 decades was essentially decades of building these institutions, which are very essential for enforcement of the rule of law. The next 2 decades, I would say, started the decline, because somewhere I think the engagement of the citizenry, I think as Indians, the first generation, that is the generation which had fought for independence, they were far more engaged with the polity. They were far more engaged with the whole, I don't know how many of you have, it is generally not there in our textbooks, but when the Constituent Assembly was debating, it was not just the few elected members who were engaged with the constitution making process. Letters poured in from all parts of India, where each citizen was writing to the Constituent Assembly saying that, look here, we want you to take care of these interests. So that was the kind of participation that we saw from women's groups, from farmers groups, from trade unions, from ordinary workers. A lot of people participated even in the constitution making process. So that was the kind of engagement that the citizenry had. Then I think after the first 2 decades, the citizenry kind of, we all lapse into some kind of a complacency. Oh well, the government will do its job, the judiciary will do its job, and we'll carry on with our lives, and we'll make our neat packet of money and be happy with it. Each one live their own lives. But it doesn't work that way. A democracy doesn't work that way. It's only as good as what the citizens make of it. So the next 2 decades I would broadly, and these are very broad categories, there's no big sanctity to it. This is just for a overall understanding. Is the decline of institutions where, you know, you had aberrations, we just looked at it as aberrations, we were not willing to actually fix them then and there, we were willing to turn the other way, we were willing to blink and let things go by, and we still carried on. And I think the last 2 decades, and more so in the last decade, we are seeing a dismantling and even a destruction of many of these institutions. And actually, I think if many of you, I don't know if in the Constitution syllabus, I don't know if the Constituent Assembly debates are part of the syllabus, which were not when we were doing law, but it should be, because if you haven't read, please go back to read at least the 2 speeches made by Dr. Ambedkar when he was introducing the Constitution and when we were adopting the Constitution, the draft Constitution. If you look at those speeches, you know, Ambedkar actually alerts us to this possibility. He says, see, what I am really worried is that India has lost its freedom earlier, not because of any external forces, but because of the treachery from among its own people. So he gives examples of commanders of, you know, various armies of the kings who received bribes and worked for the other side, or commanders who actually didn't do their job and were very silent when the enemy was attacking you. So this was a kind of treachery which was responsible for the loss of the independence in India. I mean, not India the way we know it, but he was giving a broad historical understanding of the people of India. So this is the treachery that I am worried about. That will we lose our independence once again, not because of any outside external aggression, but because the people, we the people of India, we would allow these institutions to crumble because of our own internal treacheries, if you want to call that. And treachery need not mean only in these extreme cases, indifference, failure to engage with the issues on hand. All this is part of it, and this is what Ambedkar warned us about it. And the other thing he warned us about is that while yes, we are entering a period of political equality, as far as social and economic equality is concerned, we are not, our Indian soil is rooted in inequality. And unless we as citizens address this inequality, we cannot hope for this country to survive the way it is. And to ensure that our constitution and the principles of the constitution are protected and we achieve or at least aim to go towards these constitutional goals. Now I think we are reading every day that as the millionaires and the billionaires in the country and in the world are increasing, the inequality is higher than ever it was before. The fact that people are more and more alienated from their own resources. I think even 2 days back the headlines was about 30 Maoists, you will find it within brackets, which is mostly women who were killed in the tribal areas. So the disenfranchisement of tribals, of women, of the poor, the urban poor, all this I think is still has not been addressed, and this is what exactly the concern expressed by Ambedkar when he introduces the draft constitution. So I would really urge each one of you to go back and revisit Ambedkar. And as Ramya had mentioned in her introductory speeches, today we have commentators talking about how, oh, the constitution should be changed because it's a relic of the colonial era. But Ambedkar has answered it. It was a criticism which was leveled against him when the constitution was drafted. And he very squarely and clearly meets this argument, and he says, we are not the first constitution that is being written. Constitutions have been written and in existence for hundreds of years before the Indian constitution was framed. And it's, I mean, only logical, reasonable, and I think what any common sense person would do is to look to the history, look to the past, learn from it, make your adaptations, make our corrections, do our customizations. It doesn't make sense to reinvent the wheel. So just because we have not reinvented the wheel, it doesn't mean that, you know, it's a relic of the colonial era. So I think all these debates, you will find answers if we go back to the Constituent Assembly debates, because all these issues were debated at length at that time. Now coming back to now what is the society, what is the change that we are seeing in society today? As I said, one is the dismantling of our institutions. We haven't had census being taken for the last, after 2011 we have not had a census taken. So now what is our planning all about? How are we ever going to even the basic thing as planning our economy? We are in a world where on one hand you are talking of AI and data analytics, but here we are a country who is afraid of data. We don't want to even secure data. So that is the reality which we are living in. So what is the analytics that we are going to do without even authentic data? That is a harsh reality. Look at our, you know, the SEBI, I mean the scams are all over the place. Even if you are looking at, I am not even going to the executive, the legislature and the judiciary. I am talking of the more everyday institutions which impact our everyday lives, which is your markets. We have seen the scam around the chairperson of SEBI. We have seen now the entire distrust which is building up over the election commission, where today in every citizen's mind, at the end of an election being declared, there is in the back of our mind, was it a fair count? Is it a fair election, or has there been a manipulation? So I think that is the biggest threat to our democracy and the society, because there is an element of distrust of and mistrust of institutions in every walk of our life, not just institutions, but even our professionals. You go to a doctor, do you trust the medicines that the doctor is prescribing? Do we trust the diagnostics the doctors are giving? There's an element of distrust. Am I being given some unnecessary diagnostics? Am I being prescribed drugs which are not required because the pharmacies are, you know, wanting to meet their targets? You go to the judiciary, you don't know when your case will be taken up. Even if it is heard, it's not unknown that clients very often come and tell us, oh, do this, try and do this case before a particular judge, or don't do it before a particular judge. Or, you know, I mean, they will tell you that if you go to the Supreme Court, which judge, which lawyer should be engaged before which court. That's a done thing. I mean, it's out there. Everybody will tell you. Tell me which court, and I will tell you which senior to engage. All this doesn't bode well for any of us. It doesn't bode well for our democracy. It doesn't bode well for our country, and it doesn't bode well for us as citizens. I think this is the society, this is the change that we are seeing in society. And how do we address these issues? It's not going to get fixed on its own. It's not going to be fixed by our leaders, whether it is the politicians or the bureaucrats, because they are the problem. So if the solution can only be from us, we the citizens of India. So if you're going back to the preamble, so I think our answers are in going back to the Constitution, going back to the values of the preamble, going back to see how much of all of us are living by the values of the preamble. We need to reclaim the preamble. Please go back and read it and reread it and reread it. I think a time has come that if each one of us do not take our Constitution seriously and do not strive to imbibe the values and ethics of the Constitution in our everyday lives. It's not about just Constitution is not for lawyers, it's not for lawmakers, it's not for judges, and it's not for the courtrooms. Constitution is something which is valuable for each one of us in our everyday lives, and more so I see a lot of women students, very happy to see a lot of women, young women students, law students here. For women, I think more than ever, constitution values begins at home. The principles of equality, liberty, for women it begins right at home. How many women enjoy that in your own home spaces? How safe are homes for women? No, these are all the questions which each one of us have to engage with. And as citizens, I think the time is up for us to be complacent. The time is up for us to allow just our parliamentarians and the bureaucrats, the IAS and the IPSs to decide our future. I think unless all of us wake up to the fact that any country is only as good as we, the citizens, make it. And if we do not take the effort to engage in the constitution, in the lawmaking, in what's happening in the country, I think we may end up losing these hard-won freedoms that we have taken for granted. And I'm afraid, our generation took it for granted and we have enjoyed the best of it, but not so your generation. You're being picked up for, a WhatsApp post or a Twitter post or whatever. So you're living where all your rights, which are enshrined in Part 3, we are in danger of fast losing them. And unless we the people, which is each one of us, I think take charge and learn to actively engage in the whole process of social change, I think we have a lot to lose. I think with that, we'll wait for the question and answer session.
Thank you so much, ma'am. I think if law gives us a grounding, ma'am has just given us a grounding into 7 decades of law in India, and a very rousing speech at that. We will move on to our next speaker. Shabnam Banu has been practicing in the Madras High Court for the last 13 years. In 2015, she started her independent practice and further progressed to setting up her own firm in the year 2020. She is now the proprietor and advocate of Shabnam Banu and Associates, with a competent team of associates and lawyers. She always believes in a dynamic practice of law, and she says, she embraces the march of law.
Thank you. Hi, everybody. Firstly, before I start, I just wanted to say that change is the only constant, is what has been told, and we all know that. In fact, the discussions that we are having since morning, and the topics that are being put up here, I think it all stems from the topic that we are now discussing. Because if not for those changes, I don't think we will even have those discussions. Because back, like in 20 years back or something, I don't even think these topics would have been a matter of concern or prominence, gained any kind of prominence. So I think it stems from the fact that there is so much of change in the society. According to me, I think society and the law go hand in hand. In fact, law is in place to ensure that the society is also in place. And by society, I mean you, me, and everybody, which includes everything that governs us in terms of the regulations, the laws, the code of conduct, etc., etc. Now, when we talk about the changes that we see, I think we can trace back to the times that we had the abolition of the sati system, which was in the 1800s. It started at that point of time. And till today, we see a lot of changes. Now, the issue is that each time when there is a change, okay, I don't think everybody accepts to it. Like she pointed out, it affects somebody's value in some way. But you know what? To curb this and to eliminate this, the laws are in place and the changes are brought in, because what is equal to someone is unequal to somebody else. So when we start off from the judgments of this sati system and all of that, today we come to a point where we understand that laws are in place and it is changing to uphold something as important as your fundamental right, as well as something as trivial as conducting or controlling or regulating your behavior with your neighbor. Sounds very silly, but it is true. Laws are in place to ensure that every facet of your life, from the time you move out of your house until you reach here, from the traffic violations and the people you meet and what you do and how you behave in a certain place, whether this constitutes unlawful assembly or is it an assembly for the right cause, everything is governed by the law. Now, when we talk about where this starts, I think as students sitting here, I would like to resonate more with this crowd to make you all understand that what is the changes that actually you guys could see. this starts from somewhere where my learned senior was mentioning about the constitutional changes, which I do not want to get into. So it starts from those decades. And today we are here where we are talking about how, for example, a child is born. A child is born, a child is then going to school. When you go to school, what are your rights? What are your duties? Then you go to college. What are your rights? What are your duties there? And then it goes on to your employment and your opportunities that's available over there, and how equality should be given and how you should fight for your rights. I think laws play a major role. I think one important judgment that I just wanted to point out without delving into the facts of the judgment is that I think it was one social change which happened in Vishaka versus the state of Rajasthan that culminated into a statute that said that, protection of women at workplace. It started from there. It was one inequality that took place there that came here. Now next, traversing to the Sabrimala judgment, for example, I don't think everybody is agreeable with that. Each one has their own view. The minute a judgment is out, it ignites a lot of criticism from different people. Now, what is right for you may not be right for somebody else. When Shahbanu's case happened back in the time, Muslim men were completely against it. It sparked so much of controversy, saying that it overlaps into our personal laws. But then you have to understand that if we are living in a democratic country where we talk about equality, it is very important that these laws are in place where everyone can make a claim to it equally. For example, when we are talking about tech, when that discussion was brought before this forum and everybody was talking, when one student pointed out a question, I don't think back in the time, 10 years back, I would be able to answer that because I don't know what it is. When I studied law, I don't think competition law was there in place. But today we have so many changes. And now these changes give room for a lot of good things and the bad thing. While I say that the Vishaka guidelines led to a particular statute, today there is a change where we also talk about how women should not misuse that statute. When you say there are dowry prohibition laws, or you're saying there is, your assertion towards fundamental rights, you want to invoke your rights, you want to assert them, you should ensure that you do not, after a point, misuse this particular provision, because this changes are brought to help you reach a better place and to have a very civil form. In fact, I would like to quote an example. There is this movie, I don't know how many of you have watched it, it's called The Purge. So this movie was released, I think, in 2013. It's a very interesting concept where this movie talks about where the government gives 1 day leave in a year. It's called the annual purge, wherein you're allowed to do whatever you want. You can kill people, you can steal, you can break houses, you can do whatever you want. And that movie talks about how families protect themselves inside the houses. Now just imagine, all of us have some thoughts in our mind which may not be right, okay? We are angry with somebody, we want to lash out at them. There are different things that we could do. But just imagine if there was no law and order. Just imagine with evolving mindsets, if there were no changes, what would happen to this society? When Menaka Gandhi's case was taken up as a very big example when you spoke about personal liberty, today we have come to a position where two people, FIR has been registered because they spoke something which was very inappropriate in a stage. So I think this is the change that we are talking about, because when we talk about change, it is very important to know that we have to adapt the change in the right way. Just because there is a change, it doesn't mean that you can do whatever you want. So the change is subject to a lot of responsibilities that should stem within us and our conduct in the public. While I look at courts, okay, for example, like my learned senior just pointed out, she spoke about, the respect towards women, or how you're supposed to conduct, where it starts at home. Like we say, charity begins at home. I think I have a view personally, it may not be agreeable to everybody. I feel women empowerment at large is practiced more in courts than in your houses, where it should be the otherwise. If women empowerment began at your own houses, I don't think we need to reach courts. Because today courts think that awarding maintenance is the only form of empowerment that women can have. At the same time, that should not also be misused, because today there is a change in the society because the statutes protect you, but that doesn't mean it should be taken against the other clan. It should not be used against the other clan. So while we speak about all of this, we also go into other judgments that brought a revolutionary change. For example, going back to the Sabrimala judgment, I don't know how effective was the judgment today implemented. Even today, we have so many review petitions pending, challenging the very same verdict, saying that it is still not possible because the society has to accept to it. So, like I said, not everyone can accept. If it's something to do with a particular community, like it happened in Shahbanu's case, I don't think everyone was agreeable to it. People said, no, you're just, you're invading into the privacy and the customary practice of a particular community. But it is not so, because when you're talking about liberation, you're talking about changes, I think that should be equally applicable to everybody else, okay? So while we speak about the changes in the society, we also have to adapt to the fact that these changes are subject to the fact that it is used in the right manner and it's manured in the form that we can progress through it. So each change that, like, for example, you're taking a house today. The tenancy laws are very important to protect you over there. When you go to a job, you attend an interview, you ensure that, or let's say it's a government job, you ensure that, all the set practices of where we preach about the fundamental rights are practiced in real. Essentially, it should be applied. And now the courts come into the picture. When we talk about this role, when there is a violation or there is a breach of these particular rights and duties that we're talking about, courts come into the play. Imagine if courts did not pass verdicts. Where would this culminate into the change that we are talking? It is one thing that there is a verdict and the change has not been implemented, but it's absolutely another thing when these changes are brought by court, and it is the moral and the bounded and the legal duty of everybody to ensure that we are subjected to it and we follow it and we implement it. So while today all the students who are sitting over here, I just want to address something very important. When, like she pointed out in my introduction, I believe we should be the change we want to see. Because I've had experiences in the kind of work, the body of work that I have done, where I have reached a dead end, where I don't know that no precedent is helping me. Because every time, like our senior Mr. Arima Sundaram pointed out this morning, it was a very impactful speech I felt. He said, you can't always rely on judgments. If you're having a legal issue to decide tomorrow and it's about a social change and you don't have anything to rely on, are you going to say that you're not going to take up that matter because you don't have a precedent to rely? It is not so. Because sometimes you have to make the precedent. It is very important that we set the precedents because someone somewhere set some precedent. That's why we are sitting here and we are talking about it. So likewise, when we deal with issues, it is very important that you need to be the change you want to see. It is one thing to keep preaching, within the box of what is always set for you. But it is absolutely another thing where you want to see the change that you want to be. And it only starts when young minds come up with, with all the equipped knowledge that you guys derive from these topics and these laws and everything, which I don't think people from the older generation can do. Because now we are going to the point where technology is reached to an extent that your thinking ability begins at a point where mine might perhaps end. Because you have all the exposure, you have the resources. Because back in the college when we studied, speaking about the role, we never had any exposure that you guys have today. What you're exposed today at this point, whichever year you're studying in, I had no clue in my final year of college or until I became an advocate. So I think you are so blessed to have that kind of exposure to know what is what. Growing from the times where we did not know the jargons of law and we had to go under a senior to learn the basic criteria. Today you are well equipped to know half of the things, and what you need to put to use is now the practical aspects of that. What you are taught in your in your colleges about the roles and the changes and all of that is just theoretical. But all this can take effect and form only when you put it to practice. And that can happen only when you want to be the change. Sometimes it takes a robust move and, the step forward to decide that this is the change that I want to bring. Because recently when I was overwhelmed when I read one of the recent judgments of the Supreme Court that spoke about a lady who's a journalist who filed a case before the Supreme Court challenging the discrimination in the prison. Gone are the days where we used to fight discrimination, caste discrimination in the society. Never ever did I think that there was caste discrimination inside the prison. And it is so important to have this uniform code because I do understand that we can't eradicate this, okay? We can talk, we can say it's all nice, but we all know that there is an underlying problem. But beyond that, I think somewhere you need to bring in the change that you want to see. And most importantly, when there is a change, it requires a very broader outlook to adapt to the changes. I think that's very important.
Thank you so much. So, 2 out of 3 speakers have effectively lobbed the ball back at us. It's a responsibility of us as citizens. It's a responsibility as students, as lawyers, as journalists, just as residents of this country. We'll now move on to our third speaker for the day. Following which we'll open it up for questions. Dr. E. Prema is a professor and assistant dean at VIT School of Law, Vellore Institute of Technology, Chennai. She specializes in international law, climate and environmental law, and human rights. Her research focuses on climate justice, state responsibility, and legal frameworks for sustainability. Over to you.
Thank you, Ramya, for this wonderful introduction. And I'm very honored to be in this all-women session because VIT and also Hindu were very specific of having this all-women session, and which shows the equality, equity, and also inclusivity, everything together. So that is wonderful. With the opinions which my fellow panelists were expressing their views as a practitioner of law, what I observe, or currently what I do my research in, is the outer space laws. So to me, law not only protects the interest of people, rights of people, but also provides opportunity. So outer space is one such kind of sector where I just understand that the policy level frameworks, or how it is going to be the international frameworks, not even reaching the national legislation, had provided opportunities, specifically including women to it. So one example I could give you, where we were for all this time, or the previous panel was discussing about the technology AI, as my fellow panelists were also telling that it's very complicated. If it is going to be for my fellow panelists, it's too complicated for me. At least 25 years before I did my law graduation, and now I'm talking about outer space laws. So this one is one I could see how it is going to be educational institution, the society, and how it is going to be law which is providing opportunity apart from age. Your interest in learning and your intention changing the society is much important. So in that line, I would just give you an example. I don't know how many of the students here know that the director of United Nations Outer Space, Office of Outer Space, is one woman named Miss Aarti Hola. She is of Indian origin, and now she is in a leadership position, which is a position where she decides. You know, it's not only with her regime, but she provides opportunity. She is in a position where you could very, openly can see how leadership given to women can change many of the things. Because when I have been to such kind of conference, previously 10 years before, that was not the same. It was only, sorry to say, use that word, white men, and also only men were there. But after the leadership changes, she very silently, and also with the policy level changes, including women to it, had provided opportunity not only to the European and American countries' women, but also women from South Asia and also Asia. See, as my fellow panelists were talking about how opportunities can make social changes, we have to become the change. We have to understand, adapt changes. It is not sometimes your cup of tea to decide upon. Sometimes it is very tough, and then comes the change. So we should not be hesitant in taking up new things, trying to read. Maybe sometimes I'm very slow and the younger people are much faster than me. That is not going to be a hindrance, while it is going to be you talking about changes. What I can assure you is, law is something which doesn't make society to fit in. It is providing the society how the changes are going upon, which is unavoidable. There is no bar. You cannot restrict the social change. So it is, the changes are unavoidable, and the law provides, as you could also remember Justice Chandrachud explaining how it is going to be just reversing the judgments which is given earlier, and now it is been changed to it. Right, it is because they don't say that it is wrong. They are changing it. The judgments gives an opportunity that it is the necessity of the society, and the same need to be understood. So one classic example I could give you, where I have just studied this 2022 NASA's equity action plan. It's wonderful. It was amazing to see, and it was mind-blowing, where this one is not just a policy. As we know, we always think that only legislations and constitutional guarantees protect women or provide gender equity, but this is an action plan where it is showcasing itself. For instance, one of the provisions in that talks about equity. It includes gender equality and also unrepresented, the people unrepresented. So they use these terms, which is very, very important, which is inclusive of many things. And it shows the changes provided. It includes provisions which shows internal accountability, external accountability, and also what is the progress. These two are the important, over this action plan, what internally they do for the equity, achieving the equity, and what externally they establish to the society, and what is the follow-up which is open to all the public. It's not, just like that, a policy which is being framed, which is important for the changing society, and they want to show off that we are the pioneering country which is making inclusivity and also equity is being there. But the document is very open, where the changes which it is made in the policy level is being achieved. So such kind of things can be done as there have to be a comprehensive understanding between the younger generation and also the experienced people who can just make certain kinds of encouragement to the younger generation. So that is from my side. Thank you.
Thank you so much. How many of you had heard of the UN Office of Outer Space before this? Certainly not me. But let's move on to the questions now. Please put your hands up and mic, yeah, right there.
So Shabnam ma'am has spoken about how we need to be the change that we want to see. When we talk about change in the society, the role of policymakers is very prominent, right? They decide what policies are drafted according to the changes that take place in the society. So in such a case, what do we do about the inherent biases that these policymakers might have, and what do we do about these biases bleeding into the policies that they do end up drafting, and the effect that these biases have on the changing society? Because by having such biases and by not breaking out of their mold, they're essentially preventing or hindering progress, right? So what do we do about that in such a case?
Yeah, can I? So firstly, the question that you asked is a very good one. To begin with, I think even the policy makers are human beings after all, right? So I'm sure in this panel, all four of us may have different opinions about different things, okay? To start off, to answer your question, while you speak about a policy, how sure are you that no policy has been changed till now? Are you saying all policies that were in place from the very beginning have been stagnant till today and there has been no change? Because if it is so, we won't have the LGBTQ judgment today. Without giving my reservations on what I feel about it, I'm just talking from the legal point of view. If that was the case, we would not have something like that. In fact, when our former Chief Justice, Honorable Mr. Chandrachud, appeared this morning and he was talking about a lot of things, do you even know that how many of his father's judgments did he overturn? Now, when you talk about policy, where is this put to test? It's put to test in the society. When it's put to test in the society, what is the next step of it? When the society is not satisfied with something or there's something unequal in it, where does it go? It goes back to the court. The court comes back with a verdict. This verdict has to be implemented, and when there is a public outrage where you know that rights are affected to such an extent, what happens next? Then the policy has to either be scrapped down or it has to be modified, or you have to bring in some change to go with the society, because the law and the society walks hand in hand. And when I talk about law, I also talk about policy. And when we talk about these judgments, this is not the only one. Like going back to the Sabrimala, what a big change that must have been in the society, especially in the Hindu community. You can't imagine talking about a woman going to the Sabrimala temple. What outrage did it create? How many people will be agreeable? When you talk about the LGBTQ judgment today, as people, we are sitting here and we are explaining and we are, debating it. Will your parents actually be okay with it? We are not too sure. Now, just because our parents are not okay with it doesn't mean that is not right for a particular community. When COVID happened, I still remember, while working in the Learned Advocate General's office, there was an issue that cropped up where a couple of, incentives were given, okay, to the public, because if they had an Aadhaar card, they would get it. That time there was a bill that was filed where they said, what about transgenders? They don't have an Aadhaar card. How would they get this money? Now, if you look at it, what does the preamble of every act talk about? Let's go to the matrimonial laws. It says man and woman should be married. It says the man is this, woman is this. Now, how will a transgender go claim this in an Aadhaar card when there is no laws in place? Then there was Grace Banu, one particular person who filed this particular public interest litigation, and she got an order favorable to her. Like that, there are many things that has been challenged, okay? So when you talk about where the law has said that a man and a woman, and when we're coming to a sea change of discussing issues like the LGBTQ judgment, or we're talking about the Sabrimala case, and we're talking about single mothers adopting kids, we're talking about the surrogacy bills, don't you think that we have come really far from the very narrow outlook of the policy making, and today we have come to the place where there are indeed changes. Maybe if you look further, you will know. Now, what is your role in this? Maybe tomorrow when you become an advocate, if you have a client who's coming to you and this client is telling you, I want to challenge something which is not as a part of the law, you must ensure that you do it for them. Whether you fail or no is not the point, but you at least tried. Because back in 2018, when there was a single mother who came to me, she said, nobody is willing to take up my case because, you know what, I want this name of this father that is put in the birth certificate to be removed. Why she wanted to be removed? One is because she's a single mother. Two, the name of the father that is put is wrong. It is a friend who accompanied her. When we met the authorities, she was a woman herself. She said, no, we need a name. It's okay, let the name be. So she didn't care if the wrong name was there. All that she wanted was a name should be there. Guess what? I fought it out. I went to the court, and Madras High Court happened to be the first to set out a precedent where they said that a single mother doesn't require a father's name in the birth certificate, and India had its first birth certificate without the father's name. So I've been there, I've seen it, which is why I'm telling that to you. And I think you can also do it. Yeah?
Thank you, ma'am.
Just to add to what Shabnam has said, you're right that policy makers are very often can be biased, especially in instances of men. We are living in a patriarchal society. So there is a patriarchal mindset, and it has never been very easy to make changes in policy. But for instance, if you go back to the Constitution, there has been a recent book on the mothers of the Indian Constitution. We only hear of the fathers, but there is a book on the mothers. That is the women who have contributed to the Constitution making process. And if you go back to Article 25, which talks about the right to freedom to practice and propagate religion, this clause had come up under much debate and opposition by the women Constituent Assembly members, saying that ultimately a lot of the rights of women are subjugated only on account of religion, and religious practices are often very anti-women. So that is why if you see the Article 25, it starts is subject to public order, morality and health. So they try to restrict that right and also subject to Part 3 and to subject to other provisions of Part 3. Now these clauses were brought in only because of the mothers of the Indian Constitution, because they were very aware that what it would mean when if you give people the freedom to practice religion. So again, coming back to the rape cases, on the whole issue of consent, it did not happen overnight. A lot of women's organizations have worked on it, have demanded, have lobbied, have protested, there have been campaigns. That is what has brought in the changes to rape law. When you're looking at the SC/ST Atrocities Act, again it didn't happen just because of the goodwill of or the good-heartedness or the large-heartedness of the lawmakers. It came after a lot of protests. Going back to workers' bills, whether all the bills pertaining to unorganized labor, the construction workers, migrant labor. Though, during COVID time, we have all been witness to these large thousands and lakhs of migrant workers walking across the length of India, and many of them dying in the process. And nobody ever debated that there is a Migrant Workers Act in this country. I think even the lawmakers, even the labor commissioners, nobody knew about this law. Nobody looked at it because nobody ever enforced and implemented the law. So yes, you are very right. There is a bias not only in just in policy making, there is a bias in enforcement. So again, the ball is back in our court. It's for us to ensure that we influence our policy makers, we make our voices heard, and after the law is passed, it's for us to ensure that it is enforced.
Thank you, ma'am.
We have time for one question, maybe.
Good afternoon, ma'am.
Can you come out?
Good
Thank you.
afternoon, ma'am. So my question is in relation to social media. So my generation and many more people are extremely online right now, and we can see that most of the information and almost all of the content that we consume is from social media. And this has also created many echo chambers where people on their online selves are much more likely to spread a lot of hate and vitriol towards women and other marginalized communities without much consequences because they believe it doesn't have an effect on real life. So, and all of this hate is beginning to translate, especially I've seen in my own school, the students are beginning to speak in a very hate-filled manner, and all of this is can be rooted back to the social media content they consume. So do you believe that moderation of social media is the only way that we can curb this, or is there a more of a role that the law can play in society and like changing and giving more digital literacy? So do you think that only moderation is the solution, or is there something else we can do to understand the effect that social media is having on the mindsets of young people?
I think I would go for digital literacy and critical thinking, because any moderation in terms of lawmakers, I mean today there is an attempt that that most we are seeing any posts which are not so I mean if our politicians or our rulers or whoever the powers that be are not very happy, immediately they are pulled down. That's happening day and out. And when the power to moderate is given to somebody who may not always be neutral, and especially if it's a person in power and control, then I think it goes back to our fundamental right to freedom of speech and expression. The right to freedom of expression itself, you have seen the limitations in Article 19, that there are certain limitations, and I think as citizens, we need to actually critically engage with those limitations. And yes, there is a problem here in terms of living in the virtual world. I think most of you must be hearing it from your mothers because I also have daughters your age. But yes, it is a problem that very often that the current generation believes that the virtual world, we call you all the internet warriors. We don't find anybody coming onto the roads. Everybody is happy to sit in the drawing rooms and make a post or maybe a like or some emoji, and you think that's it, you have done your bit. It's definitely not enough. First, yes, your engagement is very limited. It is in a very many ways very artificial. So it is an artificial world which has been created by the virtual media, and I think there is a danger that, of course, now there's enough information also coming in about addiction and how your brains are getting rewired, because there is an inability to engage with an issue in a long term, because now we are used to this 30-second bites. When it was the television, we were looking at 1-minute bites. Today I am told that anything more than 30 seconds, it doesn't hold the attention of your generation. Now in 30 seconds, what is the kind of engagement that any of you can wish for? Can you talk of women's rights in 30 seconds? Can you engage with that issue? Can you look at the constitution in 30 seconds? So unless all of you reflect on it, maybe meet physically, not virtually, and debate about the problems of the virtual world. Talk about the hate speech. Would we say this to anybody when we are face to face? We wouldn't do that. But behind the screen, in the comfort of your bedroom, in the privacy of your house, in the anonymity of that space, we sometimes get emboldened to do things which otherwise when we are face to face, our other senses kick in. We are a lot more restrained because the person is physically present in front of you. We are more mindful of their sensibilities, their sensitivities, their feelings. all of which are numbed when we are behind a screen. So I think that is a debate which all of us, and especially because I find that, in fact, I went to the extent of having to delete my Twitter app because I just found that I can just spend hours just doing this. And, and a lot of productive time is wasted. So I just realized that I'm just wasting a lot of time. And I deleted that app because I know the temptation is there. Even now, you must have seen me pick up the phone and look at it. At my age, I was not born with this. But yes, there is a temptation to see, okay, are there any messages which I need to respond to, any emails which have come in. So this is a constant struggle, I think, which all of us, and especially your generation, will have to engage with. So I think it's a very important question that you have raised, but I really have no answers.
I think time is up, and thank you for a very, very sparkling session today. And I think there are messages that students particularly can take back home. And the central message, of course, is that everything depends on us. So thank you very much to my panelists and for this all-woman panel today. Thank you so much for coming.
May I now request Ms. Ramya Kannan to please present mementos to our esteemed panelists. I'm sure, as our audience knows, these are copies of the Hindu on the very day that our dignitaries were born. Can we have a big round of applause for all of our panelists, ladies and gentlemen? Thank you so much, and thank you so much to our audience for your enthusiastic participation. Just give us a few moments to get the stage ready as we move on to our third panel discussion. We are now ready to begin our third panel discussion on the topic Corporate Law and Business Ethics, Navigating Legal Complexities. Our distinguished panelists for this session are Mr. N.L. Raja, Senior Advocate, High Court of Madras, Ms. Deepika Murali, Advocate, High Court of Madras, and Professor Dr. R. Kestavamurthy, Professor of Law, VIT School of Law, VIT Chennai. Moderating this session is Ms. Aratrika Bomik, Senior Sub-Editor, The Hindu. Let's give them a round of applause as they take the stage.
A very good afternoon to everyone. Welcome to the third panel discussion of this conference. What we will be discussing is on corporate law and business ethics. Our endeavor in this session is going to be to discuss the existing regulatory regime that we have, where it succeeds, where it fails, and why, despite so many compliance requirements, corporate fraud still persists. We have the SEBI regulations, we have the provisions in the Companies Act, but we still see corporate fraud persisting. We have an excellent panel with us today. I'd like to first introduce Mr. N.L. Raja, Senior Advocate practicing in the Madras High Court. We have Advocate Deepika Murli, who is also practicing in the Madras High Court. And we have Dr. R. Kesavamurthy, Professor at VIT School of Law. A very warm welcome to all of you. If we could begin the discussion primarily first speaking about what the challenges exist when it comes to the regulatory regime that we have. Mr. Raja, if we could begin with you, please.
Yes. Good evening to all of you. Today, we would all know that if you take the 100 top economic entities in the world, it is not going to be governments. The majority will be corporates. Many corporates have budgets which are bigger. Many multinational corporates have budgets which are bigger than the Tamil Nadu government. So today when you talk about a corporate as an entity, you will have to talk about rules of governance rather than rules of business management, because that's how big businesses have become. So in this world of constantly evolving business standards and business practices, the challenge of law to keep up with the pace of change of business strategies and the various methods of business is a very real one. And the main challenge has been how is law to keep up with these changes. And if you would, I don't know how many of you have read the book Nexus by Yuval Noah Harari. It's a very interesting book which sets out how the future is going to be determined by AI. So many of the things that we take for granted today, we do not know that it is actually being generated by AI, it is directed by AI, it is regulated by AI. Given these complexities, he says there are going to be machines which are going to talk to each other, computers which are going to talk to each other. It will completely eliminate the necessity for a human interface, and it will come up with financial documents which none of us will understand. And the impact of these financial documents on global business, on global strategies, on how businesses will proceed is going to be mind-boggling. So for the first time in human history, we would completely lose control of what we are doing. You just build the necessary algorithms. The algorithms will see to it that they come up with systems. These systems will between themselves discuss and come up with financial tools. It will come up with means by which businesses can be regulated. So this is a huge challenge which the infusion of technology into business is posing. There's another very interesting book called Future Shock by an author called Alvin Toffler. If you take all of human race and the life of human race on Earth and condense it into a 24-hour period, it is in the 11th hour, 23 hours, 57th minute that man invented electricity, right? So from all this period, the last 3 seconds, so to say, have made such huge change in human progress. And now we can imagine what type of progress is going to result from infusion of technology into business. Therefore, It is in these circumstances that it is necessary for human minds to come up with standards relating to ethics. And with regard to ethics, there are different views. For example, Peter Drucker says that there need not be any ethics for businesses, because if every human being is going to be ethical, there would be no necessity for ethics in business. Now, very many authors do not agree with this standpoint, but that discussion is going to go on. But what can law do to regulate it is going to be the challenge, which we are going to discuss in the next few minutes.
Thank you, sir. Ms. Murli, what is your opinion on this?
So, you know, while researching for today's discussion, so we had the occasion to see what are the regulatory mechanisms available in India. And I know there was a question put specifically on looking westward. And if you look at today's company law and the newer IBC and everything, there is a lot we take from what is first brought out abroad and then we inculcate it here. So, including in company law, whatever are the evolutions we see which happens first in the UK or the US, there is a lot that we imbibe into our policies here. So, on that note, while there are some things which we seem to have blindly taken forth, you know, for instance, like bringing in independent directors to be on the board, various other regulatory mechanisms governing like directors and listed companies. SEBI, like you all know, if you've had a course on company law, the LODR requirement specifically states what should be the regulatory framework which has to be met by a company. You also have the new Companies Act 2013, in which there is 177 and various other sections which speak about what are the audit mechanisms and what vigilance should be there. But there is a very, compare that to say your, the UK laws on whistleblower policy or the US Sarbanes-Oxley from 2002. We did have a Whistleblowers Act, which was a bill which was passed, which later became an act, but I think it's been dormant for more than a decade now. So we seem to be taking what is most convenient, and when it is not, for instance, the whistleblowers policy, we seem to be very inconveniently brushing that aside. So we all know, be it with, say, journalists, including the very unfortunate incident from January in Bastar of a journalist being murdered for exposing corruption, to other whistleblowers who have not met a not so pleasant fate. We know that this corruption and things is part of governance which is happening, and transparency would bring in a lot more accountability and corporate governance procedures as well. But what we are seeing is that not being followed, the act not being coming in, and because of that we are facing a lot of other issues in the general corporate space that we know as is today. The second issue that I want to speak about, moving on from whistleblowers and policy and everything, is specifically if we look at Corporate Law, Companies Act and all the governance that is there. Yes, like again I spoke about audit mechanisms and the need for a better system in that place. We do need some sort of amendment as well to the Parent Act, which is the Companies Act, to bring in some sort of insurance and protection for the directors as well. Here I will dwell a little into judgments that have recently been in the news. You may have or may not have seen, there is a judgment last month of the Supreme Court in Sanjay Dutt, not the actor, versus State of Haryana, which spoke on how much a director can be held vicariously liable when they've not been directly involved in an act which the company is accused of doing. You all may also have done some amount of Negotiable Instruments Act in your criminal courses and everything, where directors are generally being made liable. Now, the jurisprudence which flows from these Negotiable Instrument Act cases and this recent one that I spoke about is that you can't make a director blindly a party, blindly an accused to such litigation. There has to be some cause and effect. Yes, a director may be an agent of the company, but that doesn't mean they can be added to each and every litigation, and you can't presume that they are guilty, and you can't presume that they were involved in the transaction. That is one part of it. The second part of it is something which again is there westward, which is the D&O insurance, which is the directors and officials insurance, which is something which we don't yet have in India. There is some chatter about trying to inculcate that into legislation and everything, but probably that can only come into by way of an amendment to the Companies Act. So my 2 bits on this is, just to summarize, Whistleblowers Act, we still are nowhere near that. And secondly, any vicarious liability being foisted on a director, there is some jurisprudence on that, but something more codified will be needed to take this forward.
Thank you, Ms. Murli. We'll actually discuss whistleblower protection and the need for legislation in India a little bit more in detail. But before we go to that, Professor, I'd like to come to you. Do you agree with Ms. Murli that there are statutory reforms required? And do we take inspiration from other jurisdictions in this aspect?
First of all, I am very honored to share the dais with the 2 eminent speakers here. My point here is, I would see Professor Palmer in his book 1909, 100 years back. He has stated that what actually you are going to do after 100 years down the line is going to be decided by the corporates. Your lifestyle, what you wear, what you do, your life's value itself is decided by the corporates. Down the line 100 years, what I would see now is we are in that future, meaning the corporates are actually deciding what we're supposed to do and supposed not to do. That is where we are in. So as a senior advocate was rightly pointed out, there are so many legislations that we have adapted from the Western countries actually. If you read the work of Davis, one of the acclaimed authors in corporate laws, he actually quoted this. The mistake that every research carries is that all the Westernized data were used to do a research. Say suppose if Indian laws needs to have certain changes, that should be brought from the data collected in India. Where if you see the post-colonial era where we are in right now, all the colonial laws actually, Westernized laws were actually made into Indian laws, especially if it comes to commercial and corporate laws. Because of that, what we have lost here is the entire history of India has been lost in commercial and trade and mercantile laws that we had earlier. We lost the entire chain of it. And there is not much research is taking place in that particular area because the funding that has been given by the government is very, very less in this area. So with that, if more of funding, the more of research that takes place in those aspects will actually improve the current legal regime that we can have an opt legislation for India. As Ms. Murli was rightly pointing out, those ethical issues that are brought from Western countries, how that can be adapted to India, that needs to be looked into, especially if it comes to SEBI regulations. And SEBI regulations, very many regulations that has been brought in by the SEBI are actually coming from the Western countries to satisfy the needs of the cross-border, commercial trades and, commerce. So I think that is where we have to throw a light on that. With this note, maybe if the chance comes again with different topics, I can speak.
Yes.
Yeah. Thank you.
Yes, of course. Thank you, Professor. Mr. Raja, coming to you, Ms. Murli did speak about vicarious liability of directors. According to you, are there reforms required in that space? How do directors shield themselves from personal liability while at the same time ensuring that there is corporate compliance?
Yeah, on that topic, I made a list of, because we sort of discussed what we should be talking about so that this does not go unstructured. So I made a list of, before we talk about liabilities, we have to talk about corporate responsibilities. What is the director's responsibility? 6 main responsibilities have been identified in addition to others. These are financial reporting and disclosure, board processes, related party transactions, compliance with labor and employment laws, environmental regulations and compliance with them, and taxation compliance. Now there are 2 ways of managing this. One is put in place better governance, corporate governance, which will ensure that there might not be exposure to any liability. Now how do you do that? So the internationally recognized methods is A, robust internal controls, B, regular training of staff and people associated with your company to ensure business, behavior that will ensure that there is no cause for any allegation of misappropriation or anything that is illegal being thrown against a company. Engaging professional advisors and taking their advice as to how do you structure the corporate governance in a company, and giving respect to whistleblower mechanisms. These are what you could do at a corporate management level. In addition to this, you must also remember that the law itself provides for certain safeguards. When you talk about directors of a company, you're talking about non-executive directors and full-time directors. As far as full-time directors are concerned, there is a huge liability on them and there is no safe harbor clause. But as far as non-executive directors are concerned, you need to show that they were aware that something had gone wrong, that there is scope for a charge of negligence, they remained negligent and therefore were liable. So the safe harbor provisions of the Companies Act ensure that as far as the non-executive directors are concerned, there is a provision that they can plead. Well, in respect of full-time directors also, you could say that this happened and this was beyond my control. Now, what are these? These are statutory safeguards. Beyond statutory safeguards, there is also something that the company can do in terms of internal management. And one is, it can create indemnity clauses in the memorandum and articles of association, which empower a company to indemnify its directors. But beyond this memorandum and articles of association indemnification, it would also make sense for the company to execute proper agreements with its directors, which stipulate that in case that they are put to any financial loss, that the company will indemnify them for that. Please understand, this was specifically prohibited under the 1956 Act. On the other hand, in the 2013 Act, there is no specific prohibition, and it is possible for companies, and in fact, any person who gets onto a board as an independent director must insist that there is an indemnification and there is an indemnity bond that is executed by the company. While that bond is being executed, the director must also ensure that it extends beyond the period of his retirement also and covers him for any charge that may be made against him after his retirement. And as Deepika was talking about, there are now P&O, the principal officers, the directors and officers, insurance that are available, which the company can take. So these are the three stages at which the directors can safeguard themselves.
Thank you, sir. That's actually an excellent point, making sure that directors agree and the company actually agrees to indemnification clauses, some very good practical safeguards. Ms. Murli, coming to you, I mean, what experts have pointed out is that we are seeing a lot of criminalization taking place. Is it important to differentiate between deliberate misconduct and mere lapses in oversight when it comes to liability of directors, and how do we ensure that?
To answer that, a practical example would be, say, the new not so new Insolvency and Bankruptcy Code, which, as some of you might have had in your courses, it is something where we have seen a lot of amendments being made to, and a lot of rules and regulations are attached to the Parent Act. Now, specifically from 63 to 66, there is something called fraudulent transactions and transactions of an avoidance nature. These are some things on which there is a lot of litigation happening at our company tribunals. Now, even in these sections, 63, 65 and 66, there is a particular look-back period given. There is a look-back period, I think, of about 2 years for certain avoidance transactions and a little bit more when it comes to fraudulent transactions. But as someone who litigates in the court and represents independent directors and companies, a lot of these are filed by the resolution professionals who are appointed to take charge of the company without any real application of mind, which leads to a huge boom in the number of judgments which come out on this subject. For instance, there will be actually no causal relationship at all to the instance of fraud that had happened to a particular director. She might have just been a director at that point in time, but even then, she would be arrayed as a respondent in these proceedings. Time and again, the law has been pretty clear that you will have to establish a relationship to show that this director was liable. They were in the know of this transaction, be it of a fraudulent nature or of an avoidance nature, and they actively participated in this, and hence they ought to be made liable. But generally, when RPs prefer these applications, these rules are given a go by, and what we see is very standard form applications being filed, and directors have to come to the court and justify how they were not even part of the board meeting in which this decision was taken, or B, they were not even in the know about these avoidance of fraudulent transactions. Just to add for another minute here, there are two principles which one could sort of find mentioned in 463 of Companies Act, which is something called a business judgment rule, which is something where a director may do something in good faith, like any action taken in good faith, which we may know from other subjects of law as well, and something called a care mark standard, which comes from a Delaware court judgment as well. Those are two things you guys can look up on understanding the genesis of why certain things have been put in 463 of Companies Act. Now, these will include certain measures for the directors to protect themselves, but again, specifically on 463, while there might not be too much active litigation going on 66 and other provisions of IBC, there is some discussion going all the way up to Supreme Court. There is jurisprudence on that.
Thank you, Ms. Murli. If we could now talk a little about the whistleblower protection regime that we have in India, or rather the non-existence of it. Professor, I'd like to come to you on that. Do we require a dedicated law protecting whistleblowers? And more importantly, is it important that this law covers both the private sector as well as the public sector?
Okay. So this so far in India is concerned, where the whistleblower laws are actually well implemented in public enterprises and industries. It has not been reached to the level of public corporates and private companies down the line. Meaning, there is no such law which is existing right now to tackle with the whistleblowers. Again, as I said in my opening remarks, we are looking at the westernized codes for the whistleblowers also, where we are talking about more of ethical and cultural implementations in the whistleblowing, where we should look into our ecosystems and cultural barriers that we have in not only bringing in this legislation, also we have to implement it effectively. For that, we must look into the Indian cultural and etho barriers that we have. Especially if you ask me what are the ethical barriers that we have and the cultural barriers that we can encounter when we bring in these kind of whistleblowing legislation. See, now in our society, you see that there is a hierarchical pattern which is existing, where I should obey what my bosses are saying. I cannot deny what they were saying. I cannot go against them. I cannot represent myself to them. That is the greatest barrier that we have. And other things, if you do it, if you look into it, the power dynamics, which is very different from that of the westernized countries in India. The power dynamic works in a different way. Now, there is a theory, if you look into, where it is written by Henry Maine. He said the power distance theory. The power distance theory, actually, the more the information that you have, the more the powerful that you become. That applies to the corporates also. So that is, the people who are having more power will be encountered with these kind of a whistleblowing. How do I, as an employee or as a whistleblower, how do I come out and say my boss is doing something which is wrong? And this actually creates a social stigma and career stigma here if it comes to corporates. The career stigma actually cripples his growth in his profession, and he will be stamped as person who won't obey to anything. And this stigma, again, it comes from the ethics that we have. And if you look into the whistleblowing, the lack of awareness among the people, which is those who actually has the information in their hand. And the awareness needs to be created. And the robust legal protection needs to be given to those people who comes up and say, and this is something which is wrong is happening in my company, and that needs to be taken into consideration. So these things needs to be first addressed, and then we should think about a law which can be brought into India and implementation of it. So that is what.
Thank you, Professor. Some excellent insight. There are actually so many cultural barriers that I think we as Indian corporate employees face. We are so differential, there's so much of loyalty to our employer that we'll think twice before reporting any misconduct whatsoever. But coming to the existing regulations that we have, Ms. Murli, we have a host of SEBI regulations. In fact, the SEBI Prohibition of Insider Trading Regulations 2015, we've had a set of regulations in 2019 as well. They also offer monetary incentives. But why is it that we don't see whistleblower reports?
So, I'll draw a corollary here. Let us look at our workplace harassment laws, which protect women. You have a specific legislation, which is the Workplace Harassment Protection, Prohibition and Redressal Act of 2013 with rules. Now, initially, you all know the genesis behind it, which is the Vishaka judgment, which Shabnam spoke about. Now, when the act came in, there was a lot of confusion on compliances, who should comply, and of course, the law is pretty clear on who should, anyone above having more than 10 employees, any 10 people working, that is. So that sets down, if you have more than 10 employees, then you must have a ICC, who should be part of the ICC, all that is mentioned in that. Now, though this law is, say, about 12, 13 years in, we are seeing implementation being done in letter and in spirit. And especially with, the Me Too movement, which took over again in the US and pretty much all over the world, we did have this act in place which covers workplace harassment. And all companies are expected to comply with it. So that is what I feel is missing, because we don't have a specific act for the whistleblowers, which is called the Whistleblowers Act. Though, again, when we had looked into this, all we could see is there was an act, there was a bill, it became an act, and suddenly there is a PIB notification saying we are not going to notify it anymore. And that notification is over a decade old. So obviously now a new act will be required. Discussions will have to be made on what could be the new act, because let's face it, times have changed in the past decade. So clearly the old bill may not work anymore. But what I'm trying to say is that, like you have a specific legislation for regulating what kind of complaints are, how to handle a complaint under workplace harassment, a specific policy, a specific act, if it is there, to sort of get into how a complaint on a whistleblower's this thing is to be handled, that would sort of go a long way. Because all you have today is, I think, subsection 9 and 10 of 177 on a vigil mechanism, and that a company is supposed to have this vigil mechanism and report it in their annual report. That is all that you have. So what is then the penalty for non-compliance? And we all know if there is no non-compliance mechanism, companies might not follow, even if they are a listed company. So it all boils down to the fact that, like Professor had said, a specific legislation in tune with the ethos of how we are as a country, especially like he said on like how we are ethically, how there is still an element of subservience and complying with what your superior says. So taking all that into account, we will have to have a specific act in place.
Thank you, Ms. Murli. If we could now talk a little about the compliance requirements that companies are now supposed to follow under the new draft rules that the Union government introduced back in January for the digital personal data protection rules. Coming to you, Mr. Raja, what do you think are the compliance challenges that companies can face when it comes to the rules?
This is a huge subject, and it's a very infant stage. And as a practicing lawyer to a whole host of young minds who are seated here, let me tell you one thing. When you start tracking emerging laws, right? You go into labor law, criminal law, civil law, it is flooded with lawyers who are practicing in that branch, and for you to make a dent in that practice and to rise in your profession is going to be a challenge. So if you are going to be prudent, what you must do is constantly track emerging laws like this data protection, because there will be nobody there, because nobody knows this law. Start writing about it, start speaking about it, start interacting with professionals who know something about it, and get to be heard. It is easy for you to be heard in the present day and time when social media can push your thought process out into the open. It was very difficult in our times, but in your times it is possible. So one of the things that is an emerging law is a law relating to data protection. I would request, how many of you know that there is a law relating to data protection here at all? Is it part of your syllabus? I'm sure that it's not part of your syllabus. Have you studied about data protection law? I'm sure many of you have. Very good. That's excellent. So that's what youngsters must do. This is an emerging law, and it is, as our moderator has asked me, it's going to have a huge impact on corporates. It's going to have a huge impact on how corporates store their data. What is a significant data fiduciary? See, there are two rights which are sought to be balanced in this legislation. One is the right to privacy of the citizen, and the other is a right to benefit from certain data which you can get. For example, I run a hospital, and let's say the hospital has 1,000 cases. The hospital administers a particular drug to a particular patient, or patients who are suffering from particular ailments, right? Now this data, which that patient, who's called the principal data, is the person from whom the data is going to emerge. Now his consent is necessary to deal with this data. So this data which you get out of that person can be used for public good if you can sort of run it through a processing unit, find out how effective it has been on some patients, why has it not been effective on other patients, what is the physiological condition that blocks this drug from being effective with other patients. This is a huge source of information which society can use to improve its processes and systems. I'm only giving you a very small example. On the other hand is the right to privacy, which has now been recognized by the Supreme Court. Of course, in the MP Sharma case and in the Karak Singh case, the Supreme Court held that there is no right to privacy. And the wonderful thing about our constitution is every right which is prohibited is also allowed. Every right which is allowed is also prohibited, right? You have a right to start a business, but you can't start casinos all over the country, because starting casinos all over the country is prohibited. So, and you have a right to life, but within the provision of right to life itself is a provision with regard to detention, right? Preventive detention. So it's very strange in the constitution that every right that is permitted is also prohibited, and every right that is prohibited is also in some way permitted. So privacy as a right was the learned judges who heard the case earlier held that the constitution does not hold out any promise for protection of privacy. But in Puttaswamy case, the constitution bench of the Supreme Court completely reversed the judgment and said, yes, we recognize right to privacy, but that right to privacy is going to be regulated, it is going to be modified, and it will be accepted on certain terms. So this is the challenge between data protection and the right of society to benefit from that data. How we regulate it is a huge challenge. As I've always said, that in India, act as a noun is very easy to achieve. You want an act to be passed, act will be passed. Parliament will pass an act, assembly will pass an act. But act as a verb is very difficult to achieve. Act, to work an act, to actually see that it is enforced, that it is implemented, is going to be difficult. This is an emerging law which is going to throw up a lot of challenges, primarily in this balance between protecting privacy and ensuring that the data that is available, which could be processed for private good, how is this balance to be done is what this law attempts to enact. We do not have many cases emerging under the provisions of the Act to see whether this Act is effective, but there must be. I will just stop with saying this. Most advanced countries will have a legislation oversight committee, which will constantly keep vigil over judgments that are passed by courts interpreting particular provisions. When there are conflicting judgments and there is a difficulty in implementing the law, like in India, do not wait for the Supreme Court to decide that issue And once the Supreme Court has decided the issue, it will decide to redecide the issue, and then it will once again redecide the issue. This process most countries don't go through, because the Legislative Oversight Committee immediately picks up the issue, has an in-depth discussion on that, and brings in amendment. That's how effective a legal regime should be. But unfortunately, in India, we do not follow that method. Therefore, it is, as the famous jurist Oliver Wendell Holmes said, the life of law is not logic, it is experience. And it is human experience that feeds legislation, right? So please do not look for anything logical in law. At your level, one simple example is 35% I get, I pass. 34 marks I get, I fail. What is the great difference between 34 marks and 35 marks? That is logic. But logic does not feed law. It does not feed regulations. It does not feed rules. So what feeds regulations are human experience. Human experience must show that there has to be some sort of a classification, and that classification will have to be implemented. This is basically what the Data Protection Act attempts to do. The challenges are interesting. I would request all of you to get engaged in the process of finding out where this law must go. Thank you.
Thank you, sir. Ms. Murli, just a quick response because we are running out of time. Do you see this increasing operation costs for companies, especially because there's also a higher penalty for bigger tech companies, significant data fiduciaries? How do you see that playing out?
Yeah. So I think from when these bills have been in discussion, there has been a lot of pushback from tech companies. And so while we do have a Parent Act from 2023, there is one bill as well of 2025, but from whatever we could see as well, there are a lot of issues that, A, companies may face, and two, there are some lacunae which the government has probably overlooked. One such this thing is what we could see was data localization. How much of it is Indian data is stored here, and what can be, in fact, taken out of the country, and whether data hubs are being created here. So that is something we see woefully absent in the Act, and we know as lawyers it can't be overcome just by way of a bill, by way of like a rule or a regulation. It will require an amendment. So with respect to data protection laws, yes, probably like, various amendments we see to arbitration and IBC Acts, this may also be an act which may undergo a lot of amendments. And we probably are a while away from having something which is something which regulates the bodies that are the stakeholders which are here in this. But at the same time, I think we are a while away from where we are today. Only on a lighter note, and because I know time's up, I remember this line from Family Man which says, democracy and privacy both are an issue in India. So I would conclude with that.
Very well said. Professor, some concluding thoughts on this before we move on to the Q&A session.
Yes. See, this as I agree with Ms. Murli and Mr. Raja, who is senior advocate. I would see this, the word you see, the significant data, fiduciary. If you see the significant, the word, it is an adjective. Data and fiduciary is a non-measurable word, meaning we are going to go to the court and meddle with these particular terms actually. And as a reader of corporate law for a decade, I see that how the drafting has been changed over the period of time. Our legislation's drafting have been changed over the period of time. And now more of an adjective has been used, more of a non-measurable terms have been used, where the judiciary has to throw a light on it. There is no other choice available where we both have to fight in the court and get a clarity to it. Thank you.
So another area of law, there will be increased litigation. Now we'll move on to the Q&A session. Any questions from the audience? Yes, please. If you could please also introduce yourself.
So myself, Sujashri, I am studying 4th year Law BA. So labor exploitation has been persistent till today. It's due to a stigma that labor investment is not that much outweighs the financial investment. So why not India follows a single board system? Why not India follows a dual board system rather than a single board system of corporate governance, so that they can give an equal representation to the labor unions and the company representatives, other than giving the most of the power to a board of directors?
Well, that may be, it all depends upon how courts are going to treat such a drastic change in the way the board is being managed, in the way the company is being managed. But more and more labor laws, I think, give some voice to the persons who work for the companies. And the thing is that it will definitely be challenged in courts, and constitutional promise that I have a right to run my business. How far is this an incursion and an invasion into that right will have to be decided, because basic form of any business is that somebody invests capital and the workmen come in as labor and they participate. There are other forms in which a cooperative movement is possible. Through a cooperative society, you run an organization where the labor is also part of the management. But unfortunately, as an experiment, it's a measure that failed. And that's why we have this corporate way of managing this. Cooperative society, cooperative movement, somebody has to write a book on why the cooperative society movement failed, because that talks about the way that you are suggesting, that the labor itself will have a say in the way that the company is being managed and the government will bring in the funds. But that unfortunately failed in the country. And since we have a precedent to show that that has failed, I don't think that's going to be replicated again.
Ms. Murli, would you like to respond to?
Not really. I think I'd pretty much go with what Sir says. But,
Yeah, this corporate governance, we had a length of discussion in the classes also with her actually. Because, this dual board system and single board system actually comes from the cultural identity of the country actually. So if you look into the Japan and Germany, it is these corporate governance models are actually cultural identity than a regulation. Because these cultural identities are recognized as a regulation, then we have absorbed it into the Companies Act. Now if you see the German, it is more of industry driven, and the industrial revolutions, World War, all those have been demanded to have a dual board system. And this dual board system is, the supervisory board will be there above the board of directors. That is the dual board system. So if that is the case, India has to go a long way to have a dual board structure here. So we have adopted a convenient single board system from the westernized countries again. So that is what I could say.
Thank you, sir. Thank you.
Okay. Any more questions, please?
Yes, ma'am. My name is Abhishek.
I cannot see you.
Ma'am, here.
Could you come a little forward, please?
Yes, ma'am. My name is Abhishek. Good afternoon to all of you on the dais. So my basic question is, should companies under the Companies Act be able to be sued by other people who, because under the Whistleblowers Act and as under Article 12 of the Constitution, which is being considered as a state, should they be able to get sued, considering that they are limiting their employees' right to freedom of speech and expression if they are not able to, be a whistleblower under the Whistleblowers Act?
I could just briefly tell you that, but one is, I think many of the listed companies do have a policy in place. So if you look at, say, your large-scale insurance companies, which, some state-owned companies as well, or even say a private company, a listed company, they do have a policy in place, a vigilance mechanism like I was discussing. So your question is, what happens in the absence of a policy, right?
Yes, ma'am.
So again, if there is a policy and if it is reported, then it will have to follow the due process. Say they report to a listing authority and the complaint is taken up, that will follow its due process. So your question is, what if there is no policy and they do come to know of any misdeed by the... So then you would resort back to your criminal avenues that are available, right? Like say you do have knowledge of a criminal act. As an employee, you do know that a director is colluding with the, with another regulatory body's employee to defraud the investors. Then while criminal avenues and of course going to the press and those are available, your question is whether any writ would lie? Is
no, ma'am. Because in previous judgments in the Supreme Court or other high courts as well. In Article 12 has been described as an avenue for different, especially in the case of education institutions and very few companies, it has been described as an avenue to go through as they perform a public duty towards the public in order to know, in order to, but they perform a duty to the public. So should there be an avenue through Article 12 for them, for these whistleblowers to express their opinions and come out to the public?
I'm not sure whether the answer to that question is yes. I would say probably still a need for a separate legislation than going under Article 12, because while there have been judgments for the past several years on interpreting Article 12, I'm not so sure whether the remedy may only lie there. And I still agree with the other panelists that it will have to be a separate legislation.
How many of you have heard of Satyendranath Dubey? Who is he? Exactly. So I'm very glad that there is somebody who knows about him, because you should all read about that, because he was the person who actually wanted to expose the corruption in the highways, the company which is doing a highways project, and he sent a complaint to the government, and the government quite intelligently bundled up his complaint and sent it to the person against whom the complaint was made. And in a short while, the poor man got killed. And it was the furor that death created that led to the awareness about the need to have a law to regulate whistleblowers. Unfortunately, even though that law has been passed by Parliament, it has not been notified. Whistleblowers, activists are very relieved that it has not been passed by Parliament, because they say that the act itself is faulty, because there is no, it only talks about government employees, and it still does not provide for the identity of the whistleblower to be kept anonymous, which is the main thing, which is the reason why that act was passed. But surprisingly, there is no provision in the act which ensures that the identity of the person who is a whistleblower will be kept anonymous. So these are the misgivings of activists about the Whistleblowers Act. That's why it's not been, so they're quite glad that it's not been notified. But what has happened, you must understand, to answer your question, is many of the provisions relating to whistleblowers have now been incorporated as regulations into the Companies Act. For instance, this case that you are mentioning, if you have a complaint and you think the company has not taken action, it is essential that the person would write to the audit committee. And the audit committee today has a whole lot of rules and regulations, and the director knows that if he is not going to address this and find a solution to the problem, he could be criminally prosecuted. We talked about limitations of director's liability, but all this does not help a director if he is going to be sued in a criminal court. So that is the answer. There is answer in the provisions of the Companies Act which will ensure that there is a solution.
Thank you. Any more questions? We can probably take one more question. Yes, please.
Good evening, I'm Tarun. I'm a fourth year pursuing my BA LLB. So I think the panel has addressed a broad range of issues relating to corporate governance and also relating to the recent privacy laws. So I just want to discuss something relating to competition law, if I can. So I think a lot of regulatory regimes have brought in new competition laws to regulate digital markets. I think the main concern there is platform markets. I think platform markets avoid liability in the sense that they call themselves intermediaries and they take a safe harbor provision which is available under many laws, like Section 79 of the IT Act as well. Now, while India wants to focus on ease of doing business, wants FDIs and all of that, how do you ensure that these platforms are also held liable for their actions?
Have you gone through the provisions of the Consumer Protection Act 2019? Do you know what are dark patterns?
Yes, sir.
So there are 13 different types of dark patterns which have been identified, which many of them would answer your question with regard to regulating competitions. This is still, once again, for all of you who think you must make a mark in the profession, under the Consumer Protection Act, this is again going to become a major area. 13 identified dark patterns, please read that. And the CCPA, the Central Consumer Protection Authority, is emerging as a powerhouse of regulating competition. and it is duplicating, it's not duplicating, it is mimicking the functions of the Federal Trade Commission in America. But the Federal Trade Commission in America is far more effective than the CCPA. The CCPA, please track what they have been doing recently, very good work. And this is only the last 2 years, even though the act was passed in 2019, after 4 years, it's only the last 2 years that CCPA has picked up energy. There's lots more that they have to do, but it's a good direction in which they are traveling. That would be an answer to the question. Please read about the 13 dark patterns and the trade in platforms and how they are regulated now.
Time's up. Thank you so much, dear panelists. This has been such an insightful session, and I'm sure all the law students in the audience feels the same way. Thank you so much.
May I now request Ms. Aratrika Bomik to present mementos to our esteemed panelists. Yes, let's have a big round of applause for all of our panelists. Thank you so much for this wonderful session. Thank you. And just give us a few moments as we set up the stage for our next discussion. Requesting our guests to kindly remain seated as we move on to our final panel discussion of the day. This one is titled, The Future of Legal Education in India. It gives me great pleasure to welcome our esteemed panelists for this session. Calling upon Mr. P.R. Raman, Senior Advocate, High Court of Madras. Can we welcome him with a big round of applause? Mr. Anirudh Krishnan, Advocate and Founder, AK Law Chambers. And Professor Dr. P.R.L. Rajavenkatesan, Professor of Law, VIT School of Law, VIT Chennai. And moderating this important discussion, let's welcome back on stage Ms. Aratrika Bomik, Senior Sub-Editor, The Hindu. So Aratrika, just give us a few moments. We're waiting for one of our panelists to join us on stage. But if you'd like to, in the meantime, speak to the audience in general, the stage is yours.
Let's just wait for Mr. Krishnan to be back and then we can begin with the last session of the day.
A big round of applause for Mr. Anirudh Krishnan, advocate and founder, AK Law Chambers. Aratrika, over to you.
Thank you so much. Welcome to the last session of the day. This is, I think, a session that would be of utmost interest to all the law students here. We'll be talking about the future of legal education in India, the changes in the legal curriculum in particular that are necessary to adapt to the evolving demands that we have. We have an excellent panel with us today. We have Mr. P.R. Raman, Senior Advocate practicing at the Madras High Court. We have Mr. Anirudh Krishnan, Advocate and founder of AK Law Chambers. And we have Dr. Raja Venkatasan, Professor at the VIT School of Law. A very warm welcome to all of you. I would actually like to start the session with a topic that has been the central most topic throughout the day today, which is artificial intelligence. A lot of questions were posed on artificial intelligence to former Chief Justice of India, D.Y. Chandrachud. We have had extensive panel discussions on it as well. Mr. Raman, if I could begin with you, how do you think law schools should prepare students to adapt to the advent of artificial intelligence and machine learning?
I think it's a bit of a trick question because in my personal opinion, the word artificial intelligence has been created to give a kind of a sheen insofar as using it in and for educative purposes. It's artificial. It's not intelligence. Well, you've been hearing today from the former Chief Justice of India, very esteemed senior advocate of standing in the Supreme Court, and a lot of people, I'm sure, would have told you that the days when, when I was in college, well, there was not, the standard of education was not too high. Now, that posed a few challenges, which I believe have probably shaped the way in which I would address an issue of which I do not know much about. I have steadfastly refused to use AI, whether it's on my WhatsApp or it's whatever. However, I did use a software called Dragon Naturally Speaking. I was probably the first one in Madras to use it as a lawyer, something like about 20, 25 years back. Now that's different. That eases the way in which you work. But this is a very dangerous tool insofar as students are concerned. I would not, for the life of me, begin to think that faculty would devote any amount of time teaching students how to use AI to learn law. Law is a very serious subject. You can't leave it to machine learning to tell you what the law is or what precedent is or which is the section which provides for the question that you have asked in a particular enactment. Now, I'll give you a very simple example. Well, I do remember from somewhere that in a document which is a testament, in testamentary jurisdiction, let's say it's a will, disposition of property, when followed by a para which says, look, this disposition is conditional, will mean that the disposition has already happened. Anything to lessen from that position is not going to hold water. Whereas in a contract, whatever is said at the end would actually make for the position which holds good in a court of law. Now, this is a very simple thing. There is a distinction. I know this distinction. Now, I don't know or I don't remember where I could have acquired this knowledge. Now, if I turn to AI and feed in these parameters, I'm pretty sure it will come up with some case law, it will come up with so many things. That is good for me because I'm practicing law. Now, I won't trust it. I obviously go back and check. But the fact of the matter is, education cannot be based on that. I would urge all students to go about it the hard way. Take your books. Learn, because the bigger challenge than being presented with matter to read is to find out where to acquire that matter. It could be under the Transfer of Property Act, it could be under the Contract Act, it could be the Evidence Act. Take all three. Point is that unless you inculcate a desire to satisfy that thirst for knowledge, by actually doing something yourself, you're not going to retain that knowledge. Therefore, I am completely against using AI as a tool for educative purposes.
Thank you, Mr. Raman. Professor, I'd actually like to come to you. You have a background in academia. Are you as pessimistic about artificial intelligence as Mr. Raman? And do you think AI tools can help with legal research?
Madam, good question. Artificial intelligence is one of the criteria where the student can collect some information. But the intelligence should not act artificially. Why? Because the intelligence will not come overnight. It needs hard work. It needs commitment. It needs sincerity. It needs dedication. Take an example. The law school in India, which started in the year of 1855, we have around 170 years of history. In that history, we have created many jurists. And those jurists, they always think brain as a technology, as a tool. Even in the courtroom itself, they have collected a lot of information and reacted. What the artificial intelligence will do, it is only the giving an information quickly. If you give the summarize the issue, automatically they will tell how they have to draft it, what all the relevant sections are there. And now you can use it as one of the criteria in the classroom, but that is not a only criteria. I will tell you one thing. If you are going to tell the student that you have to use the artificial intelligence, the student will depend upon the AI only. They are not depend upon their brain. Why? Because they tuning the brain, collecting the memory, remembering the section, it is not a easy things actually. I will tell you one thing, I think everyone knew about it in my classes also. I used to tell all my students to come up with the BARE Act and also with the book. In addition to the technology which they may use it. Why? Because if you have a BARE Act, then you can act quickly whenever the faculty handle the class. And you can use the artificial intelligence, but it should not be for 100%. I will tell you one example. For an example, first of all, the student should learn what are the existing legislation. Students should learn what are the existing information first of all. The learning process should not be dependent upon the mobile phone. I will tell you one thing. We have around 25 national law universities and also 1,200 law colleges and also the private institution. There is a survey that most of the students, they are depending upon the mobile phone. That is called as a mobile phone learning. And even they use the chat GPT. Nobody is against the chat GPT. But the only thing is that even in the chat GPT, even in the artificial intelligence, my senior advocate rightly pointed out that we should know when we have to use the technology, when we have to use our own intelligence, either to accept the technology or to defeat the technology. It will be applicable for everything. I will tell you one thing. Take an example. Recently also, we have a new criminal laws. For example, even in BNS 358, even if you go for BNSS 538 like that, if it is like around 700 section, if you tell the student that you go with the help of the artificial intelligence, no student will remember and recollect the section. No student will effectively argue the case before the court of law. For an example, I will tell you, even using the artificial intelligence also depends upon the which subject you are handling, which domain you are. For an example, if I am from information technology student, because I devote my studies in the information technology. Your profession itself is a legal profession. If you want to be a noble in the legal, but you should not depend upon only the technology. And one more thing I will tell you. Nowadays, what the process is happening, because normally everyone they are asking that whether, as far as the future of legal education is concerned, the future is depending upon the only the technology or not. Why? Because many of them they are speaking that the technology is the major criteria for betterment of legal education. But my view is that that is not. But that is one of the criteria, but that is not a only criteria.
Thank you, sir. Mr. Krishnan, what are your views on this? Do you think concerns regarding originality in academic work can arise especially?
Yeah, I think AI can supplement legal research, but it is very dangerous if AI is the primary source of legal research. Now, if students use AI, AI provides a direct solution. It provides a direct answer to a question. What does this prevent? It prevents reading of commentaries. It comes in the way of reading case laws. Now, reading commentaries and case laws is essential for any student for many reasons. First, you need to understand the march of the law. Now, for you to understand the legal principle, it's very important to trace case law from the first case law on the point till the last case law. You will find loopholes in between. And it's very important to understand basic concepts. Therefore, the march of the law is very important. Second, when you read a case law, you may be searching for a case law on a particular proposition. If you go by AI, AI might directly say this is the proposition, this is the case law. But when you search for case laws on that proposition, you are reading multiple case laws which discuss many other propositions. As a student and as a young lawyer, it is important to build your database of propositions and case laws because you don't know when it will come handy. Tomorrow you're dealing with a case, you will know that you've read this proposition somewhere, you'll broadly know where it is and then you can go and search for it. But if you're not aware of the proposition at all, you're going to be lost. Therefore, building that database of propositions and case laws is critical, and not reading case laws, not reading commentaries will come in the way of that, secondly. Third, if you need to have the skill of distinguishing a case law, you must know how to read a case law. If AI gives you the direct solution and you have not read enough case laws, you develop the skill by reading thousands of case laws during your law school and your early stages as a lawyer. If you have skipped this stage, it's a very important stage of development. Therefore, I am of the view that AI certainly can supplement. So, if I am a student, what would I do? I would still stick to reading the commentary first, writing down from the commentary the various case laws on that proposition, pulling out those case laws, reading case laws cited in those case laws, and then use technology to supplement this. I will search for case laws that follow these case laws. I will also then do an AI search to find out any additional material on all of this. But if you directly go to the last stage without the commentary and the next stage of reading case laws, that's an important stage of development. And lastly, when you read case laws, you look at innovative arguments that have been made. Now today, as a lawyer, when you need to put forward a new argument where there is no decided case law, you need to have seen similar arguments being made in the past. Let me give you an example. The famous basic structure argument of the renowned jurist Mr. Nani Palkiwala. You will find an argument that is about 70 or 75% similar made by Mr. M.K. Nambiar in Golaknath. Now, today this is how law develops. You read the earlier case law, you see something there, and then you innovate on what is already there. Now that AI will come in the way of all of that. Therefore, please use AI as a supplementary tool, not as a primary tool.
Thank you, sir. Professor, I'd like to come to you. What do you think is the future of legal education in terms of making sure there's confluence of other subjects as well? Do you think an interdisciplinary approach is the future?
It's a good question, ma'am. Actually, nowadays, even the University Grant Commission, and also even if you are in engineering field, All India Commission for Technical Education, Council for Technical Education, they are concentrating more on interdisciplinary and also multidisciplinary. That is what normally the people used to do. Take an example, I am basically from legal background. But if I have a science background, I can excel in intellectual property rights. And if I am having a legal background, if I have 1 or 2 degrees, because many of them they are coming from after engineering also they are coming, BTech then LLB, they can excel in the various fields. And nowadays, it is not like only the conventional system we have, like a traditional system. Once upon a time, even in Tamil Nadu, this is the situation. Whatever the subject you read, it is maybe in international law, constitutional law, criminal law, property law, and contract law. There are 4 or 5 subjects. After 2012, even in Tamil Nadu, but there are around 14 subjects. Take an example, air and space. Take an example, law, science and technology. Take an example, space law. Take an example, cyber law. Nowadays, speak about law and sports. Like that, there are multidisciplinary. Now, the question is, how you will use the multidisciplinary. It depends upon how you frame the syllabus, first of all. Take an example, the person who is always interested with the framing the syllabus should know that how they have to frame the syllabus. I will tell you one thing. There are institutions in which the syllabus will be framed by the particular person. Now the question is whether the particular syllabus is really standard or not. Normally there is a probes. A good teacher will never ever complete the syllabus. Why? Because completing the syllabus, it should not be too much. Because I should not concentrate more on history. Otherwise I cannot create a history. Rather, I have to concentrate more on theoretical aspect on the one side, practical aspect on the other side, how the student should apply their mind in the name of clinical legal education. Take an example I will tell you. As far as the future of legal education is concerned, the people are always talking about theoretical thing. But that is not a case. For an example, there was a survey, I will tell you ma'am, while I was handling the criminal law subject, 90% of the students didn't see the police station, didn't go to the police station. Didn't go, for 50% didn't go to the, I'm telling about all of us, didn't go to the court, didn't know the court that how the process is all about. But telling them to study only the books, it's a waste of time. We have to permit the student to go out and see what the real world is all about. Because without telling them the real, what is the real, for an example, if I am an academician, I should not give 10 to 20 assignment or 5 assignment by saying that, you complete this assignment and submit it, for this there is a mark. Even if it is a one assignment, you tell the student, go there, even take 4 months or 3 months, do the research. It is not like a theoretical research I am talking about it. I am talking about the research like an empirical. It's not like one person should do. Even 2 students, 3 students, 4 students should join together and see that which field in which they are interested. Normally the people can say, even the morning which I am telling about it, they are saying that we have to identify, we have to track that where we have to get an opportunity, where we have to get an employment, where we have to get a job. If you want to be a successful lawyer in your field, at least you should know 10 to 20 subject minimum. For an example, if I am an IP lawyer, I can talk about copyright, I can talk about the infringement of copyright, I can tell that section 63 and 51 is an offense infringement. At the same time, I should know the criminal law also, that under which law, under which section, and I have a power to take a cognizance as a judge. If I am purely on IP perspective, I should know theoretical perspective and also practical perspective. And one more thing, ma'am, as you rightly pointed out, and the future of legal education, it is not job oriented first of all. Because the people used to choose their legal field, it is only for society oriented. And many of them, even because it's a universal fact, whoever comes to the law school, any law school, wherever you go, they ask the first question, is there any placement? Is there any placement? The point here, They're forgetting themselves that if they work hard, it is up to them. Nobody will compel them. They go for practice, like a litigant lawyer. 10-year concentrate in a case study perspective rather than the theoretical perspective, they can get more than what one employee is going to give to them. And one more thing, there is always an issue by saying that 70 subject, 80 subject. Whenever there is a competition between two universities, one university will see the syllabus of another university and adding 4 or 5 subjects by saying that this is a new. Actually, that is not at all new. You take any law, foundation will be old. I will tell you one thing. And if you want to strengthen the legal education, first of all, students should understand something in the regional language. Take an example. Our senior advocate is here. He is doing a lot of things in Tamil, and he is also having a magazine in Tamil. Why? Because the people who understand whatever the case comes in Tamil, but he should be always efficient in English and their respective regional language. The true and also the exact information of the particular case, we can cherish it. But that is not happening, I will tell you. And the student is, not all the student I am telling about it. Percentage may be less. The student always thinking about it, how the future of legal education, how we have to settle. Rather, the student should think that how they have to equip themselves, because it cannot happen one day. You ask with any senior lawyer, I think our senior advocates knew, even in the practice, you will never ever excel in a day. It will take 10 years. It will take 15 years. And it will take 20 years also. Even in a legal field, after 25 years only we will know, even if we don't want money, the people will come and approach. Why? Because if you search the knowledge, money doesn't issue. And then money will search you by saying that where you are. But as per the future is concerned, when we are discussing a future of legal education, that itself is very pathetic. Why? Because there is no end to the legal education, ma'am. Thank you.
Thank you. So some very valid points made, especially because, I mean, right after graduating, if you were to go into litigation, you won't get the luxury of specializing. That much comes much later. So to have that grasp on all legal areas is very, very important. Mr. Raman, I would like to come to you. Do you think that law schools should focus on making sure that law students are taught more by practitioners?
See, to give a flavor of what is actual practice, I genuinely believe that law practitioners would probably be in a better position to impart certain skill sets. It need not be purely theoretical. It could be in the realm of ethics. I'll tell you very frankly, see, this is an occupation which pays. Now, as students, you should also be curious. Now, tomorrow if a client comes and says, listen, I have a problem and I'd like you to handle this for me, you are expected to charge a fee. The conduct rules of the Bar Council of India says, please charge a fee. Point is, how do you go about it? Now, these are all very simple things which might come naturally. But it's always good to have some knowledge about how this goes about. Another area where I would believe that experienced legal professionals could help is, of course, areas where, particularly in litigation practice, how do you conduct yourself? How are you expected to address court? How are you expected to prepare, for example, let's say a conference where you're briefing a senior counsel, an arguing counsel. What are you supposed to do? Now, I do not know whether your current curriculum would cover areas like that, because one of the key takeaways would be, when you go into a conference, the person who you are going to engage is probably a little more or far more experienced than you. Decisions would be taken at that stage to pursue a course of action or not to pursue a particular course of action. This case for which you are going there could be at some interim stage. Now, if you have not made a note in that conference as to why that decision was taken, this particular matter will come up for final hearing with you having 10 years under the belt. You would not even remember why I did it. These are all certain nuances which ultimately provide for a professional way of going about your work, a systematic and efficient way in which you can safeguard yourselves. One of the first things that I was taught, at least, is your worst enemy in your profession is not the lawyer opposing you or the client of that lawyer who's opposing you. It is your own client. It's important because, see, experienced practitioners, we know there will be one question that is asked which will stump you. And the client would probably feel that, things are going out of hand and why did this happen? I'm sure there are so many naysayers who are going to advise these people, look, this is what went wrong in your case. These are all little things in which probably legal practitioners would be able to impart a sense of confidence in you when you actually go out into the open. So I am not advocating for a moment that legal practitioners should be engaged as regular, or rather be given the work of regular faculty, because regular faculty is structured. They know where to start, where to stop. Legal practitioners never know where to stop. They only know where to start. So to answer your question, yes.
So actually on that note, so under the BCI rules, full-time faculty members are not allowed to practice. Do you think a reform is required? Especially because the NLU consortium back in 2019 had actually passed a resolution to this effect.
No, I feel that regular faculty being allowed to practice is a very positive thing. The reverse may not necessarily be true, which is why I said legal practitioners should not be given the actual work that faculty do, the actual curriculum which a faculty member is expected to impart over the course of a particular term, because he will mess it up. He's got other things to do. But the reverse, yes, I fully support it. They must be allowed to practice.
Thank you, sir. Mr. Krishnan, coming to you, I think one of the most common criticism that we see is that law schools focus on rote learning. Do you think the curriculum, the questions, they should be more application driven? What are your experiences?
See, I think a mix is important. I am not a person who believes that there should be no rote learning at all, because there are two things that a lawyer needs to know. First, what is the law, which is most important. And for that, you can't be in the air all the time. You will need to know, well, if you are dealing with a specific relief act, you will need to know what is the provision dealing with readiness and willingness, for instance. So knowing what the law is paramount, and that comes first at the undergraduate stage, where a certain amount of rote learning is inevitable. But when you go from the undergraduate stage to the postgraduate stage, that is where it needs to become entirely application based. For instance, when you look at courses abroad in Oxford, Cambridge, etc., you will have very few lectures at the postgraduate stage, and you will have more tutorials and group discussions, where for a group discussion they will give you a proposition, they will give you reading materials. You read all those case laws, all those articles, and you come, and then there is a debate based on that. Now, at that level, they don't go into what the law is. They go into why the law is that way. Or how do you interpret the same case in two different ways. Now, these are also important, but you will not be able to get to this stage without knowing what the law is, for which rote learning is important. Therefore, it's possible to say that maybe at the postgraduate stage, we can shift more to an entirely application-based approach, but I think that finding that mix is very important. Otherwise, it will become like the proverbial four blind men describing an elephant based on which part they touch without knowing what exactly there is.
Thank you, sir. I would also like to talk a little about litigation as a career prospect, especially because we have so many law students here in the room. We don't see law students pursue or want to pursue traditional litigation anymore. how can we incentivize them to do so?
See, what happens is that there is a, when Professor was talking about placements. Now, when you go for placements, you have the corporate law firms that offer possibly 3-4 times what the litigation firms and the traditional litigation offices will offer. And in a corporate law firm, for every 10 corporate law transactional job, you will have 1 litigation post that comes up. Now, initially, that lure is there. In a lot of cases, there is genuine financial need. I'm not belittling that. But the difficulty is, once you're in that system, even if you want to litigate, it's difficult. You need to come out at the right time. If you stay there 7-8 years and then want to come out, you spend too much time in that system, too much time developing another level of specialization, and then it's difficult to come back and become a more of a generalist or to step into a litigation, because you develop a lot of skills in the first few years as a litigator, which you cannot miss out on. So I think what is required is for students, well, you want to go make your money, do it for the first 2-3 years, build your bank balance, and once you are financially secure, come back, but come back within, say, 3 years. It also requires a lot of mentorship, because for students without any background, without any family in law, may feel that making it is difficult. There is a long wait period before you really make it as a litigation lawyer, and during that wait period, you will earn significantly less than your friends and peers in corporate law firms. But once you get past that wait period, I don't think there is any comparison. As Mr. Raman was mentioning, it's an occupation that pays. So I think that mentorship and that assurance to young lawyers that wait it out few more years and you can really make it is something that is important.
Thank you, Mr. Raman. I would actually like to come to you. From your experience, how can we encourage young law students to pursue litigation, and also more importantly, how can bar associations or even the judiciary help to make sure that for young lawyers, litigation is a viable profession?
See, I think most law students would probably have attended some amount of counseling before they joined law school. Now, you might have had some preconceived ideas about what you want to do as a lawyer, whether you want to do corporate practice or whether it's a stepping stone for you to study more and then get into some other field, or perhaps you were always born with that gut feeling that I want to litigate. It is not a choice which others can guide you to do, but definitely provide a platform for, yes. The platform begins, for example, now I have a grievance. Courts are not allowing students that easily to come in. You have a problem, you have security measures in place. You can go to the lower courts, yes, but not to the high courts or the Supreme Court. You have to go in batches. You can't go as you wish. I'm sure you have probably enough a faculty to take you there and then make the pass and do all that, but it is a process. Us, in our time, for example, the High Court here in Madras was walking distance from our college. At any point of time, something we read in the papers, something very interesting, some constitutional point, something to do with the elections, assembly, etc., we would just walk into the court. We would see stalwarts battling it out. It left a huge impression on us. On the days when you were taken to court, you might probably, I wish you well, but these kind of battles don't take place every day. Every day, if you go and see something, you might not even understand what's going on. This is where I find that there could be a help, a push, to see that access is easy. I was talking to my junior colleagues in the office as to whether students are allowed in the online viewing. I was told it's not very easy. They will have to disclose, they have to get permission from the registrar, etc., 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 which is also cumbersome. So how will you have a taste of what it really means to stand up in court and argue your client's cause? That thrill, I can tell you, your corporate practice cannot match. Legal practice, what it pays, in terms of the first phase till liftoff, you cannot match corporate practice. But there is a balance, as Anirudh points out. Now, where probably the BCI has been doing good work, I'm not saying no. They have been conducting learning courses, they've been doing a lot of things. But what I find is the BCI itself seems to be in a bit of a quandary. I was just coming across a notification issued by the Bar Council of India last year, complaining about the mushrooming of law colleges. The problem is that when you want to start a law college, you go to the the Education Ministry of the state concerned. So the Higher Education Ministry first, let's say, gives you permission. Then you go to the university, get your affiliation. And only after that, the Bar Council of India comes in. By that time, infrastructure is built, investments are made. So what does the BCI have to do at that point of time? They can only come inspect and probably give you some a heads up on what is wrong, what needs to be done. I think there is a need. I think perhaps you're going to touch that topic again, but point is, I think there is a need for a unified body. This consultative process between the UGC and the BCI, I think, will work better if it's a unified body and lots of heads are put together before an institution is started. After an institution is started, it is practically impossible to shut it down. Even with violations, even with so many misgivings on how much staff is employed, whether students are coming or not, what is it that the BCI can do? So these are all issues pertaining to powers of the BCI, and it's a statutory body, so something has to be done. This is what I feel. But the point is to incentivize students to become litigators. The question also arises, don't we also need corporate lawyers? Of course we do. So it's a Hobson's choice. So you need to make up your minds, and to make up your minds, all of this exposure is brilliant. Come to court, see all this happening. Or if you want, you can go to a corporate law office and see. It might be a bit boring compared to what happens in court. But there is a thrill in that. If that's what suits you, good. So point is, today I am told that students are having apprehensions about getting into practice for a variety of reasons. It is physically taxing. It is probably something which you would not have imagined that you're going to be put through with the coat and the gown and the summers and all the heat and everything, running around carrying books. But there is light at the end of the tunnel. I can promise you that. I can promise you that. And to incentivize you to do that, the first thing that has to be done is access to court halls must be made free for students. It's very important.
Thank you, sir. I would actually wanted to talk a little more about the limitations of the BCI and whether we require a separate regulator. But we're out of time. I'll just hand it over to Professor. Sir, if you could just also tell us if exposure to legal aid could maybe help students develop an interest for litigation, exposure to practical realities.
Yes, ma'am. As far as the legal education is concerned, let us take our university, VIT School of Law. Periodically, we used to do the legal aid. We used to tell the student to go to the nearby places, to mingle with the student, and also mingle with the community, and also the downtrodden people, and also the needy people. And there are issues. For an example, if you go to one village, there are 1,000 issues comes. Take an example, sir, we are living in the particular area, we don't have any pata. Many senior citizens, they are saying that our kids are not taking care of us. And also they are telling many benefit, the government benefit, it's not coming. Few of them are telling, sir, the crimes against human cases and all, sir, High Court it is pending for 10 years. Sometimes the district court it is, like more than that. We don't have any awareness. What we do it from our schools, and we used to invite the judges, we used to invite a practicing advocate, we used to invite an academician and those who are in the field, tell them practically with the help of the district legal authority that how they have to solve the issues. Even many students, they are coming forward and they are doing it. I will tell you one thing, ma'am. Even as a teacher, I cannot advise as I like. For an example, I am handling around 4 subjects. What I will do, if I want to tell the student, there is a process called Monday petition. In Tamil, they used to tell Kurai Dirkum Nan. I will go as a common citizen and look into that, what is the step-by-step process. Even if you go to the collector office, how we have to file the application, in which place it will go, when the petition to whom, when it will go to the DRO, when it will go to the Tahsildar, when it will go to the Deputy Tahsildar, then when it will go to the Revenue Inspector, RI, then finally where it will go to Village Administrative Officer. Like that, there is a step-by-step process. Legal aid, it is a real instrument where we can help the needy. That is what we are doing it from law school also, ma'am. And also it is an opportunity to student to learn practically how we have to face the client, how we have to face the society. That is because even in our law school, we have started in the year of 2014. The first legal aid in the year of 2014, we had it, and 2014 and 15 in a place called nearby Sengalpattu, because we went to the Tirupur and other places, where a lot of issues, not only in one legislation, around 10 to 20 legislation, we can learn it in one legal aid, only one legal aid. Nowadays, there are so many complaints, particularly for an example, the senior citizen complaint. And one more complaint comes because as per the city is concerned, there are 2 issues. One is rent control issues. Another one is they are residing in the particular place, they don't have any pata. Our student used to tell the simple advice by saying that if you don't have any land, you can apply to the government so that they will give 30 cents. Likewise, practically, it is not easy also to give the advice. We have to update ourselves. We have to seek the help of our legal aid team, and also the student also used to prepare well in advance. Periodically, we used to prepare the report also, that, and also we will know and well in advance and go to the particular villages also, and also ground reality will do that what are the issues which they are facing it.
Thank you, sir.
Thank you.
We'll open the floor for questions now. Any questions?
Good evening. Good evening, panel. My name is Avantika. I wanted to know why there is this gap in our legal syllabus. For instances, subjects like jurisprudence. For instances, subjects.
Yeah, we can hear you.
For instances, in subjects like jurisprudence or Indian legal system, we have concepts like dharma. And whenever we talk of philosophers, we talk of people like Manu or Kautilya. We never talk about people like Thiruvalluvar or even the post-colonial pioneers of movements like the self-respect movement. And when we are talking about incorporating AI into our legal system, possibly so, wouldn't we essentially increase the cultural bias that is already in place without rectifying the very little issues such as this in our already existing system?
Mr. Raman, would you like to respond?
Well, actually, let's say about 100 years back, legal education included Roman philosophy. So Roman law was studied. I didn't study Roman law. Yes, writings of Manu, old Hindu law, all of that was taught to us because there was a significance in terms of how courts interpret that law. So when there is, let's say, a vacuum, they try to go back and see what was the previous position of law. What you're speaking of is that, for example, Thiruvalluvar's work, it was probably taken into consideration in systems of law and courts very, very many years ago. So the significance of studying that, I do not know whether it is of use to a person who is learning law. So the other question is AI. You are absolutely right. AI is going to increase the bias And our earlier systems, the oldest systems of law and reliance on learnings of our ancestors is going to get lost. I agree with you on that, which is the reason why I do not want you to go to AI at all. Thank you.
Yes, please.
If I can add to that, when you look at jurisprudence, you look at principles which explain propositions of law. Jurisprudence helps you understand the why behind the law. And it is those principles and those philosophers that you usually study. I'm not an expert in framing the curriculum. Like for instance, Austin, law is the command of the sovereign. Directly relatable to you construe a tax legislation strictly because it's the command of the sovereign. You look at sociological school. Law is social engineering. Right? The directly relatable principle, when you construe a welfare legislation, you look at the object and you beneficially construe it. So there are various theories of jurisprudence are directly linked to various propositions of law, and usually it is those philosophers who you study whose theories have been used to develop legal principles. Another great example is the theory of Grund norm, and whether the basic structure of the constitution itself is the Grund norm from which everything else emerges. So there I think jurisprudence really helps, and the focus while framing a curriculum is perhaps on those philosophers whose theories have helped develop legal principles of this nature.
Do we have any more questions? Yes, please.
Good evening,
Could
sir.
you come forward a little?
Good evening, sirs. Considering the fact that legal education is not just a mere privilege for the law students, when it comes for whole India, all the citizens of India are supposed to learn has to have legal aid or legal education. And how do we promote legal education to the whole citizens of India? And my second question is that if we promote legal education in India, how will it affect the future Indians, and how will it improve the jurists in the future?
Yes,
I think probably this is a question you'll have to address Fort St. George. Point is, we can only practice law. You want to educate across the country persons who are probably not that educated themselves as to their rights. Yes. We want to teach them law. The problem is a little knowledge is very dangerous. So, how to propagate knowledge which is going to be useful to the common man so that he can understand his rights, his basic rights, his fundamental rights, is something which, government policy should be looking at. I don't see a role for a lawyer in that sphere for the simple reason that as a body, maybe as a body, the Bar Council of India, or perhaps a whole university or a group of universities can carry out such programs. But there are so many other good things to do. People know their rights. We are a very litigative country. There is enough litigation.
And I think your question also is on the reach of legal education to the various parts of India. Now, one thing is today with the video conferencing facilities and everything being available on YouTube, a lot of lectures can be delivered by people who are specialists wherever they are, and it can be seen by students across the country. And recently there's an endeavor where the Justice Anand Venkatesh, working with the the education department of the state of Tamil Nadu, was of the view that that commercial laws are not really covered in the government law colleges. Therefore, he had reached out to couple of us, my colleagues and I, to do a series of lectures, and now every month there is one lecture in a different government law college covering a different aspect of commercial law, and the government has made it mandatory for every other government law college students to be present. All of these happens on Saturdays. They have to be mandatorily present in their college auditorium, and it is screened through video conferencing across all government law colleges in Tamil Nadu. So right now we have finished covering arbitration, Commercial Courts Act. Now we are moving on to the Insolvency Code. So the idea, it's a start, but I think this video conferencing can be used to reach out to people in the nook and corner of the country.
Thank you. We have time for one more question. Yes, please.
Good evening to the distinguished guests. My question is, in this age of technology and artificial intelligence and other things, and increasing interest in the corporate field by various law students, is there a diminishing trend for the inclusion of social sciences in the study of law? Because without knowing the social background, one will not be able to understand the ground reality, and without understanding the ground reality, application of law will not be possible in a very effective and imperative manner. So is there a diminishing trend for the study of social sciences included with law?
As far as law is concerned, it is inclusivity and also accessibility. No one can compel any student that you have to study this subject. It is free for them. They can choose any subject. That is the reason why in the law universities and all the private universities, they have a different subjects. For an example, in our VIT School of Law, we have an elective subjects. Whoever wants to choose the particular subject, they can choose. That is called as a fully flexible credit system to give the flexibility to the student to choose it. Nothing wrong. For an example, more than 90% it is not about corporate cases. But if the student wants to pursue the corporate law, that is their freedom. But what we have to do, normally we used to identify, invite the people who is in expert in the particular field to come to the law colleges and to deliver a lecture. Take an example, teacher cannot be a master of all the subject. The teacher can be a master only in a few subjects. For an example, whoever is practicing in a court, because they are a real master, they know what all the issues are there. We used to invite them and we used to request them to deliver a lecture. That is what we are doing it. And it's, as far as the corporate field is concerned, just because something is blooming, it doesn't mean that other subject and other area also will be diminished. It will never ever be diminished. Thank you.
That brings us to the end of the session. Thank you so much, dear panelists, for your time and excellent inputs.
I now call upon Ms. Aratrika Bomik to present mementos to our distinguished panelists. Can we have a round of applause for all of our panelists? And for our moderator, Ms. Aratrika Bomik. Thank you so much. I now call upon Mr. A.R.L. Sundaresan, Additional Solicitor General, High Court of Madras, to deliver the valedictory address. Can we give him a big round of applause?
Respected elders, all the professors here, and the young and energetic law students. Good evening to all. I thank the Hindu and VIT University, especially Thiru Suresh Nambar and Dr. G.V. Selvam for having invited me and for having given me the opportunity to participate in such a grand function where all the stalwarts in the institution have participated today. The topic, Justice Unplugged, where the Hindu and VIT University have plugged themselves together and have conducted a fabulous event with almost the best available participants in the field of law. Two organizations of repute, the Hindu, which was established in the year 1878 as a weekly newspaper, which subsequently became a daily newspaper in 1889, with more than 135 years of standing, and VIT University, established in 1984 with the motto, a place to learn and a chance to grow, with about 2 lakh students or so on their campus, have come together to conduct this seminar, Justice Unplugged, where the law meets the future. When I was contacted and a request had come that I should participate in the event, I said, yes, I'll participate either in the morning or in the evening. But I was not sure about the other participants. But then, after I saw all that in the newspapers and the invitations, I congratulated myself for having accepted the invitation, because otherwise I would have missed the opportunity of being amongst the gathering where before me such stalwarts have been there. I thank the organizers once again for having given me the opportunity. Just see the galaxy of persons who have participated today. Hindu and VIT together have done so much to make this happen, and they deserve to be congratulated. The students of VIT could not have asked for anything better. Two former Chief Justices of India, a well-reputed senior advocate from the Supreme Court who practices almost in all the high courts, Mr. Arima Sundaram, 3 senior advocates practicing with rich experience in the Madras High Court, 5 advocates from various disciplines of law practicing on all sides in the High Court, 8 professors, all of them have participated in the first 2 sessions and the 4 subsequent sessions. And bringing all them together under one roof on one day is something which nobody can imagine. It was well done, and I think in the valedictory speech, it is my duty to applaud for all that and see that VIT carries it forward with Hindu plugged together all in the future also. Legal education, as it was when we studied, and what it is today, and what is necessary for the future, there is a far difference between all this. The numerous new laws, specialized tribunals dealing with new areas of disputes, new laws relating to customs, taxation, environment, commercial disputes, arbitration, IPC, etc. And there has been advent of new technological advancements, and the deep impact of artificial intelligence. All this requires that the institution should update themselves and the students should update themselves. We lawyers who are practicing with some experience, we have to update ourselves so that we stay afloat. But quite different, the students who are studying now, they have the opportunity now itself to learn about that. The institutions have updated themselves already and they are educating the students in such a way that when they come out of the institution, they will be a well-developed lawyer, updated with technology and updated with AI. Therefore, what we did not have, you are all fortunate to have now, and all that is made available to you by institutions like VIT. But one thing has to be kept in mind. A lawyer, in the true sense, should not become over-dependent on technology or AI. His brain is his think tank. The knowledge which he has and the first impression which he gets about the case and the thoughts which come within him, that will only help him. AI can be to aid and assist you, and technology can, instead of going to the books for the physical copies, you can click onto the mouse and then you can open the journal, you can see it. It helps you in that way. But then, what students should always keep in mind is that whenever some client comes to you and talks to you about a case, suppose he says, I have an agreement for sale, I want the property to be sold to me, but the vendor is not coming forward, don't immediately go to the computer, don't immediately go to the case law, don't do that. First, grasp the facts. Then see which is the law which will be applicable. Thereafter, if necessary, go to the case law, go for AI, go for technological advances, etc. Therefore, don't forget that you will have to first concentrate at the grassroots level only on the facts, the client, the law, and then go for that. But at the same time, you can't keep yourself away from AI or technological advances. There is a balance that has got to be maintained. As days go by, you will know where to draw the line. And that is what the institutions and the offices in which you may join, they will have to train you and mentor you and bring you up so that you don't become over-dependent on AI. At the same time, you don't stay far behind, not knowing how to use AI if the occasion arises for you to use AI. Therefore, that delicate balance has got to be learnt and delicate balance has got to be applied. Now, coming to the event which has been organized by Hindu and VIT, I understand that the purpose of this conclave was address critical and timely issues arising at the intersection of law and technology with specific focus on challenges and opportunities presented by AI. Foster a dynamic and insightful dialogue that moves beyond traditional legal discourse confined to courtrooms and statutes. Equip and prepare the next generation of legal professionals to effectively navigate and address intricate challenges posed by rapid technological advances and evolving social reforms. The conclave, Justice Unplugged, Shaping the Future of Law, has brought together distinguished legal minds to explore the evolving relationship between law and technology, with a special focus on artificial intelligence and its impact on legal doctrines, privacy, ethics, business regulations. The event has provided a platform for insightful discussion on the challenges and opportunities in modern legal landscape. The panel discussions of the conclave have focused around 4 themes. The first one being intersection of law and technology, AI, privacy and ethics. The intersection of law and technology, particularly in the realms of AI, privacy and ethics, presents a complex challenge and opportunities. AI-driven decision-making raises concern about accountability, bias, and transparency, necessitating legal framework to ensure fairness and non-discrimination. As technology evolves, legal systems must adapt to safeguard fundamental rights while fostering technological advancement. As such, this topic chosen was the need of the hour, and the panelists who participated there were the best in the field. The next one, role of law in changing society. Law plays a crucial role in a changing society by providing stability while adapting to new social, economic, and technological developments. It serves as a framework for justice, ensuring individual rights, resolving disputes, and maintaining order. As societal values evolve, laws must respond to emerging challenges such as digital privacy, environmental protection, human rights. Judicial interpretations, legislative reforms, and policy decisions help to bridge the gap between the tradition and modernity, ensuring the legal system remains relevant and effective. Ultimately, the law acts as both a guiding force and a reflection of societal progress, shaping and being shaped by change. The panelists who have participated in this session are crusaders of human rights and environmental protection. The gathering could not have asked for better representation in that panel. Next one, corporate law and business ethics, navigating legal complexities. Corporate law and business ethics are essential in navigating the legal complexities of modern business world. Corporate law establishes the legal framework for business operations, covering areas such as governance, compliance, contracts, and mergers. Meanwhile, business ethics ensure that corporations operate with integrity, balancing profit-making with social responsibility. Issues like corporate fraud, insider trading, and environmental responsibility require businesses to adhere to both legal regulation and ethical principles. Navigating this intersection demands a proactive approach where the company's integral legal compliance with ethical decision-making to build trust, mitigate risks, and ensure sustainable growth in a competitive global market. Here again, you could not have asked for better persons than the members of the panel. Next one, future of legal education in India. I was fortunate to be here for a better part of that session. The future of legal education in India is poised for transformation driven by globalization, technology, and evolving societal needs. With the increasing emphasis on interdisciplinary learning, law schools are integrating subjects like AI, cybersecurity, and environmental law into their curricula. Use of digital tools, online legal research platforms, and AI-powered analytics is reshaping legal training. There is also a growing demand for experimental learning through moot courts, legal aid clinics, and industry collaborations. Regulatory bodies like BCI are pushing for reforms to enhance practical skills and global competitiveness. As the legal profession evolves, India's legal education must adapt to produce lawyers equipped for a dynamic and technological-driven world. The panelists in that session have answered so many questions and have educated the people here as to what is legal education now, what it has to be for the future, and what it had been in the past. And I'm sure that it will be very useful to make the present students as complete lawyers to face the world in future. In fine, I would say that the conclave, Justice Unplugged, Shaping the Future of Law, with the participation of jurists and legal professionals in a meaningful discussion on the evolving legal landscape, with emphasis on the impact of AI, privacy laws, corporate ethics, and legal education, have highlighted the urgent need for adaptive legal frameworks that balance innovation with fundamental rights. The insights of the esteemed dignitaries has reinforced the importance of proactive legal reforms and ethical considerations in shaping a just and technological resilient society. As the law continues to intersect with rapid advancements, such platforms remain crucial for steering the future of legal discourse, practice, and education. There are many positives that the persons who have participated here can take away from all the stakeholders from this conclave. From the beginning till now, all that you would have heard is something which you would not have been able to grasp within your classrooms. There may be one lecturer, two lecturer, there may be a few subjects, there may be visits to various towns or Mofussil areas where you meet the people, but then bringing all these stalwarts from various parts of the country with such rich experience and making them speak before you is something which this conclave has achieved. And all of you should be very thankful for this and this memorable day where all the stalwarts were before you. Before I conclude, I would say that as a student, what I am today or what little I am today is because of what I grasped from my school, St. Michael's Academy, my college, Madras Law College, and my father's office, where I was an intern when I was in the college. When I had become a graduate, my father had become a judge, and therefore I was not actually practicing with him, but I learnt in my school, in my college, and in my father's office. And the real thrust in my mind that triggered me to become a lawyer was, I think, in class 8 or class 9. For the first time at that time, civics was introduced as a part of history. And my civics teacher, I remember her even today, Mrs. Bala Tyagarajan. She is the one who exposed me to constitutional law. And what constitutional law, little bit in civics, the elections, legislature, parliament, what was taught to me, that put in my mind that I should become a lawyer. And I thank my school and my college and all my professors for what they have made me today. And I think that for any student to look forward with confidence, they will be able to do it if they have the same bonding with their school, their college, and their professors. The professors are the ones who make us outside the home. Inside the home, it is the parents who shower the love and affection to us. Outside the home, it is our teachers who make us, and it is they who give us the confidence to face the world. I thank all for giving me this opportunity. Thank you very much.
Thank you so much, sir, for your insightful address. May I now request Mr. L.V. Navneet, CEO of the Hindu Group, to present a memento to Mr. A.R.L. Sundaresan. I believe Dr. G.V. Selvam also has a special memento that he would like to present to Mr. A.R.L. Sundaresan. So requesting you to come forward and please do the honors. May I now invite Professor Dr. Abhiraj C., Professor of Law and Dean, VIT School of Law, VIT Chennai, to please deliver the vote of thanks.
Esteemed dignitaries, distinguished members of the legal fraternity, respected faculty, dear students, and esteemed guests, good evening. Thank you is such a prayer that cannot be seen or touched. It must be felt by heart. It is both a honor and a privilege to deliver this vote of thanks at Justice Unplugged, Shaping the Future of Law, a conclave that has truly been a gathering of knowledge, experience, thought, and leadership. This conclave has been a reality due to the visionary leadership of our Honorable Chancellor, Dr. G. Vishwanathan Sir, to whom we are utmost grateful. We extend our deepest gratitude to our esteemed Vice President, Dr. G. Selvam Sir, a leader who believes in action over words. Sir has always been welcoming to ideas that aim at expanding the horizon of VIT School of Law. This legal conclave is a testament to his relentless pursuit of excellence. We are fortunate to have here with us today Honorable Justice N.V. Ramana and Honorable Dr. Justice D.Y. Chandrachud, two of the most distinguished Chief Justices in India's legal landscape. We sincerely thank both the Lordships. We also express our sincere gratitude to respected Advocate C. Aryama Sundaram, Senior Advocate, Supreme Court of India, for being part of this conclave. We are grateful to the most respected Shri Advocate A.R. Sundaram Sir, Additional Solicitor General, High Court of Madras. Thank you, sir, for coming and gracing this occasion. We are so grateful to you, sir. And we could connect with you when you remembered your college and school days. That means a lot to all of us, and I'm sure our students will also follow the path of respecting the elders. We sincerely thank respected Mr. L.V. Navaneet, CEO of the Hindu Group, for his leadership and support in shaping this conclave. Our heartfelt gratitude to Mr. Suresh Nambat, editor of the Hindu, for his insightful contribution to this event. A special thanks to Mr. Mohammad Imranullah, the Deputy Editor, for expertly leading the discussion with Chief Justice Dr. D.Y. Chandrachud. We sincerely thank all the moderators, Mr. Nagaraj Nagabhushanam, Vice President, Data and Analytics, Designated AA Officer, the Hindu Group, Mr. Ramya Kannan, Chief of Bureau, Tamil Nadu, the Hindu, and Mrs. Aratika Baumik, Senior Sub-Editor, the Hindu, for their exceptional role as moderators, steering the panel discussions with great insight and clarity. We extend our heartfelt gratitude to Senior Advocates Srinath Sridevan, Senior Advocate N.L. Raja, Senior Advocate P.R. Raman of the Madras High Court, for sharing their invaluable expertise as panelists and enriching the discussion with their profound legal insights. We also thank Advocates Shurit Parsarthi, Advocate Nagasela, Advocate Shabnam Banu, Advocate Deepika Murali, and Advocate Anirudh Krishnan, Advocates High Court of Madras, for their valuable contribution to the panel discussion, enriching the conclave with their insightful perspectives. Special thanks to our friends in the Hindu, Mr. Ayyappan, Mr. Rajesh Menon, Mr. Arvind, Mrs. Vrinda, and Mr. Vikram. We have to give a round of applause to the entire team. Personally, I could learn a lot of business strategies from them, and as well as time management, which is very important for lawyers. We also sincerely appreciate the invaluable mentorship of most respected Dr. Tyagarajan Sir, Pro Vice Chancellor of VIT Chennai, Dr. P.K. Manoharan Sir, Registrar of VIT Chennai, for their instrumental role in organizing this remarkable legal conclave in collaboration with the Hindu, the nation's most esteemed and widely read newspaper. Now, I would particularly like to extend my sincere appreciation and thanks to the faculty members of VIT School of Law, Assistant Dean Dr. Prema, my good brothers and friends Dr. Keshav Murthy, Dr. Raja Venkateshan, Head of the Department Dr. Ganeshan, Dr. Ambika, my other good friend from Student Welfare Director, Dr. Rajashekar, the PROs who has helped VIT School of Law in branding and promotion, Mr. Arun, Yuvraj, PROs VIT Chennai. I have to thank here Dr. Suganya Madam from SDC and the entire CTS team, VIT Chennai, for their instrumental role in guiding and shaping this academic initiative. Special thanks to Mr. Punya Kodi, our licensing officer. This meticulous efforts and dedication of the faculty, students, and organizing team have ensured the seamless execution of this event. It is through such collective commitment that legal education transcends textbooks and courtrooms, engaging with the larger ethical and philosophical dimensions of justice. As we conclude this remarkable gathering, let us carry forward what we gained today with a renewed sense of purpose, recognizing that justice is not merely a concept to be studied, but a principle to be lived and upheld. If time is money, then today we all have earned millions. Thanks to all of you for making this event wonderful and glorious. Thank you.
Thank you very much, Professor. And thank you all once again for your active participation and your valuable presence today. May I now request everyone to please stand for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जाहे तब शुभ आशीष मांगे गाहे तब जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
We wish you all a pleasant evening. Thank you so much and look forward to welcoming you all again soon. Have a lovely evening. Thank you.